So good morning everyone. So very good morning. Today we are here to have a revision session on the Companies Act, as we already said. So this session will be concentrating. Let me first explain you the modus operandi of this revision session. This will be a rigorous revision session for December 21 examinations for CA final. In this particular session, the main objective is to cover all the concepts. So not just giving importance to directors and other things like compromises, arrangements, amalgamation, operation mismanagement, inspection, inquiry, investigation, special courts, NCLT, government company, foreign company, nidhi company, dormant company, miscellaneous provisions of Companies Act, removal of names. Often I used to see that in a revision session, all these are kept in dark. Just the directors will be given some importance, which I don't want to give. Anyway, directors, people know at least 70-80% of the content with regard to the directors, the board meetings and the managerial personnel. And again repeating the same in a revision session, I don't think that it is having some sort of sense. So therefore, the main objective of the today's session is not to cover those directors which people already know. I want to just cover which people doesn't cover for the examinations or due to the length or due to non-understanding of the concept. If anything was missed, I'm just trying to put a clear brush on these particular areas like compromises, operation mismanagement, inspection, inquiry, investigation. So these three chapters are accounting for 15 marks in every attempt minimum. November 2018 examinations, okay, in that attempt, inspection, inquiry, investigation chapter came for 14 marks in exam. Compromises came for 5 marks. Operation mismanagement came for 4 marks. That means these three chapters are accounting for 22 marks in exam. Even at a worst case scenario, every attempt we are getting 15 marks from these three areas. 8 marks from one topic, 6 marks from another topic, 4 marks from another topic. And for the God's sake, we don't know how the questions are being tested in MCQs because we don't know the MCQ paper. So therefore, the problem is compromises, inspection and this operation, removal of names, types of companies like nidhi, dormant, foreign, government, miscellaneous, NCLT, special court. These areas are accounting for 40 marks in examination. I repeat, these are having 40 marks in examination. Totally Companies Act will come for 70 marks. Including choice, it comes for 80 marks. In that 80, 45, 50 marks are covered from these areas. You check any kind of question paper that comes. Directors will be having 21 to 22 marks in the total paper. 21. Okay. MCQs take another 5 marks was tested. 25 marks. Then from where the remaining 50 marks are coming? These areas, which we are leaving. Therefore, we could not score well in the examination. Okay. So therefore, listen carefully. I'm not just going to read the concepts as and when required. I will also explain the logic behind. Okay. So the concepts will start with, as I already given you the word, compromises, arrangements and amalgamation. From there we will be starting and we will be going into the remaining concepts. Okay. So everyone, please get ready. Okay. If you have the charts material with you, please open the charts material, put before you. We will be going through that. Even though you don't have a charts material, no problem. Anyway, charts material covers everything what is there in the Bare Act. So therefore, all the concepts will be covered. Okay. Compromises, arrangements, this is important, therefore I am covering this. This is unimportant, therefore I am not covering this. Like this, nothing will happen. Every concept we will be covering. Okay. So, but to some extent, with a presumption that you already know some concepts, I will start. Okay. Because if I go on explaining the logic behind each and every section, session gets prolonged unnecessarily. Therefore, I just don't want to have that. And again, listen carefully. If today's live session started at 8 o'clock, ended 6 o'clock as per the schedule, 8 to 6 schedule is there. For example, in this particular 8 hours or 9 hours technical session, if we could not complete any 1 or 2 chapters, okay, because of the reason to complete the revision, I can't just read and go. If at all one or two chapters were left out at the evening session, we will be covering that in the very next day. Okay, those two topics. I will be having another live session. Just 1.5 hours we will be spending on that, or 2 hours max, and we will be covering it. Okay, maximum I try to cover today itself. If at all one or two topics were left out, I will not leave that. Next area we will be covering that. Okay, so with this, let us start with the concept. And everyone, hi. Let us start with the session. See here. So the topic we are going to start is compromises, arrangements and amalgamation. I repeat, compromises, arrangements and amalgamation. And some people are also participating from CA Foundation. Thank you very much. But still, it is very much Dirgadarsi. So listen carefully. So the topic is compromises, arrangements and amalgamation. Let's have some observation on this. See here, the topic is compromises, arrangements and amalgamation. So in this particular area, three parts are there. One is a compromise, another one is an arrangement, and third one is an amalgamation. Three concepts are there. Breakup of the chapter will be looking like this. Compromise and arrangement generally will be governed by section 230 and section 231. Okay, compromise and arrangement. Amalgamation starts from section 232 end with section 240. Okay, so amalgamation 232 to 240. Compromise and arrangement only without amalgamation 230 and 231. So these are the section structure. It starts with 230, end with section 240. 11 sections will be there totally. Okay, in this 11, except 236, we will cover everything here. 236 section will be dealt after completion of oppression mismanagement area. Okay, because there is a link with that. So since there is a link, we will cover after oppression mismanagement chapter. So 10 sections totally we have to cover in this area called as compromises, arrangements and amalgamation. And beyond anything else, first let me explain the idea of this chapter. Sir, before starting with the revision, let me first explain the idea behind this particular concept called as compromise, arrangement and amalgamation. See here. Compromise means what? Resolving a dispute is called as a compromise. That means to have a compromise, first there must be some dispute that should be in existence. What do you mean by dispute here? What really it means to say? Debenture holders must be paid 9% interest, not paying properly. Unpaid dividends are there on preference shares, not paying properly. Creditors are not paid properly. Like this, many financial disputes will be there. I am not talking about technical disputes or physical disputes. I am talking about financial disputes will be covered by this chapter. Whenever there is a finance related dispute, dispute must be resolved. Resolved through what? Resolved by a compromise. Okay. Compromise between whom and whom? In company there will be only two parties. Company, okay, shareholders and debt holders. Shareholders, debt holders. I am talking about financing. Therefore, I am not talking about directors. Company will be having two limbs. On one side, debenture, debt holders will be there. On another side, shareholders will be there. Shareholders, debt holders are the two wings of a company. This particular person we call as a creditor. This particular person we call as a member. Therefore, compromise is entered by the company either with a member or with a creditor. This is what said in section number 230, subsection number 1, if you see. Okay. So, the compromise will be entered into between the members and the creditors of a company. This is the first idea behind this particular section. Next, point number 2. Okay. During the compromise, what you will do? We will enter into various arrangements in order to have a compromise. Listen to the language. We will be making various arrangements in order to have a compromise. That means to have a compromise, some discussion should happen or not. That discussion we call in the chapter with a technical name called as arrangement. Arrangement is a procedure to make a compromise. So we have to make an arrangement. Okay. Arrangement includes what? Discussions through meetings. Meeting will be conducted. We will tell the debenture holders how much interest we need to pay to you. 9% interest. Sorry, we couldn't pay that much. We will pay you 6%. Compromise. Instead of not paying anything, it is better to pay 6. Come to a compromise. If they accept, compromise will be effective. If they don't accept, compromise will not be effective. Like this, arrangements will be made in the chapter we will read anyway. This is the basic idea. Now the real question starts. Dispute happened between whom and whom? Company members, company creditors. Therefore, we are entering into what? An arrangement to resolve the dispute. Okay. If no person is involved in the middle to govern this, it becomes most informal. Means what? Company will call some debenture holders whom they know. They will tell, you people accept for 6% interest of debentures. We will be saying that we entered into compromise. For all the debenture holders, we will pay at 6% interest rate. Okay, you please say yes. These people who are henchmen to the company will tell, yes, no problem. We are ready to take 6% interest instead of 9. Then what about the other debenture holders or other creditors who are not interested in this 9 or 6? Therefore, court is involved in this arrangement. Don't do whatever you want. Technically, don't do overaction. I am there in the middle. I will tell you how arrangement should be. I will tell you how compromise should be. I will be the person who will be sitting in the middle like a pedaraidu, and I will give the judgments. Okay? Don't do whatever you want. Do as per my instructions, including conducting the meetings. Generally, meetings will be conducted as per general meetings chapter number 7, management and administration. But for this chapter, meeting will be held as per the orders of tribunal. Means what? Even meeting also you cannot call on your own. I am there. I will tell you when to call. I will tell you whom to call. I will tell you what to discuss. I will tell you agenda. I will tell you timings. I will tell you everything. Follow that. Don't do overaction. So, compromise should not be an informal compromise. It should be a formal mode of compromise. For that reason, NCLT is involved in the middle. In this entire chapter, the king of the ring will be NCLT, the National Company Law Tribunal. Okay, so this is the basic idea of this chapter. Hope everyone understood up to here clearly. Right? So, please everyone, please give a reply. Everyone understanding the concept clear up to here? Sir, everyone, whoever is watching, please give a reply. Everyone understood the concept clearly up to here? Right? Thank you. So, this is the basic idea why there will be a compromise. And compromise will be always through a legal channel called as NCLT. You cannot do whatever you want. Okay? It should be only in the supervision of NCLT. With this, let us start with our chapter. So this is the basic core introduction. Like this, for every chapter I will give a 10 minutes intro, and then we will start with the chapter. Then you will also match with the wavelength of what I am discussing, or else you don't track why I am discussing about all these issues. So this is the idea. That means in the entire chapter, NCLT will come. I repeat, in the entire chapter, NCLT will come. The place where NCLT don't come becomes the most important area dealt by section 233, where NCLT is not involved in the scheme of compromise or an arrangement, called as a fast track merger procedure. 99% expected question for the December 21 exams. So, fast track merger concept, section number 233. 233 section talks about non-involvement of NCLT at the time of compromise. Instead of NCLT, ROC and official liquidator will be involved. That means the civil procedure set out by NCLT doesn't apply for 233 kind of mergers. So how it is, let's see in this chapter. See here, first one, section number 230, application and related issues. First thing, everyone has to understand one important thing in this connection. See here, first, application must be made to NCLT. From this, what we need to understand, directly tribunal will not take any compromise case suo motu. This is one MCQ question that he can ask from the very beginning of this chapter. Okay, the papers in the latest trend, if you observe, they are literally screwing up with the student's mind. They are twisting the questions in such a way those who read entire concept only has to write. Observation is, there are disputes going on in a particular company. Creditors are not paid properly. Debenture holders are not paid properly. Knowing about this, NCLT want to initiate compromise. Overaction oddu. Nenu cheppana niku. So therefore, don't do overaction. Tribunal also cannot do overaction. That's a beautiful concept of Companies Act. Tribunal, don't do overaction. Did I tell you? Creditors are asking tribunal, did I tell you that they are having a dispute with us? Kaadu kada? So overaction cheyiddu. So don't unnecessarily involve into the private affairs. You have to involve if and only if I make an application to you. I will make an application if I have a dispute. Okay? So see here. So application by whom? By company or creditor or member or liquidator in case of winding up. So question will come. Sir, company okay. Company means artificial person, sir. Then who will go? Board of directors. Always company here represents board of directors. Next one, or who can make? Creditors can make. Yes. Next one, members can make. Liquidator in case of winding up. Sir, why liquidator, sir? Winding up, why, sir? At the time of winding up, company is dead. Why liquidator will come? Listen carefully. At the time of liquidation, assets will be sold. Assets will be sold. Liabilities will be paid. At the time of winding up, when you sell the assets, and when you discharge the liabilities, you will get exact assets 100 crores, liability 100 crores. Then the company will not wound up first. It's a fantastic company. If it makes some efforts, again assets value will increase. So not like that. Assets are 20 crores, liabilities are 60 crores. In that case, company goes for liquidation because of insolvency. Now answer, I sold the assets, I got 20 crores. I have a liability to discharge worth 60 crores. Then this 60 crores liability will get entire 60 crores. No. How much they will get? They will get proportionately lesser amount. That means they have to compromise their amount or not? Yes. Therefore, even in the case of liquidation, a winding up petition was filed with the liquidator, with the NCLT. Even during that time, yes, compromise will be there. So everyone, application by whom? Company, creditor, member, liquidator in the case of winding up. Next one, application to whom? The king of the ring, NCLT. Next one, mode of making application. You make an application in NCLT 1. Tribunal will give a reverse confirmation notice to you whether it has accepted or not accepted in form NCLT 2. In form NCLT 2. That means you made an application, tribunal accepted your application. If this application of NCLT 1 is not in accordance with the rules of NCLT, rejection will be happening. That notice will also be given. Your application for going for a compromise is rejected. Sorry. What is the purpose? Compromise or an arrangement. Parties to a compromise. Company with creditors, company and members. Next. Now what tribunal will do? Arrangement. What arrangement? Arranging a meeting. Meeting means, can I go as per general meetings chapter? Overaction uddu. I will tell you how to conduct, when to call, when to hold, when to convene. Everything I will tell you. So, power of tribunal. Order meeting of creditors, meeting of members, or if application is by creditors meeting, members meeting, both meetings to be called. Called means what? Here what you need to understand. How to call I will tell. Means what? How the notice should be, I will tell. Sir, notice, general meetings chapter, section number 102, section number 101, special notice. Overaction uddu. Notice also, I will tell how it should be. Okay? Call, held, conducted, proceedings how it should be. I will tell you, follow that. So entirely one chart is covering out the application and related issues. So everyone, fastly let us revise. Application by whom? Company, creditor, member, liquidator in case of winding up. Application to NCLT. Application NCLT 1. Okay, acceptance will be given in NCLT 2, and the purpose of making application is compromise or amendment. The parties to the compromise will be company with creditors or company with the members, and tribunal has a power to order for the meeting to be called, held and conducted in the manner set by the tribunal. Okay, very good. Next one. Very, very important. Mark this important. You can expect this to come in examination. Already in one of the latest 2020 November attempt, this question was tested. Again, there is a chance to test this point. Okay, let's have a clarity on this. So everyone please participate. And by the way, sir, everyone understood the concept up to here? Arrangement includes a dispute. Pavan Kumar, arrangement includes arrangement does not include a dispute. Compromise includes a dispute. To resolve that compromise, we make an arrangement. Next. Notice must be given to how many days? Sir, notice concept we didn't come at. Venkatesh Katargada, we didn't come to the notice concept. I will come. Third chart will be on the notice. Okay. When we come there, we will be covering that. Okay then. So let's go into the concept. Affidavit and its contents. Affidavits and its contents. See here. There will be 3 points in this section. Listen, how question will be tested in exam. He will ask a question. What are the disclosures to be made while making application to NCLT under section 232? This will be the question he will ask in exam. For this, you need to write this answer. Entire answer we need to write. But linking must be there. Logic, if you don't understand, you can't really appreciate why it came. Sorry, anyway, let's try to understand clearly. Sir, first thing, compromise and arrangement is being made. I am one of the member. I am holding 20% capital in the company, or I am a creditor having 20-25% of the total outstanding due amount, or I am a liquidator. Some person who is making an application. I am making an application to the NCLT. While making an application to NCLT, I should tell why I am going for a compromise. What is the problem? Or what you want, what you expect from the company, what you are expecting from this compromise. We need to give some fact disclosures. I repeat once again, as an applicant, we need to give a fact disclosure. Fact disclosure through what? Through an affidavit. In a affidavit, we will make some disclosures. Affidavit means we will sign below. All the above statements made above are true and correct to the best of my knowledge, and we will sign. If you make wrong affidavits, you will be liable under section number 448 and 449. Punishment for wrong false statement, punishment for false evidence. So therefore, we should be very careful while drafting the affidavits under Companies Act. So affidavit we need to draft. Affidavit contains a statement of facts. What statement of facts you need to file? Listen. We need to file the following statement of facts. As per 230 subsection 2 clause A, latest financial position, latest auditor's report. If there is a pending investigation or pending criminal proceedings against the company, we need to disclose clearly in the affidavit. Okay, applicant has to disclose. Sir, applicant is a creditor, sir. How he will have legal knowledge, sir? How he will draft affidavit, sir? That's why I have given one note point here in my material. An affidavit as specified in this section shall be made by applicant under this section. In practice, that means in the original practice, sir, I have been in the last 3.5 years completely into NCLT works. Therefore, we have, with our own eyes, we have seen these concepts. In practice, it is generally made by an advocate who shall act as a legal representative to the applicant through a specific power of attorney or writing a wakalatnama shall assist in making it. Affidavit shall be made by applicant. Applicant will not do that. Applicant will approach advocate. Advocate will observe the financial structure of the company, or chartered accountant will observe the financial structure of company. He will draft an affidavit. Okay, that's what will happen. Income tax office, we will get notices. We will give reply. Reply should be given by the assessee. Assessee will give a auditor on behalf of assessee will write. Like the same thing here. So, latest financial position, latest auditor's report, pendency of investigation proceedings. Okay, next. These things we need to give. So, latest financial position. Now the question will start. Sir, why I need to give a latest financial position? The only reason behind why we need to give the latest financial position of the company is, in the financial position as given in the affidavit, company is well working, but these people are going for compromise. Why you are going? Along with that, latest auditors report. How they booked the auditors in Companies Act, let's observe. Latest auditor report la, auditor has given a qualified opinion, not adverse, qualified. That means to the extent of my verification, to the extent of my independent examination, everything is correct. Beyond what I examined, beyond the samples what I examined, beyond the population what I tested, if there is any wrong or a fraud, I am not responsible for that. To the extent of my checking, company is well working. Like that, he has given an audit report very recently, 2019-20 or 2021 financials, he has given a clean opinion, qualified opinion, not clean, qualified opinion he has given. But the company is going for a compromise. Means what? Financially the company is down. Auditor report he has given a normal qualified opinion. You are telling that company is going for a compromise. Something is fishy. So matching is not there. You are telling finance is better. Auditor is telling that company is very good. You are telling I want compromise. That means there is a mistake with any of these two persons. Either auditor must have given wrong report or company is asking for a false compromise. Anything must have happened. Therefore, latest financial position and latest audit report should be given. Both should be reconciled. Financial position must be bad and same should be reflected in the auditor's report. To have that, this was given. If auditor certifies the financial position as not satisfactory, tribunal will be very happy. Okay, what auditor said, same thing company is also asking. At least I can look into that. Next. Pendency of investigation, pendency of proceedings. If pending is there, let that complete. Later we will go for a compromise. Okay. Next. 230 subsection 2 clause B they will tell reduction in share capital if there is, you have to disclose. What is that? Reduction of share capital. Reduction of what, sir? Share capital. Sir, why share capital reduction only we specifically specified here? What could be the possible reason? Listen, debenture holders are there. If you observe the accountancy financial reporting paper amalgamation chapter, you will have internal reconstruction. They will tell creditors to forego 25% of their claims, debenture holders to forego their outstanding interest, 9% debentures will be converted into 7.2% debentures, 13% preference shareholders will be converted into 7% preference shareholders, like that, and directors to forego their outstanding remuneration. Like that, various arrangement points they will give. On that basis, you will prepare a reconstructed balance sheet, reduced company. Okay, that means, listen carefully, equity shareholders are there. Listen, logic is important. Equity shareholders are there. What is the maximum damage you will cause to equity shareholders here? Just I am asking, what is the maximum damage you can cause to equity shareholders? Number one, you can go for a buyback. You can go for a buyback. Buyback is not a compromise. Buyback is not an arrangement. Why, sir, buyback is not an arrangement? It is entered with equity. Name itself is telling. Buyback. I will buy your shares and I will pay you money. Where is the compromise here? Where you compromised? Ikkada compromise em ledu. You are getting what you have to get. In the market, share is trading at 245. I am telling I will give you 270 rupees. Where is compromise here? You compromise means you should lose something. Where you lost? Buyback losing will not be there. If really losing is there, buyback will not be accepted by the equity shareholders. I think you can understand the logic now. Buyback can never be a compromise. Buyback is just an arrangement without a compromise, which is not covered by this chapter. Okay, reduction of share capital is a classic example of compromise. Do you know why? I am a shareholder. I invested 100 rupees in a equity share, entered into company. Company is telling that I am reducing that 100 to 50. Means at the time of winding up, getting money itself is a suspense. In that half only I will get. How much damage is caused to me here? Therefore, for equity, if there is any damage, that will be only reduction of share capital. That's the only compromise they can make. Get the point, everyone? That's the idea behind this. Sir, dividends not paid, sir. If dividends are not paid to equity shareholders for your kind consideration, though they may enter into compromise, It has other avenues and consequences. Don't pay dividends, disqualification to directors. Don't pay dividends, interest has to be paid on that. Various other sections are there. 127 talks about penalties to be paid, and 164 subsection number 2 clause number A will be talking about disqualification to the directors if the dividend is not paid properly. That means when dividends are unpaid, other avenues are available. But for equity, the main damage is reduction of share capital. Therefore, reduction of share capital is the only compromise. For example, split shares, consolidate shares. Split shares means one share turned into 3 shares. Or consolidation means 3 shares converted into 1 share. Here there is no compromise. Okay. So only arrangement is there. There is no compromise. Okay. There is no compromise at all. 3 shares becoming 1 share or 1 share becoming 3 shares means market value is same. Everything is same. 100 rupee market value become 33 rupees per share. That's all. Damage is not caused to you. Okay. The only damage you can cause to the equity will be reduction of share capital. Okay. This is the basic idea. Next one is very important. Have a look. Section 230 subsection 2 clause number C. Section 230 subsection 2 clause C. Listen carefully. Multiplication of authorities. In India, there are various debt dispute resolving authorities. I repeat once again, in India, there are many debt dispute resolving authorities. Okay, debt dispute resolving authorities, DDRAs. Means what? Whenever there is a stressed assets, whenever debt was given but he is not paying properly, we have alternatives. Multiple alternatives are there. You can make an application under insolvency code. You can go under surface if it is a bank loan. You can go to BIFR if it is an industrial or a financial structuring loan. So like that, there are various avenues available. Listen carefully. There is a concept called as corporate debt restructuring. What is that, sir? Corporate debt restructuring. What do you mean by corporate debt restructuring? Restructuring means what? Dead thing will be again come into living, is called as a restructure. Corporate debt restructure. Dead debt will be made as a live debt. How it will be made? By compromise. By what, sir? Compromise. Listen carefully to the logic. Many people are not understanding this concept clearly. Just let me explain. After this, all the concepts are very easy to understand. So, corporate debt restructuring. What exactly the corporate debt restructuring mean to convey? Generally, corporate debt restructuring will be done in 2 ways. Okay, as per BIFR, Board for Industrial Financial Restructuring, or RBI guidelines, or what, sir? RBI guidelines. Now listen. There are secured creditors in a company. Which creditors? Secured creditors are there. Debenture holders, let us take, or loan by the banks, let us take like that. Secured creditors are there. These secured creditors are not paid by the company properly. Are not paid by the company properly. Okay. These creditors made a complaint to BIFR already. Already they made a complaint to BIFR. BIFR has taken application and it is pending with BIFR. That means going on. That dispute is going on in the BIFR. The BIFR is also like a court. In that court, the matter is running. During that time, some other creditor or some other member put an application to NCLT for a compromise. That means multiple authorities are taking the same type of case. Then what's wrong to merge both the applications? With that intention, a concept has started in NCLT. NCLT said that BIFR, anyway I received one compromise application. Anyway I have to observe the application. You are taking our secured creditors problem. Do one thing. Transfer all those cases to NCLT. Transfer all those cases to NCLT. What NCLT will do? NCLT will go for a compromise. Compromise, if you enter, what will happen? Corporate debt restructuring will stop. Means what? I will explain like this. There is a corporate debt restructuring already running in BIFR. NCLT will tell BIFR, I am expert than you. Why? After IBC, I became an expert in debt restructuring. Do one thing. You are having our company's, this company's pending case. And I am also having the same company's application. Do one thing. Why both the authorities has to do the same type of case? You transfer everything to me. I will look after. Are you understanding the point? So you transfer everything to me. I will look after the scheme of compromise and arrangement. Let's stop the corporate debt restructuring. That's why in the affidavit, you need to clearly tell if there is any CDR scheme approved by not less than 75% of the secured creditors in value. Okay, you have to give this disclosure. If there is any pending BIFR application for CDR, you need to clearly tell in the affidavit. Okay, that means NCLT will know, okay, again is this company one BIFR application is pending. Let that CDR scheme stop there. I will take all these into compromise. That means instead of two authorities taking the same type of case, stop the CDR and I will take the case here. Sir, who said that to stop the case in BIFR? Section only said here. Nothing is my sonta kavitvam. So see here. Let me show you that. This contents of sanction order la one point will be there. If compromise or arrangement is accepted by creditors, any pending applications before BIFR shall abate. Close. Cancel the applications at BIFR. CDR scheme will be stopping there. Okay. That means any pending BIFR cases are there. Na? You don't take. Anyway, compromise is going on in this company. You stop there. I will consider this also into compromise. So BIFR applications will abate. Okay. So that's the idea behind this particular section. See here now. 230 subsection 2 clause number C says that the applicant has to give a creditor's responsibility statement. Means what? He has to tell that the company is responsible towards the creditors in making the payment. Next. Safeguards for the protection of other secured and unsecured creditors. Sir, what is the safeguards for other secured and unsecured creditors? For example, I'm going very fast into this, please. Logic, I will tell, but not very slow. Please see here. For the first time itself, you try to understand. Or else after the class, you go back to the lecture and again listen. But I can't repeat multiple times. Sorry for that, but still, please see here. There are debenture holder type 1, debenture holder type 2, debenture holder type 3 in the company. Secured, unsecured, secured. Due date 2020-21, 2020-25, 2020-28. These are the three due dates. Now, 2020-25 persons don't come for redemption. 2020-21 will come for redemption. They are not paid properly. That means compromise will be entered with 20 or 25, 28 debenture holders. Or action, they are paid after many years after. So we have to enter into compromise with this set. But the moment you enter into the compromise with debenture holder set number 1, immediately debenture holder 2 set, debenture holder 3 set, reason is, same thing might be happening even to us in near future. Then what will be our horoscope? What is our fate? Therefore, this compromise is because of a temporary problem in the company. Safeguards to the protection of, how beautifully lawmaker uses the language, other secured and unsecured creditors. Means which other secured and unsecured creditors? Other than those who are entering into compromise. Okay, next. Now you are telling that safeguards to other secured and unsecured. Safeguards, protection. Now listen. Secured creditors will be feeling protected. I repeat, secured creditors will feel protected if cash is there, assets are there. If the assets are there, they feel secured. Unsecured creditor will feel happy if assets are there. Anyway, that assets are not secured. That means I have given unsecured loan, no security of assets. For me, asset amounts are not important. Cash availability, liquidity is important. For unsecured, liquidity is the criteria. For secured, assets are the criteria. How beautifully he drafted this concept. Report by company's auditor about the fund requirements of CDR, satisfying the liquidity to protect unsecured. Valuation by registered valuer of the assets, tangible, intangible, mobile, immobile, for secured. Answer completed. Now you have to tell very clearly whether you are going by, in the BFR complaint is there na, BFR pending complaint, that is as per BFR, as per RBI guidelines, you need to clearly tell. The company decides to adopt CDR scheme as per RBI guidelines, okay, and not as per BFR guidelines, a statement specifying the fact. What BFR will do, NCLT will do now. Okay. So this is the idea behind the affidavit concept. So to be very, very clear on this aspect, application by the company or a creditor or a member or a liquidator to the NCLT in NCLT 1 and reply in NCLT 2 for the purpose of compromise or arrangement between the company and the members, and the tribunal will conduct the meetings and the affidavit will be given latest financial position, reduction of share capital and the CDR scheme details. Next. Number 3, notice and related concepts. This I will go little bit fast because just remembrance is required, nothing great inside. See here. 230 subsection number 3. Okay. The notice and related concepts. 3 subsections are there. 230 subsection number 3, 4 and 5. We'll be talking about the notice concept. 230 subsection number 3. Notice to whom? To the creditors, members or debenture holders. To the creditors, members or a debenture holder. Creditor, normal creditors, members, shareholders and members, debenture holders, the creditors, main creditors. In form CAA2, you need to give a notice. Place their address registered with the company. Attachment. You have to give an explanatory statement. You have to give what, sir? Explanatory statement. Explanatory statement containing what? Effect of the compromise or arrangement on creditors. Sir, what creditors effect will be there? They will be getting a reduced value. Trade creditors are there 70 crores. 10% reduction. What will happen? 63 only they will get. Effect on you. What is the effect on you? There is a loss of 6 crores or 7 crores. Like that we need to give there in KMP. Sir, why KMP is there, sir? What KMP will get? Listen carefully. If you observe section number 202 of the Companies Act, compensation for loss of office. Whenever company go for amalgamation or reorganization, in order to reduce the liability of remuneration, they will remove some directors and KMP. Therefore, effect on KMP, effect on directors. How beautifully he drafted in the law. Promoters. Whenever you observe any case, whenever company go for reorganization, okay, first one, promoters will enter into the reorganization. Effect on promoters. Normal shareholders, debenture holders. Effect on all these people, you need to clearly state in the notice. Next, first proviso. Web display. Not just giving a notice, if it is a listed company on the website of SEBI and recognized stock exchange, you need to display the notice. If it is an unlisted company, on the website of the company and in the local newspaper. Next, second proviso. If notice is given by advertisement, all these contents must be given in the advertisement as well. Okay, next one. 230 subsection number 4. Notice shall specify that voting can be done either personally or by a proxy or by a postal ballot. Okay, notice shall specify you can vote either by coming to meeting or by proxy, or if it is conducted by postal ballot, you need not even come. Through postal ballot voting, it will be completed. Next, very important, sir. Mark this point, very important. In the past exams, I have seen 3 times this question to get repeated. 1 mark type questions are asked here. Objections raised against the scheme. Listen carefully, confusion will come. There are 2 types of persons, objecting person, dissenting persons. In this chapter, there are 2 kinds of persons, objecting, dissenting. Dissenting shareholders or dissenting members are those persons. Let us say, dissenting shareholders means what? They didn't raise any objection. In the meeting, they didn't vote in favor. Those are called as a dissenting. Okay? Objection persons are whom? They don't like compromise itself. Dissenting are those who like compromise, but the terms of compromise they don't like. In the meeting they didn't vote in favor. These people, they are objecting the very compromise itself. So there is a lot of difference between both of them. So don't get confused. Dissenting are different, objection are different. Next, objections by shareholder. If shareholders has to raise an objection, they should hold minimum 10% of shareholding of the company. Creditors now 5% as per latest altered financial statements. Very important. Notice to statutory authorities. Not only to the members, creditors and debenture holders, you also need to give to statutory authorities at least 1 month, not 21 days, because we are not following general meeting chapter. Notice to whom? In all cases, give to MCA, central government, income tax, ROC. If it is a banking company, give to RBI. If it is a listed company, give to SEBI. If it is affecting section 5 of Competition Act, combinations, CCI. If it is a listed company, also to stock exchange along with SEBI. If it is a sectoral regulating company, means if it is an insurance company, IRDA is a sectoral regulator, also to them you need to give. Notice completed. Next. Now you made a notice. Now let us see the screenplay of the total picture. Dispute started, application made, affidavits attached to that, matter slowly went to tribunal, notice is distributed to the members and creditors as per the orders of tribunal, notice was seen by the members and creditors, they will now come to the meeting and attend and approve the scheme. How that will be? Let's observe. Approval to the scheme. Approval by whom? Members. If it is a member, majority members holding. So this everyone in the class, when I am taking normal session, they will make wrong. They are just observing holding not less than 3/4 of the value. They will use the word in the Bare Act, majority holding not less than 3/4. Means what? Majority means if there are 100 members attending the meeting, 51 members will make majority. That 51 should hold 3/4 in value. Same with creditors. Okay. Next. Scheme binding on whom? Once it is approved by this majority with this holding, with this majority with this holding of creditor, scheme shall be binding on company, creditors, members, liquidator and contributors. Everyone it will be applicable. Everyone it is binding on. Contents of sanction order. November 2019, if I am not wrong, May 2019. A question came for 5 marks in the examination. Contents of sanction order. Who sanctioned? Tribunal sanctioned the scheme. That sanction order shall provide for the following. See here. If the compromise is with the preference shareholders, okay, I couldn't pay them. What to do? Convert them into owners of the company. If you convert preference shareholders into equity, no problem. But what about my preference dividend arrears? You will also convert that into equity or you will pay in cash? You need to tell very clearly. If there is a conversion of preference shares into equity shares, the arrears of preference dividend may be down. Paid in cash or converted into equity shares. You need to tell that very clearly. Okay. If there is a variation in shareholders' rights, it shall be as per section 48. Sir, what is variation? Section 48 will discuss, not in our syllabus. Therefore, I don't want to discuss much on this. Okay. Next, if compromise or arrangement is accepted by, creditors, any pending application before BAFR shall be abated. Already we discussed this concept. And such other matters including exit offer to dissenting shareholders, protection to creditors. Already we read this. 5 points will be there. 1, 2, 3, 4, 5. Came for 5 marks in exam. Okay. Tribunal sanction order should clearly specify what to do with preference shareholders and their arrears. Next one, if there are variation shareholders, right, what will be there? Okay. Next one, exit offer to dissenting shareholders, protection to creditors, abatement of BAFR pending applications because already CDR is accepted through NCLT route. Next issue. Sir, I will answer all your doubts after completion of this topic. This is a very big topic. Once 230 is completed, half the chapter clarity will come. Okay. Next. Miscellaneous issues. Precondition to issue sanction order. Listen. We said that this is the entire compromise scheme. This is the entire scheme of compromise. Auditor of the company has to give a certificate that the proposed scheme will be in accordance with section 133 accounting standards. That means whenever reconstruction happens, we need to give impact to the accounts. Okay, that I will do. He has to give a certificate. Next. Filing of sanction order. Tribunal sanction the scheme. That sanction order should be filed with ROC within 30 days. Okay, within 30 days. Next. Mark this important. This is not tested till now, but can be asked in exam. This is dispensation of meeting with the creditors. Okay, dispensation of meeting with creditors. Let's try to understand what is a dispensation of meeting. Dispense means avoid meeting of whom? Avoid meeting with the creditors. Why we will avoid meeting with creditors? Creditors, if they are holding 90% in value, shall approve by an affidavit. That means there is a company. There are 7 creditors totally. Why meeting here? Power action. Why meeting unnecessarily? Again, time will be taken. For meeting, notice has to be given. That notice should be given 30 days prior. We have to wait for 30 days. 7 creditors are there. When the number of creditors are very less, maybe value is big or small, number is less. In such a case, than going for a meeting, it is better to solve through a paper affidavit. In that, if they agree, 90% in value has to agree. That's all. Dispense the meeting of creditors. And very, very important, dispensation is not available to members. Dispensation is available only to the creditors. Okay. Next, this very important point again. Sir, everything is important. I can't tell that it is unimportant because any question is getting tested. Array 230 subsection 7 was asked in examination suddenly means why can't we expect this point to come in exam now? So please listen carefully. Scheme of compromise or arrangement shall include reduction of share capital if any or buyback. Listen, compromise is going on. At the time of compromise, reduction of share capital application is also added to that. Okay, if normally reduction of share capital is going on without compromise, not during C&A, 230 section does not apply. 66 will apply. 66 reduction of share capital. But during compromise arrangement, if you bring reduction of share capital concept, instead of 66, 230 will apply. That means separately you need not again go through reduction. Directly you can merge with 230 section. 66 will not apply. But if you are going for buyback, buyback is not a compromise. Na? Therefore, not during C&A. Normally buyback is going on. 230 will not apply. 68 will apply. During C&A, also 230 will not apply. 68 only will apply. This is what discussed in section 230 subsection number 10 read with explanation. Okay. This is the entire 230 section. Now answer my question. Application made by some people made to NCLT, NCLT sanction. Till now, implementation didn't start. I repeat, implementation didn't start. This is all pre-implementation procedure. Now, as per the scheme drafted, they need to pay creditors, they need to pay debenture holders. Like this, they have to apply the scheme. During the implementation of the scheme, what is the guarantee that really company will go to the compromise in the way tribunal said? What is the guarantee? Therefore, tribunal said that I just don't give instructions. I will be supervising the implementation of scheme. If you are not implementing properly, as per the needs, I will modify the implementation. If you are not paying the debts, okay, if you are not paying the debts and if you are not complying with the orders given, then I will also pass a winding up order on the company under section 273. It's a may. Power is there. You may exercise, you may not exercise. This is what said in section number 231. This is the end of two important sections, 230 and 231. So this is the idea, sir. If you have any doubts, you can ask now. Sir, everyone in the class, please give a reply. Everyone understood the concept clearly up to here? Sir, everyone, please, without anyone in the session, I have to take the class now, please. Your reply itself will be a booster for me. Everyone understood the concept clearly? Yeah. Thank you very much. Okay. Thank you very much, everyone. Thank you. And moreover, some persons are asking me to repeat some concepts once again. And sorry to say this, if you want after the lecture, you can go back and listen the same. I will not delete the lecture. It will be there in YouTube forever. Okay. If really you have any problem, you can go back. And question, Krishna Sastri, sir, if there is no dispute between company and creditors, arrangement can be made without application to tribunal, NCLT. If there is no dispute, why you are going for compromise first thing? Section 48, everyone is asking what is variation in shareholders' right. So when time permits, I will tell you. At least at the end of this chapter, 5 to 10 minutes I will take and I will complete that variation concept. Okay? Okay then. So let's go back to the concept. So please, sir, have patience in listening. One day, I'm guaranteeing you 60 marks. So please, concentrate properly. I will complete everything. Merger and amalgamation, the king of this particular chapter. 232 section, merger and amalgamation, section 232. What it is going to tell and what is the idea behind this, let's try to understand very clearly. Start from the basic level of understanding. See here, application by whom? Same as 230. First clause, same persons, creditors, debenture holders, members, whoever the case may be, will make an application for merger. Okay, application to whom? NCLT. Same NCLT 1, NCLT 2, communication of acceptance or rejection. Same. Application for what? For what you are making application? Compromise or arrangement. Compromise or arrangement. Sir, compromise or arrangement? Already we entered, na? Why again compromise? This compromise or arrangement will be in relation to merger or amalgamation. Normal compromise la. Compromise in way of merger or amalgamation. Okay? Observation required. In relation to merger or amalgamation involving transfer of property, assets, liabilities. Sir, PAL whenever I write in this chapter, property, assets, liabilities. Okay? Property, assets, liabilities. Okay, listen carefully. Normal compromise, merger amalgamation compromise, what change will be there? In a normal compromise, payments will be made at a lesser volume to the creditors members. In amalgamation compromise, transfer of assets will be there. Transfer one as company to another company, one company to another company, one company to another company. Assets, transfer, liability, transfer, purchase, consideration, goodwill, composition, all these things will come. Okay? There, reductions will be there. Here, transfers will be there. So, therefore, merger and amalgamation talks of a transfer and compromise normally will be talking about reduction. Right reduction will be there in a compromise. Okay? Now, so application by whom? Application for what? Application to whom? Three things are completed. Duty of a tribunal. Tribunal will direct to call, hold, conduct. Meeting in accordance with 233 to 236 are a beautiful 233. 230 subsection number 3 will be talking about notice. 234 notice. 235 notice to statutory authorities. That means this section starts after completion of subsection 1 to subsection 6 of that section. In examination, if a question comes to you on merger amalgamation, you need to write application by creditors members, all these set. You need to tell that notice should be given as per the works of tribunal. 3, 4, 5 we need to summarize and write in the exam. After that you need to write all this. Because 232 section has initiative of starting with 230 procedures first. Therefore, first we need to start with that and then we need to go into this. Okay. So, this is the idea behind this particular concept. Okay. Next, what schemes are covered under 232 subsection number 1? Listen carefully. Technical point. Let's make some analysis on this. I just don't want to give a theoretical view on this. Let's observe. So, see here. See here, sir, everyone. Observation. A limited, B limited is there. A limited, B limited are there. Now, observation. A limited is taking over B limited. A limited and B limited forming AB limited. A limited absorbing B limited is called as merger by absorption. Merger by absorption, not Masters of Business Administration. Whenever I use MBA here, merger by absorption. A limited plus B limited equal to AB limited. New companies formed. This will be called as merger by new formation. MBNF means what? Merger by new formation. A limited plus B limited forming AB limited, merger by new formation. A limited absorbing B limited, merger by absorption, merger by new formation. The differentiation you need to understand if you read the Bail Act. Okay. So, these are the two types of schemes that this section covers. Along with these two, everyone remember carefully, one important question can be tested which is not tested till now. Section also covers demergers. Same procedure. Because the section uses the word division. Demergers are also governed by the section. So, whenever section suddenly question comes in exam, A limited want to demerge into B limited and C limited, immediately you should not tell, hey, this is out of syllabus, sir, I didn't teach in a class. Demergers are also governed by section 232. Observe clearly division of assets and liabilities. So, A Limited taking B Limited merger by absorption, A Limited B Limited forming A B Limited merger by new formation, and demerger. Scheme 1, Scheme 2, Scheme 3. These are the three schemes covered by section number 232. Let's have a glance. See here. What schemes are covered by 232? If property, assets and liabilities of one company is transferred to another existing company, merger by absorption. A Limited is there, B Limited is there. Okay, A Limited is there, B Limited is there, I am telling, existing. One is merging another, one is absorbing another, merger by absorption. A Limited is there, B Limited is there, forming a new company, AB Limited. AB Limited not yet formed, new company. Therefore, that's called as, if properties and assets of two or more companies are transferred to a new company, it's called as a merger by new formation. Okay, and it also covers division. Next, listen carefully. In this section, a technical word will be used called as, merging companies. Notice has to be given to the members. Okay, like that they will tell. Then they will tell notice must be given by merging companies. They will tell. Merging companies means which company? Question will come. Therefore, explanation 2 has defined this. Merging companies means if it is a merger by absorption, both by transfer or untransfer, because both are in existence. Merger by new formation, A Limited, B Limited forming AB Limited. A Limited, B Limited are transferor. AB is a transferee which is not yet formed. Therefore, merger by new formation, section compliance will be made only by existing companies which are transferor companies. Okay, these are both are said in explanation 2. Next, what is a division? Division means a demerger, where it is divided among two or more companies. Next one. Meaning of the terms property, assets and liabilities. Properties means assets and rights or interest of every description. Liabilities means debts or obligations of every description. Next. So, to be very clear on the basic level of understanding with section number 232, application made by the same persons, application made to the same persons, application will be accepted, application may be rejected, NCLT same applications. Now this covers a compromise or arrangement, but not a compromise arrangement what we have already seen. It is a compromise or arrangement in the nature of a merger or absorption which will be involving the transfer of assets, properties and liabilities of the company. And there can be two types of methods that will be merger by absorption, merger by new formation. In case of merger by absorption, transfer and transferee companies will be there. Merger by new formation, only transferor companies will be there. Therefore, in case of merger by absorption, transfer and transferee has to comply with the provisions of this section, and in case of a merger by new formation, procedure must be complied only by the transferor companies because transferee company has not come into existence till now. Division will also be covered, which covers the demerger concept. Next, attachments to the notice. Sir, already we attached 230 subsection number 3. These are additional attachments. Along with 230 subsection 3, we need to also attach this. If you go back to the board of directors concept, board of directors, section number 179 subsection 3, the board of directors of the company shall be entitled to exercise all such powers only with the consent of the board of directors by a board meeting, making calls on shares, authorization for buyback, issue of security, borrowing money, invest funds of the company, to grant loans, give guarantee, provide any securities in connection with the loan, to diversify the business, to approve annual financial statement, to approve mergers, amalgamations and takeovers. Okay? Mergers, amalgamations and takeovers. Making calls on shares, authorization for buyback, issue of security, borrowing money, invest funds of the company, grant loans, give guarantee, provide any securities in connection with the loan, or to approve annual financial statement, to diversify the business, to approve mergers, amalgamations and takeovers. Means what? The one of the board of directors power under Companies Act is to approve the mergers, amalgamations and takeovers. Therefore, first thing in this particular notice given to the shareholders or creditors, you need to tell that already board has approved the scheme as per 179(3)(I). Okay, board approved copy will be there now. 173, that copy will be filed with ROC. Effect on shareholders, KMP, promoters, non-promoter shareholders. Explained, sir. In the previous section we have read effect on creditors, all these things we said. In a merger, why creditors will be affected? They will be paid, that's all. Transferred from one place to another. Therefore, here main issue is with the shareholders. Shareholders, KMP, promoters and non-promoter shareholders. Next, copy of valuation report of an expert. Sir, what is copy of valuation report of an expert? Whenever you are transferring one company to another company, obviously intrinsic values, so net assets values will be calculated to calculate purchase consideration. Okay, net assets value or purchase consideration share values will be revalued at that time. Therefore, it should be done only by expert, if any. If revaluation is not done, well and good. If at all any done, registered valuer under section number 247 has to do the work. Next, 232 subsection 2 clause number E. A supplementary accounting statement, the gap between the last date of the previous financial year and the first meeting to approve the merger or amalgamation exceeds 6 months. This point, please, we will discuss in a separate place in itself where there will be a linkage. Okay, at that time I will discuss. Remaining all the concepts are completed here. Very, very important. Not tested. Mark this important for exams. Not tested till now. Contents of tribunal sanction order in case of amalgamation. Totally there will be 10 points. All the 10 you need to remember. Come with me. You will definitely remember all the 10 points. Listen carefully. Sir, in a merger, listen to my discussion first. Okay, listen to the discussion first. In a merger, I repeat, in a merger, there will be transfer of assets and liabilities from one person to another person. If you observe FR problems, they will tell in total assets, plant and machinery is not transferred. Okay, they will tell debtors of worth 10 crores are not transferred. Who is telling whether it is transferred or not? Tribunal will tell whether to transfer whole or part of the liabilities and assets. Clear everyone? Okay. Tribunal will pass a sanction order. In that they will tell whether to transfer all the assets or whether to transfer part of assets. Okay. Now, observation, common sense. If you observe the FR accountancy, first one will be business purchase account data to liquidator of selling company. After that, assets liability transfer. After that, purchase consideration transfer to equity, liquidator of selling company to equity debentures. So whatever the case may be, we will put an entry. 3 important entries are there. Number 1, business purchase to liquidator. Okay. Now the question starts. Why liquidator will come? Liquidator, why liquidator? Sir, merger is a corporate marriage. It's an auspicious occasion. At that time, person who comes at the time of death, liquidation means liquidator will come. Liquidator is like Katkapri. He will come at the time of death. Funeral time he should come. Why he is coming at the time of marriage? It's a bad aura. But still lawmakers will tell like that. Why he has to come at the time of amalgamation? Listen. Amalgamation is a process of killing the going concern assumption of one company. One company is running, another company is running. When both are running, one can't merge another. First you should lose your going concern. Going concern will be lost when you transfer all the assets and liabilities. Going concern is lost. That means balance sheet of one company looking like this. Balance sheet of another company looking like this. So many assets are there. So many assets are there. These assets are transferred. These liabilities are transferred. Now this asset. Now this company is like this. Pura khali. Nothing is there. Now you can merge both the companies. That means you have to dissolve company. You should not wind up the company. Liquidator in FR, financial reporting, liquidator will be there at the time of amalgamation. He is not coming to wind up your company. He will be coming to dissolve the assets and liabilities. Therefore, if you observe the 4th point, he will use the word dissolution without winding up. How beautifully he said. This is what we need to observe in FR as well. Okay. Next. Now tell me, entry number 1, first entry, business purchase to liquidator. Business purchase means what? Assets and liabilities should be paid. Number 1. Second one will be transfer of assets and liabilities. Transfer of assets and liabilities. Third one, payment of purchase consideration. You can pay in 3 forms. Okay, you can pay in shares, you can pay in debentures, sometimes fractional shares in cash or other instruments also you can issue. See here, payment of purchase consideration in the form of shares, debentures and other like instruments. Okay, any shares held prior to the merger by transferee company, those should be cancelled. Already if you are holding some shares of that company, cancel and remaining shares will be purchased. Next, so this is the first, second, third, fourth. Next, whenever amalgamation is there, one company merge with another company, pending legal proceedings against that first company will be transferred in the name of transferee company. Next one. Provision for dissenting shareholders. If anyone is not liking with the scheme, we will be giving him provision of exit offer. Means what? I will pay you some amount, you leave the company if you don't like the scheme. Very important, if there is a NRI shareholder. Through FDI route, any person becomes a member of this company and you are now going to a compromise. Okay? In that case, what will happen? In that case, how to pay them? The purchase consideration will be determined by tribunal, because if I pay lesser amount to them, it will not encourage the foreign market. Therefore, purchase consideration paid to all Indian equity may not be same as FDI equity. I will pay more than what I pay to the Indian equity because it will encourage them. So, next, obviously, transfer of employees will be made from one company to another company. Next, very important, see here. Transferor company is there. Transferee company is there. Transferor is listed. Transferee is unlisted. Transferor is unlisted. Transferee is listed. Transferor is listed. Transferee is listed. Transferor is unlisted. Transferee is unlisted. Super case. Transferor, selling company. Selling company is listed. Purchasing company is unlisted. Selling company is unlisted, purchasing company listed. Selling company listed, purchasing also listed. Selling listed, unlisted, purchasing unlisted. First case, I come from the below. Unlisted, unlisted, resulting company is unlisted. Listing, resulting is listing. Unlisted selling, purchasing listed, na? Listed. This is the case covered by the section. They are telling that if there is a company like this, see here. If transferor company is a listed company and transferee is an unlisted company, in such a case, transferee continue to be unlisted. That means just because of acquiring unlisted, unlisted suddenly will not become listed. But you need to observe one danger here. Selling company is listed. That shareholders, shares are already traded in the market. Acquiring company is unlisted. Share prices suddenly come to 10 rupees. Damage to them or not? Therefore, exit offer will be given to them as per predetermined formula. Okay, given by SEBI. Or SEBI will value separately. Whichever is higher, that value will be paid to them and they will be leaving the company. Next, new company formed. New company formed. New company, what company formed? New transferee company is formed. Yes or no? So, listen carefully. Transferor company is there, transferee company is there, new company will be formed. New company will be formed with a higher capital base. For example, if the authorized share capital of transferee company is 100 crores, transferor company's capital is 70 crores, merge na 170 crores it will become, it crosses authorized share capital when it comes to new company. New transferee company, I mean. Okay. In that case, authorized share capital has to increase or not? For that, we need to pay some fees or not? Fees will be paid by new company. From this fees, set off fees paid by transferor company at the time of incorporation. Set off the fees paid on authorized share capital by transferor company against the fees paid on authorized share capital by transferee company. Any other incidental matters, court will provide for. These are all the orders of tribunal. Next, other topics. Same thing, sir. Whenever amalgamation is there, Ind AS will apply. Auditor should give a certificate that, okay, the total scheme will be in effect of 133. Ind AS will be there. Business combinations. I will follow that standard while giving accounting impact. You need to give a certification. Next, filing order. File the tribunal sanction order with ROC within 30 days. Okay. Tribunal will tell when the scheme will become effective. That means when the merger will be completed, tribunal will tell the date. Okay. So listen. See here. I started compromise arrangement this financial year. February 2021, I started compromise of merger nature. It started, March completed, 1 month after March, 2 months after March completed, financial year crossed. Even after 210 days, still scheme is going on. Merger cannot be completed in one day. Satyam company merger was taking almost around 2.5 years. Merger with the Tech Mahindra at that time. I am telling, I started in one financial year. that one financial year completed, even after completion, after 210 days also it is continuing. In that case, progress of the scheme must be submitted to the ROC in CAA 8, certified by CA, CMA or CS in practice. Okay. Next. Consequences of contravention. I have given the penalty chart at the end. Follow that. If 230 section, previous one, or 232 section, if these two sections are happening for a government company, then instead of NCLT, supervision will be given to the tribunal. Okay, sorry, CG instead of tribunal. That means if it is a government company, then the administration of this entire procedure, that means whatever we discussed till now, instead of tribunal, copy paste central government in case of government companies. Okay, so this is the idea behind section number 232. This is the another concept that we are discussed. So these are all case laws only for your understanding. When you have the charts book, you can read this. Next. So two small sections are there. Let me discuss those. Listen. Sir, please. Sir, up to here, everyone understood the concept clearly? Please, a small message from you. Everyone. Please. I said you already. You will be the boosters for us to take the class now. So today, so long journey na, so you should understand our problem as well. Everyone understood the concept clearly? Yeah. Thank you. And up to here, whatever is discussed till now, how you felt with the class, everyone? Are you okay with the flow? Are you okay with the speed? Thank you very much. Thank you. So let's continue. See here. Two other sections are there. See here. Connected provisions to the amalgamation. What are these connected provisions to amalgamation? Two small sections are there. Okay. First point. Preservation of books after amalgamation. Question arises like this. Two companies are there. Transfer or transferee. Let's say A, B are there. B is acquired by A Limited. Once B is acquired by A Limited, automatically only A Limited will be in existing. Question has come, the books of accounts of B Limited must be maintained, need not be maintained. Answer is neutral. You can't tell yes, you can't tell no. If you want to dispose the books of transfer or company, first make an application to central government. Central government will appoint an inspector to inspect your books. If there is any instances of fraud, offenses in promotion, management, etc., you cannot dispose, or else you can dispose the books. Answer completed. Next. There is a company called as A Limited. There is a company called as B Limited. A Limited, B Limited, there are two different kinds of companies are there. Okay. A Limited, Mr. A is a director. B Limited is there. This is a company which here Mr. B is a director. B Limited is merged by A. B Limited is absorbed by A. A absorbed B. Now only A Limited will be in existing. Mr. B has done frauds in B Limited. Now Mr. B became director of A Limited. Now B said, since that company is not in existence, my frauds also will go away. నువ్వు గంగానదిలో మునిగితే నీ పాపం గంగానది కంటుతుంది కానీ నీ పాపం పోదు. ఓకే, సో ద సింపుల్ లాజిక్ బిహైండ్ దిస్ ఈజ్, నీ దరిద్రం దానికి అంటుకుంటుంది ఏ లిమిటెడ్కి, అంతేగాని యూ విల్ నాట్ బికమ్ క్లీన్ జస్ట్ బికాస్ ఆఫ్ గోయింగ్ బై ద స్కీమ్ ఆఫ్ మెర్జర్. యువర్ లైబిలిటీస్ యాజ్ అన్ ఆఫీసర్ ఆర్ ఎ డైరెక్టర్ విల్ నాట్ గెట్ సీజ్డ్. దే షల్ కంటిన్యూ అండ్ నో అబేట్మెంట్ ఇన్ దట్ రెస్పెక్ట్. ఓకే, దట్స్ ద బేసిక్ ఐడియా. This is what said in section 240, 239. So we completed so many sections now in a flow. 230, 231, 232, 239, 240. 5 sections completed. Next, merger or amalgamation of one company with a foreign company. Okay, sir, what is this foreign company concept? Listen, I will write a notes here. Observation required. Transfer or transferee, resulting company. Okay, see here. Transferor company, Indian company. Transferee, foreign company. Okay, transferor, foreign company. Transferee, Indian company. Transferor, Indian company. Transferee, Indian company. Transferor, foreign company. Transferee, foreign company. Okay, see here. Transferor is an Indian company. Transferee is a foreign company. Resulting company is a foreign company. Transferor is a foreign. Transferee is Indian. Resulting is a Indian. Indian company merging together to form a company outside India. Foreign company. Simply the logic is, try to understand, if anywhere in the entire scheme of amalgamation foreign company is involved, normal 230 procedures and 232 will apply. Along with that 234 will also get applied. Not tested in exam, mark it important. In this connection, I will tell you one small logic, listen. Okay? In this connection, I want to tell one small logic, listen. Students are generally seeing the past exam questions and going to exam. No problem. Yes, it will test your knowledge. I am not denying with that. But don't be under wrong impression that questions which are not tested in examinations prior will not come in exam. Shall I give you an example? 230 subsection 7 la contents of tribunal sanction order is not tested anywhere in the past exam questions. It came directly in one attempt. Then what will be the position of a person who rely on past questions, RTPs and MTC and go to exam? The trend that is fashionably followed by institute today is blend. 20 to 30% of the paper will come as it is from the past questions. Remaining paper will be new. In that, partially old, partially new blend will be there. Minimum 30% to 40% of the paper absolutely new in the exam hall. That's why we couldn't score well, because we are relying more on unreliable sources. Unreliable source means what? Institute past questions are itself are unreliable source. You can't rely on that. Institute didn't tell that in this 70 marks of Companies Act, I will definitely ask 40 marks from past exam. Like that, it didn't give any guarantee to you. Therefore, with what confidence you are reading that? You can build your confidence through past exam questions, but it should not become your source of preparation. That's what my problem is. Okay, what I want to tell is, don't make past exam questions as your source of preparation. It should be aiding your preparation. It should add to your preparation. It should augment your preparation. It should enhance your preparation. It should not become the preparation in itself. Okay, so sir, anyway, now listen. What mergers are covered here? Indian company with company incorporated in notified jurisdiction. Notified jurisdiction outside India. Indian company with a foreign company to form a foreign company. Foreign company with Indian company to form Indian company. Anything resulting or merging, anything in that total scheme, foreign company must be involved. Okay, next. What is a foreign company? Listen carefully, this is important. Generally, when I ask a question, what is a foreign company? Immediately people will come with a section 2 clause 42 definition. Foreign company means a company or a body corporate incorporate outside India, having a place of business in India either by itself or through agents, whether physically or electronic mode, and conducts business in any other manner. They will tell the definition under section 2 clause 42. Not that. Here explanation has given different definition for foreign company. You may or may not have place of business. If it is incorporate outside India, it is called as a foreign company. Okay, what is notified jurisdiction? Annexure B is there to the Companies Act. That Annexure B defined what is a notified jurisdiction. Some countries with whom India don't have financial relations will not be there in Annexure B. Pakistan, Afghanistan, these countries will not be there in annexures. Okay, next. Procedure. How to amalgamate? Same. Along with 232, we need to follow this. Since two companies of two different countries are involved, foreign exchange will be involved. RBI involvement comes. 232 entire procedure will apply. Along with that, valuer should value. That valuer should have recognized a certification from the global body, internationally accepted accounting principles he should have. Sir, why sir valuer will come? I got a doubt, sir. If any kada valuer, why it is compulsory to come a valuer? You have to come. Why? Question will arise na? Merger started today. Foreign company, Indian. You have to pay purchase consideration. Purchase consideration will be paid. For example, foreign company added to Indian company to form Indian company, or Indian company added to foreign company to form a foreign company. Here, resulting company is Indian. Here, resulting is foreign. Here, purchasing company, first case, purchasing company, Indian company. Selling company, foreign. That means Indian company must pay to foreign company. Second case, foreign company must pay to Indian company. Means flow of foreign exchange is there from one person to another. How much value you need to pay, how much exchange rate you will take, how much share price you will take. How can you quantify that? Their shares you have to value. Our shares we have to value. Purchase consideration you need to calculate. Therefore, we require an internationally accepted accounting principles knowledge person by a recognized professional body, global bodies. Okay. How the purchase consideration will be paid? Same. Cash, deposit receipts are a combination. If it is Indian company, shares. Outside India, deposit receipts may be given. Okay. Next, 234 section is subjected to provisions of any other law. If there is any international taxation dealings, income tax will apply. Am I clear? Yeah. This is a amalgamation of a company with a foreign company. Next, central government amalgamation in public interest. Sir, I completed 234 section as well. Everyone following the points? Everyone in the class following the point? Everyone in the class following the point up to here? Everyone clear? Yeah, thank you. So let us start with remaining concepts on compromise area. See here. Power of CG to provide for amalgamation in public interest. Sir, another 15 to 20 minutes. We will cover this area. Big concept in the syllabus now. We will complete. Okay. After that, investigation will start. Not so big like this. Easily we can complete. Same with oppression. What time we have taken for this? In this time we will complete those two. At least 1.5. Okay. So once these are completed, remaining becomes easy for us. NCLT 30-35 minutes. Special code 30-40 minutes max. Okay. After that we will go into registered valuers. All the concepts I will complete. But let me complete important concepts with some level of detail. Remaining we can just go with the flow of the discussion. We can easily understand the remaining parts. Okay. Okay. Next. See here. Power of central government to provide for amalgamation in public interest. So first let us understand the background in 2 minutes. Why public interest? See here. The biggest scam happened in India with regard to the companies is a Satyam scam. Till now. Recognized, maybe. I'm not talking about political scam. Political scams, there are industry hit holders. Okay. I'm not talking about political scams. I'm talking about corporate scams. Even after so many regulations, even after so many personal regulators like ROC, okay, they will be watchdogs. Even after the vigilance that was provided by the MCA, companies have done some frauds. Classic example, Satyam case. Satyam case, some big scam has happened worth thousands of crores. If you inflate the value and calculate today, it comes to around 30-40,000 crores. It was around 7,833 crores in the year 2005, 2021. Almost 20 years you can take. 18 to 20 years. 20 years after, what is the value of that 8,000 crores today? It will be multiplied to 30-40,000 crores. That means one company could do that much level of fraud. Means what Companies Act is doing? With that idea only 2013 Companies Act started writing by J.J. Irani committee in the year 2007-8. After Satyam merged with Tech Mahindra, government has got a tight slap on the face. What our Companies Act is doing in India if these people are doing all these things? So therefore they thought that a vigilance mechanism should come in Companies Act. Therefore, so many concepts here: audit committee, nomination, remuneration, vigilance mechanism committee, stakeholders relationship committees. Why these concepts came? Satyam scam should never happen with another company in India. Now let's come to the point. When Satyam scam happened, government was shocked with the scam. Market was shocked for the scam. International cross-border merging companies also shocked. Do you know Satyam is one of the rarest breed of Indian companies who got their shares cross-listed. Satyam shares are traded in Nikkei Canada. Satyam shares are traded in NYSE and Nasdaq USA. Satyam shares are quoted in Hong Kong and Shanghai Stock Exchange. Satyam companies shares are traded in Thailand. Satyam company shares are traded in India, everywhere. And free floated shares in Australia. It is having a huge belt market in New Zealand. Such a big company, if it does a fraud, all countries like India will get disreputed. Same thing happened. No one believed in the reporting of any other financial reporting of any other company. All software companies are also in severe distress. At the same time, Lehman Brothers company in USA also broke out. Enron case came in USA. That's why 2007, 8, 9. Black days for all the entire world market. US market fall down because of bankruptcy of Lehman Brothers. Because of bankruptcy of Enron case is there. Fraud happened in USA. Like Satyam here, Enron for them. So Enron case happened. Lehman Brothers case happened. Breaking of Lehman Brothers. Like this, all the cases once for all, it hit the markets. Boom lost for software market at that time. So many movies, short films came at that time. Okay, criticizing the loss of boom for the software market. 2008-9 time. 7-8-9. India stress on Satyam case. There, all the other Enron company like that, those companies have done. Suddenly there is a severe distress. What to do with the Satyam case? Now the investigating department has got it out. What to do with Satyam case now? What we can do? Government has got a concept. This is the most biggest fraud that happened. Created a disrepute. Na? Shall we wind up this? Is a question. Wind up is a good idea. But one thing please answer. Satyam company is having around 2 lakh employees at that time. It is having around 10 to 12 lakh shareholders throughout the globe. Cross-listed company. Having around lakhs of crores of creditors are there. Thousands of crores of tax dues are there. Thousands of crores of workmen compensation dues are there. If I wind up the company, will you feed all these 2 lakh employees government of India? Okay. Will you give job for them? They will lose the job. Will you give the job to them? To all the 2 lakh employees, will you give the job? You will not give. To all the 10 lakh to 12 lakh shareholders, will you pay exact compensation on market? You can't pay. Okay, can you pay to the creditors? There is around 1 lakh crore creditor due is there. Will you pay? You will not pay. Okay, workmen gratuity bonus PF dues are there with the company. Around 20-25,000 crores are there. Will you pay? Government said I will not. Then why you are winding up the company? Then who the hell are you to wind up? Killing is not at all an idea. We have to reconstruct the company. Therefore, the biggest fraudster in India itself is not wound up in India. That's India for me. That's India for you as well. India never kills the persons. It will try to change that. Killing is one simple concept here. I will tell tribunal, I wind up this company. That's all. The next day winding up orders will come. ROC will come. Liquidator will come. They will sell the asset. They will discharge the liabilities. These people will become beggars the very next day. Killing is not our idea. Our idea is to reconstruct public interest. If I wind up this company, people will lose a trust on government. Whenever that person does wrong, what employees has done, in the interest of public, I will not wind up the company. I will merge it with another company having similar objectives. Therefore, Satyam company merged with Tech Mahindra on a bidding process. They purchased a share at 55 rupees. The share which is traded 683 rupees on the day of announcement by Satyam Ramalingaraju. When Ramalingaraju announced that company is in fraud, the share price is 683. Purchase price of the share by Tech Mahindra is 55 rupees. Sir, what's a sudden fall so much? At least you got 55. If winding up is happened, you might have got zero value. Okay, 55 rupees. The Tech Mahindra purchased entire company. Per each share they paid 55 rupees. At that time they got it out. Fraud done by directors of company. Employees, what they have done here? You are punishing Ramalingaraju by keeping him in jail. But what for me? I am not benefited. One jail పెడితే నాకేం వస్తుంది? ఒక రోజు 2 రోజులు మనశ్శాంతి, సంతృప్తి. But after that, I will not get monetarily anything in my pocket. He is in jail. Okay, mentally I am satisfied. Fraudster is inside the jail. What compensation you are giving to me? I am also a loser. At that time they got it out. Really kada? I kept them in jail. I merged with this company. Really they lost much in this company. What compensation we are paying to them? At that time Government of India got a doubt. Companies Act, is there any section search? Can we pay compensation in case of mergers like this? No section is there. At that time they brought the concept called as class action suits. Class action suits, section number 245, we will cover today. Class action suits, if you really observe, it targets on payment of compensation. Yes. Sir, how compensation will be paid? I will puke Ramalinga Raju, I will puke his sons, I will puke the throat of that auditor. Why you are given wrong reporting? I will take money from them and compensate the losers. That is the idea that we have to understand. So auditors, chartered accountants, legal advisors, okay, directors, they will spew you up. Gontu pisiki kakkistadu mottam. So that's the real intent of this section. ఇంత ఎమోషనల్గా చెప్తుంది ఎందుకంటే కనెక్ట్ అవ్వడానికి. యూ షుడ్ కనెక్ట్ టు ద సెక్షన్ ప్రాపర్లీ, దెన్ యూ కెన్ రియల్లీ అండర్స్టాండ్ ద ఇంపాక్ట్ వై దిస్ సెక్షన్ కేమ్. సో పవర్ ఆఫ్ సిఈజీ టు ప్రొవైడ్ ఫర్ అమాల్గమేషన్ ఇన్ పబ్లిక్ ఇంట్రెస్ట్. Type from here very fast. Concept is clear, everything will be same like previous ones. Amalgamation is in public interest. CG provide for listen, one important point I forgot to tell. Here absorption will not be there, amalgamation will be there. Satyam, Tech Mahindra merged to form Mahindra Satyam. Tech Mahindra didn't acquire Satyam and put the name Tech Mahindra. Tech Mahindra acquires Satyam to form Mahindra Satyam. This is only amalgamation, new formation, not absorption. Okay. So central government shall provide for amalgamation of two or more companies to a single company. Okay. So now, next, power of CG to provide for amalgamation. CG will specify what are your duties, what are your debts, what is your property, what is your rights in the newly formed company. Next, legal proceedings in the name of Satyam, will they continue? Will they continue in the name of Tech Mahindra Satyam. Next. Position of new company and payment of compensation. So new company is formed. We have to pay compensation to the shareholders. Compensation means purchase consideration. Okay. If rights, interest and privileges of any shareholder, debenture holder, other creditors of the transfer company before amalgamation is same. Must be same. That means if I have one amount of share in Satyam, I should get the same amount even in Mahindra Satyam. If there is any lesser rights to me in the new company, I will be entitled to get some compensation from the tribunal. Tribunal will not pay compensation, tribunal will quantify the compensation. Okay, tribunal will quantify the compensation. I repeat, if I am a creditor in Satyam company, my due is 10,000, my due is 500 crores. New company is formed, in that I am getting only 300 crores as a compensation. I am losing some right or not? At least to that right, give me some equity shares. Okay, if you are not giving equity shares and reducing my liability, I am having a lesser rights or not, I will be entitled to a compensation. Compensation will be determined by the tribunal and notified in the official gazette. If you are aggrieved by the compensation, on this a question was tested. Okay, aggrieved by compensation. Listen, central government has announced amalgamation in public interest. Amalgamation cannot be rejected. You cannot object amalgamation. It was already a decision taken. You can only aggrieve by the compensation. This is what one of the question asked in 2017 attempt. Any person can aggrieve on the compensation, can't aggrieve on the scheme of amalgamation. Okay, within 30 days of the date of notification official gazette, you can aggrieve and you can person aggrieved by compensation may prefer an appeal within 30 days to the tribunal. You can make an application to the tribunal that this compensation is very less. It will pass a final order. Okay, so the draft scheme, basic rough scheme, central government will draft, send to both the companies Satyam and Tech Mahindra. If there are any objections or suggestions, you can give, we will accept. Okay, final order will be passed. Okay, and objections will be considered and final order copy will be placed before both the houses of parliament. Main points you need to understand is power of central government to provide for amalgamation in public interest, and central government will provide for amalgamation, the transfer of properties and rights. Legal proceedings will continue in the name of new company. If rights are lesser in the new company, you will be entitled to a compensation. If that compensation is not agreeable, you can agree on that and make a preference appeal within 30 days to the tribunal. Draft scheme will be submitted to both of them. Any appeal must be completed before you close the particular amalgamation, and final order will be placed, and it will be placed before both the houses of parliament. Amalgamation in public interest completed. This is another area. So everyone in the class who are listening to the class understood the concept? Understood the concept, everyone? This section, particularly this section, amalgamation public interest. Hope everyone understood the concept clearly. When, one question, Praveen Parker, sir, when legal proceedings are transferred to transferee company, why one go into legal proceedings unnecessarily because of amalgamation? If you like amalgamation, then you should be ready to take liabilities as well. You should not tell that I want amalgamation but I don't want legal proceedings. They will not accept. You should accept both. And purchase consideration will be paid accordingly. Okay? Yeah. So let's continue. So just at the end of the story we are. Please concentrate properly. See here. Just a minute. Yes, this one. Power to acquire the shares of shareholders dissenting from the scheme or contract approved by the majority. Section 235. Let us try to understand the idea behind this section before we begin with anything else. See here. See here, there is one company. Okay, there is one company. There is another company. Name them X Limited, Y Limited. This question is 235 read with 238. Mark it important for the exam. They may merge and ask a question. This was asked in 2015 RTP but not tested in exam. 238 section I am talking about. We will merge 235 and 238 now to explain the real impact. X Limited, Y Limited, two companies are there. X Limited will give an offer to Y Limited. Will give what, sir? Offer to Y Limited. To Y Limited, Y Limited's shareholders, they will give a offer. Okay. Offer to what? Offer that X Limited is going to purchase the shares of Y Limited. X Limited purchase the shares of Y Limited. Now observation is required. I am not merging with Y Limited. I want to acquire the shares of Y Limited from their shareholders. Okay. I want to hold the shares. You can purchase in open market. You can purchase in any format is anything. But the idea of the company is X Limited want to acquire the shares of Y Limited. Okay. I will give notice, offer notice to the shareholders of the company. Which company? Y Limited's company. I will give a notice, offer notice. I will give an offer. Market price today is 200 rupees. I will be paying you 383 rupees for each share. Are you ready to sell the shares? In the market, 383 anyway it will come. I don't think that it will come in the near future. But this company is finding something appealing in this company. This company will send to the shareholders of Y Limited, I will purchase your shares at a higher rate of 383. Are you ready to sell? Offer will be given. That offer will be valid for 4 months. In this 4 months time, acceptances should come from members holding not less than 90% of the total shareholding. Not 90% of the members, shareholders holding 90%. That means there are 1 lakh shares. There are 1 lakh shares. 10,000 shareholders are holding 92,000 shares. If the 10,000 accept, enough. Even if the remaining 90,000 shareholders don't accept, no problem. I want number of shares, not the number of shareholders. Okay. We need to get the consent of, offer consent of 90% in this 4 months time, offer period. Okay. Now observation required. See here. Chart. Month 0, offer given by offer given by transferee company to the shareholders of transferor company. Offer given by the transferee company to the shareholders of transferor company. Okay. Next, what will happen? Offer will be valid for 4 months. We call it offer period. Okay. Next, month 4. 4 months completed. In this 4 months gap, I should get acceptance from members holding not less than 90% in value. Okay, shall accept. In this 90%, my holding, already transferee company is holding some shares. My acceptance I can't give to me, even my subsidiary or my nominee. Those need to be excluded. In the remind, for example, there are 1 lakh shares here. 1 lakh shares la 90% mean 90,000. Already even before giving this offer from the stock market, already transferee company purchased 10,000 shares. Deduct this 10,000, 80,000 is there na? In this 80,000 we need to count. Okay, in this 80,000 we need to take the consent. Next, so 90% value means the shares held. Now listen, here they accepted, they didn't accept. I got only 85% acceptance. You can't continue with the concept. Sir, what is this concept, sir? This is a merger amalgamation, takeover. This is called as what, sir? Takeovers. This concept is not merger. This is a takeover bid. It will be called as takeover bid. So listen carefully. I gave offer for 4 months. 4 months la 90% acceptances didn't come to me. You can't continue with the takeover. Sir, 90% acceptances came, sir. Now you give a notice. You give a notice. Who give? Transferee company will give a notice. Will give notice to whom? Other dissenting shareholders of that transfer or company. Why you are not accepting here? What's wrong with you? Andar accept chesaru kada. Everyone is accepting. Why you are not accepting the scheme? Like that we will give a notice and we will tell that I am going to acquire your shares as well. Okay. 2 months la you need to give a notice. Last date for issuing the notice to dissenting shareholders showing its intention to make acquisition of the shares. Next, once these dissenting shareholders received the notice, they thought that who the hell is he? I'm not accepting. Why he is telling I will compulsorily acquire? You don't know government. Amaravati lands తీసుకున్నట్టు. So he is a government. Government means yes, there is a chance. A compulsory acquisition concept can come. You are a normal company like me. How the hell you can tell that I will acquire your shares? But there is a chance in companies. Appeal can be made by dissenting shareholders within 1 month. In 1 month you can go for an appeal to tribunal. Last date for appeal M7, M0, M4, M6, M7. M0 offer given, continued for 4 months, acceptances 90%. Notice to dissenting another 2 months period. After that appeal period another 1 month period. Last date for preferring an appeal. Appeal judgment going on like this. 2 situations can happen. Appeal in favor of dissenting shareholders, appeal in favor of transferee company. If appeal is in favor of dissenting shareholders, you can't acquire the shares of dissenting only. Remaining you can acquire. Anyway 90% acceptance came na. Remaining 10 you can't acquire, 90% you can acquire. Appeal in favor of transferee company, the transferee company shall be entitled and bound to acquire the shares. Now the question will come. Sir, winning is dissenting, you can't acquire. Winning is transferee, you can mandatorily acquire the shares of dissenting. Okay, this is the point. Now my question. Transferee company should pay compensation to transferor company. Like this, you should not think. Transferee company has to pay compensation to shareholders of transferor company. Means what? This shareholders bank account details must be there with transferee company. Means if there are 10 lakh shareholders in the company or 5 lakh shareholders in the company or 1 lakh shareholders, 1 lakh bank accounts I have to feed now. Is it possible? Is it practical? With the transferor company, already their bank details are there. But payment should be made by transfer. That means their bank account details must be known to transferee. Is it practical to know the bank account numbers and depositing in their accounts? No. Super concept was drafted by Companies Act saying that don't do like that. Transferee company, you transfer entire amount to transferor company's bank account. Transferor company must transfer all these amounts within 60 days to their shareholders. In that time, it will be kept in a separate bank account called as escrow account. Okay, this is the whole idea behind this particular section number 235. Hope everyone understood the concept very clearly up to here. Okay, so please one reply everyone. After every section, let me at least make a confirmation whether you understood or not. Everyone understood section 235? One person is asking, can you explain the closure time of appeal again? Closure time of appeal. Appeal will be made within 1 month time from the date of receipt of notice from the transferee company by the dissenting shareholders. If they don't make an application of appeal, scheme is said to be accepted by them. Deemed acceptance will be there. Okay, that's the idea. So let's start with the other concept. See here everyone. So 235 section completed. Sir, one question before we continue with the next one. One small question to continue before we continue with the next one. One small question. Please answer this. That question what I want to ask is, see here, 90% acceptances came. 10% didn't come. Okay. Now, if 10% also comes, what the other company will become? I repeat. X limited is there. Y limited is there. Y limited is having 1 lakh shares. Example, 90,000 shares are acquired. 10,000 not acquired, okay. 10,000 also acquired. What will happen? What will happen? Arey, what will happen here? Answer. Why you are sitting silent? Arey, I am shouting from last 2 hours. Can't you just explain one point? Yeah. Everyone has answered that. Okay. Takeover completed. Okay, takeover will be completed. That is okay. What will happen? What is the status of that other company? What is the status of that other company? Therefore, one company will become wholly owned subsidiary of another company. Like this, you should not think. This particular section is not to, I repeat once again, this section is not to, I repeat once again, this section is not to make wholly owned subsidiaries. No. If you see the bare act clearly, for this only I asked that question. I know what answer you will give. See here, X limited, Y limited, 2 companies are there. Y limited there are 1 lakh shares. X limited how many shares? Irrelevant. In 1 lakh shares, I gave offer notice to the shareholders holding 20,000 shares. In this 20,000, 90%, not in the total. Don't be under wrong impression that this section is to make subsidiaries. No. This section is to make the takeover of some shares of another company. This section 235 must be read along with section number 186, loans and investment by company. The brothers gather, if at all it has to ask an exam like this, it can come. You have to comply with 186, after you need to come to 235. 235 is a procedure, 186 is permissions. Everyone now understood? Huh? The brothers gather. So now another question will come. Okay, just wait for the twister. Just wait for the twister. Listen, this section, some persons are telling, please explain again. I'll explain. This section is not for making subsidiaries. Acquisition of one company, the shares of another company by takeover bid, then only this will apply. Okay, by takeover bid if you go, this will apply. Takeover, we will acquire shares of another company. Acquisition of shares is governed by 186 as well. Permissions as per 186, procedure as per 235 we need to follow. This is the basic idea. 90% of offer shareholders only we need to get. Total 1 lakh shares, 90% you need to acquire as per this particular section. No. Offer given only to 10,000 shareholders. Shareholders holding 10,000 shares. In that 10,000, 90% acceptance should come. Not total 1 lakh shares or 90. If you read Bayer Act, you can understand this way of logic. Okay. Now my question. Okay. Now my question. See here. There is a observation required, sir. Unnecessarily, I am not going to tell any story here, and we don't have time to discuss about some stories. So please listen. There is a company called as X Limited. There is a company called as Y Limited. Two companies are there. Okay. This is a transferee company. This is a transferor company. Okay. Now listen carefully. This transferee company is giving offer to shareholders of transferor company that it want to acquire its shares. When some outsider is giving offer letters to your shareholders, what the directors of this bloody Y Limited is doing? Are they baiting nails? Or eating grass? When some outsider is giving notices to your equity shareholders that I will mandatorily acquire your shares, what the directors of that company are doing? Logic or not, everyone? Answer here, logic or not? Yes or no, everyone in the class? Obviously, when some outsider is giving notices to your equity shareholders, what you are doing? Em chestunnava nuvu? Evado outsider vachi nee company lo unna shareholders ki offer notice lu ichi acquire chestanu ante em chestunnava? Gatti pikutunava? So what you are doing here? So if some person, some outside company came to your company giving notices that I will acquire the shares, what you are doing? This is what the opening scene of Atharinti Daredi movie. Some person is trying to acquire your shares. He is contravening the provisions of 235 in that movie. Did you understand the logic, everyone? Now you can attach the concept. Okay, because Pawan Kalyan is involved, so you can understand the intention of that. Some outsider giving notices to your shareholders, gatti pikutunava? Idende idi ekkada solla? So what is going on? Therefore, lawmaker also thought of the same. How it is possible? So screenplay was changed a little bit. They brought a section called as section 238. 238 section says that, see here, whenever there is a takeover under 235, first, before giving offer notice to my shareholders, first this company should approach to the board of directors of that company. Observation again goes to 179. 179 subsection 3, what I said, making calls on shares, authorization by buyback, issue of security, borrow money, invest funds of the company, to grant loans, give guarantees and provide any securities in respect of loan, to approve annual financial statement, to diversify the business, to approve amalgamations, to approve takeovers. 10th power, section 179 subsection number 3, clause number J. We'll be discussing about takeover approval by the board of directors. Transferor company will first put a notice to the directors of transferor company. It will tell, I want to acquire the shares of your shareholders. I will pay this much to them. Then circular will be issued by the directors of that company. Circular will have 5 contents. This is what they will ask in exam. Form CAA 15 circular issued by directors of transferor, issued to the shareholders of transferor. Circular will recommend the acceptance of scheme. They will, directors of the company will tell their shareholders, if we are the directors in this company in the next 5-6 years, share price will not be going to 380. We know about us. Accept the scheme. They will accept. Now answer, this is merger or takeover? Takeover. Takeover means what? Another company must pay cash to the shareholders. That means the other company which is acquiring must have necessary cash with it. After acceptance, everything is accepted. That person is not paying after taking the shares. Therefore, directors should tell in the circular to the shareholders clearly that necessary cash is available with the transfer or transferee company. And circular should be registered with ROC. Once the circular is filed with ROC, ROC may refuse it. Okay, refusal. What are the reasons? Not containing full particulars or false particulars are there. You can go for an appeal within 30 days. This is how 2 sections are blended each other. So everyone understood the concept clearly? Everyone understood the concept clearly? Everyone in the class understood the concept? Yep. Sir, this section is also completed. Almost all the topics are completed now. Just one small section was remaining. Okay. Pooja Jaiswal, sir, what if appeal in favor of dissenting shareholder? We takeover will not cancel. Remaining shares of dissenting they can't acquire. 90% are already accepted. Now scheme is already accepted. Remaining you can't acquire. Pooja Jaiswal, I think you understood what I said. Please give an answer for that. Amit Thapa, first time understood. Thank you very much, at least to understand that. Mohammad Samir Pasha, వింటున్నాను ఎదురవుతున్నావు నువ్వు ఇప్పుడు కూడా. Mohammad Samir Pasha, I am asking you. So next, everyone clear. Yes. Samir Pasha, you are listening today for the first time in life. Thank you very much. I am really feeling privileged. Okay. Sorry, everyone. Only one section was remaining for us, section 233. We will start that section after a small break. Just 5 minutes to 10 minutes, we'll complete the 233 after the break, and then we will be starting with oppression mismanagement. After that, inspection inquiry investigation will start. Okay, 233 section. Why I want to take a break means I said 233 is the most important section in this chapter. I just don't want to continue because 2 hours long session, people may get exhausted, get recharged, come back, we will continue. Our target, complete entire Companies Act today. Please have a break and come. It's a 10:06, 10:30 we will meet back. 10:36, 30 minutes break because I am also exhausted totally. 10:36 we will be meeting back. Okay, please everyone participate properly. We'll complete entire Companies Act. Okay, thank you. So please everyone in the class take a break and come soon. Up to 10:36, 10:35, 10:36 I will be back again. Okay, half an hour. Take a break and come soon, please everyone. So welcome back everyone. So let us start with section number 233. Let us start with section number 233. So just another 2 minutes, 10:40 we will start. Let others also join, because I am getting messages on my mobile that please start 1 minute after. So let everyone join. Sir, how to buy the charts? I will give you the details after the session. Okay. So I will be answering all your queries. Pooja Jaiswal, I have heard your question. Definitely I will answer. Please everyone join fast. The only intention is let not anyone lose any point in the revision session. Please everyone join fast. Everyone, please join fast. Yeah, let us start. So now we are going into the next area. Srinivas PS, sir, it is 10:41 now. Yes, in my mobile also it's 10:41. I know here. Let all the others also come. So let us start with section number 200. Let us start with section number 233. Okay. So let's start with that. See here. Merger or amalgamation of certain companies. This is dealt by section number 233. Merger or amalgamation of certain companies. Section number 233. First, let us understand the modus operandi. That means idea behind this particular section. Once you understand the wavelength of this section, concepts become very easy, not so difficult. See here. See here once for all everyone. What is the purpose of section number 233? Let's understand. 233 section is not available to all the companies. It is available for two types. Small company merging with another small company. Next one, holding company with wholly owned subsidiary, acquiring the wholly owned subsidiary. In these two cases, section 233 will apply. Okay, I repeat, 233 section will apply for small with a small, holding with a wholly owned subsidiary, where compliance mechanism will be very, very less. Holding company, wholly owned subsidiary means it's just a mirror image of holding company. Therefore, so much procedures of 232 are not required. 232 section, if you observe the total steps, it will be taking around 8 to 9 months to complete the scheme. Is there a scheme to complete within 60 days or 70 days or 3 months? Yes. That's why it's called as fast track merger procedure. Which procedure? Fast track merger procedure. 233 section is a fast track merger procedure where a small company can merge with another small company, or a holding company can merge with a wholly owned subsidiary company and forming only one company later. That's why this concept is called as a fast track merger. Now the question will come, sir, why it is fast track merger? Is there any reason? Yes, there is a reason. As per section number 420, tribunal hearing will happen. Hearing of tribunal. Tribunal hearing, I will tell you very clearly, because around 68-70 cases we appeared before NCLT. NCLT Hyderabad, NCLT Chennai, NCLT Bengaluru. So when we come to NCLT chapter, I can practically explain how NCLT proceedings are. But still at this point of level, let us understand what is section 420. 420 talks of a tribunal hearing, orders of tribunal. Okay? Sorry, let us understand like this. Tribunal hearing will happen under section 420. Tribunal gives a judgment. Okay? This judgment has to be given within what time? Section 422 will discuss of this. 422 says it should be given within 3 months. Extendable by another 90 days. Means technically 6 months. That means when I make application in form NCLT 1, whether it is accepted or not itself will be said within 6 months time. After that proceedings has to start. Whenever NCLT medium is involved in the procedure, proceedings will get long standing and promote a big longevity in the proceedings journey, which is not welcomed in various situations. Therefore, lawmaker has a thought of, is there any chance to make omission of tribunal involvement? Government said no. Without NCLT involvement, don't start this chapter. Compromise arrangement chapter, tribunal must be there. Okay, we will do one thing. We will put government mediators, but tribunal will come only when there is a objections in the scheme. Means what? ROC and official liquidator will take care of entire merger. But if there are any objections, tribunal will come and involve. That means generally tribunal involvement is 0, but there is an objection to the scheme of merger, tribunal will involve. Like the draft section. They drafted a section called as section number 233. I repeat, small company with another small company, holding company with wholly owned subsidiary, section 233 will apply. Now I will ask one question, everyone answer my question. One small company with another small company, both want to merger. Which section shall apply? First tell me, section number. One small company with another small company, which section will apply? Everyone here, what is a mandatory section to comply? One small with another small merge together. Which section will apply? I asked you everyone, please participate in the class. Okay? Please. Yes. Mandatorily we need to follow with section number 233. Wrong. Like this we should not think. 233 is only an option. I repeat. 233 is only an option. 233 is wrong answer. Even if you want to merge, okay, even if you want to merge small company with another small company, instead of 233 you can go by 232. No problem. 233 is only an option. Still some people are giving 233. Right, stop giving answers here. So 232 is optional. 233 is also optional. If you want 232, go by 232. If you want 233, come through 233. Whatever you want, follow that. Now question will arise, sir, when there is a procedure where tribunal is not involved, when there is a procedure where you can complete in 3 months, why I will unnecessarily go to a procedure where it will take 1 full year to complete? Even as an option, why they will select? A question will arise. They will. Why they will? Listen. Observation is required here to understand this chapter. This chapter is not like bacha director's concept. Just to read alternate director, additional director. That is a bacha concept. These concepts require a lot of contemplation. Lawmakers' intention must be understood. Bacha concept, directors, board of directors, managerial remuneration, bacha concepts those are. So, see here. So, what promotes for section 232 applicability if there is 233 already? Why I need to go to 232 here? If there is a fast track procedure given, listen carefully why it is. Merger or amalgamation between whom? 2 or more small companies, okay, holding company with its wholly owned subsidiaries, such other classes. As of now, such other classes are not there. First, listen carefully. So, there is one small printing mistake in this topic. This is approval of members. By mistake, it was repeated because error is human. Because of that, here and there, 1 or 2 small mistakes make up, but 99% accuracy I maintain. Okay, so please see here. Notice to ROC and OL. OL means what? Official liquidator. Okay. First, what notice? Proposed scheme of merger. Notice to whom? ROC, official liquidator. What is PABs, sir? Persons affected by the scheme. Okay. Next, purpose. What is the purpose? ROC and official liquidator. Why I have to make an application? I will provide them with the scheme of MA. They will give their objections or suggestions to the scheme. Okay. Which ROC and OL? Any ROC. Yeah. My company will be there in one jurisdiction or not? That ROC. Now question will come. Sir, one small company is in Andhra Pradesh, one small company is in Tamil Nadu. Then what to do, sir? Tamil Nadu ROC and Andhra ROC. Tamil Nadu OL, Andhra OL. To all of them you need to give the notice. Okay, they will give their objections or suggestions from both the sides. Now these objections and suggestions will be given in which form? CAA 9. Okay, within 30 days of board approval you need to have. So I repeat once again. First, merger idea comes to board of directors. Board of directors, as per section 179 subsection number 3, they have made a merger decision. That decision taken must be given as a notice to ROC and OL. In which form? CAA 9. I am coming back. From here I will be coming to this. Board approved merger scheme. In CAA 9, you need to file a notice to ROC and official liquidator, sending the scheme of merger. Purpose is to raise objections. Notice to ROC, OL and PABS. Which ROC? Jurisdictional ROCs you need to submit. Completed. ROC, official liquidator, read the total scheme. They have made their suggestions. They made 1 or 2 objections. Now, approval of members. Later, approval of creditors. Okay. Approval of members. Approval by whom? Members holding not less than 90% of the total shares. Members holding not less than 90% of the total number of shares. Total number of shares are 90% who have hold. Their approval is required to be taken. Okay. Next, in that meeting, they have to consider the objections and suggestions given by ROC and OL. Accordingly, they need to accept the scheme. Listen carefully here. Like 232, majority holding 90%, 75%, not like that. Members holding not less than 90% of the total number of shares must approve the scheme. Here. Next, approval where? At a general meeting. Tribunal will tell them no, give the notice. Tribunal will tell where to conduct. All these things will be there. Here the problem will come. TCS is there. TTCL is there. TCS is holding company to TTCL. TCS is holding company to TTCL. TCS is a holding company to TTCL means what you need to understand here. TCS, let's say for example, it is holding 100% of the capital in TTCL. Means TCS and TTCL are holding and wholly owned subsidiary. Clear? Now, both the companies members holding 90% of the total number of shares has to approve. Anyway, in this company only TCS will be there, it will be approved. In TCS, there will be around 10 lakh shareholders. Let's say more than that. Example, 10 lakh shareholders are there. Members holding not less than 90% of the total number of shares will be how much? It will be, for example, totally there are 10 lakh members. 90% of the shares are held by 7,50,000 members. 7,50,000 members has to approve to the scheme. Is it practical? Is it practical to come to general meeting? All the members holding the shares and coming to the meeting and voting there at? Impossible. 7,50,000 members attending the meeting. So where you will accommodate them, or how the hell you can get the approvals? Impossible. Therefore, lawmaker said that in such a case, go to 232 section where 90% members need not be counted. There, 232 section members, majority members holding not less than 90% of the 75% of the total share capital. That 232 will apply. That means in big listed companies, this scheme might not be adoptable, even though it is a wholly owned subsidiary. At the time, go for 232 applicability instead of 233. Later, creditors approval. And moreover, wholly owned subsidiary only one shareholder will be there. From where these concepts will come? Therefore, majority concept is deleted here. Next, creditors approval. First see this. Creditors approval. Approval by whom? Here, creditors, majority creditors holding not less than 90% in value has to approve to the scheme. Okay, approval mode in a creditors meeting. Notice should be given not less than 21 days prior to the meeting. Declaration of solvency must be filed. Means what? We are having enough liquidity. That means, listen carefully. In this kind of merger, healthy companies only can merge. Concept of liquidity, concept of declaration of solvency is not there in 232. 232 don't discuss about solvency. You may have solvency, you may become insolvent. Merger is happening. Satyam company is there, gone, but merger happened through public interest. Here only healthy companies can merge. Sir, my company is not healthy, sir. Almost it is nearing insolvency. This section does not apply. Go to 232, even if it is to small companies, even if it is holding to wholly owned. That's the beauty of section 233. So, filing by whom? By both the companies must file. Declaration of solvency CA10 file with ROC. Up to here, everyone understood. Since this is a difficult section, at every point of time I will be asking the questions. Everyone in the class understood the concept clearly. So next one. Other points on 233. From here, a big chart will come. Observation required. Bare Act we can't read all these things here. Charts will definitely help you to clear this easily. Such a big chapter, in 10 charts, chapter will be completed. And all the points were included. I didn't exclude anything. I just made charts and simplification. See here. First thing. Scheme approved by creditors, scheme approved by members. Within 7 days of that particular meeting conducted, file CA11 by transferee company to ROC, official liquidator, and central government. That means our persons accepted the scheme. File with 3 persons. ROC, official liquidator, MCA, central government. 2 situations will happen. Situation 1, listen carefully. ROC, official liquidator point of view. We submitted the adopted scheme to ROC and OL. They didn't give any communication back that there are any objections. Deemed to that he has no objection on the scheme. They communicated, but they said no objections are there. Then central government will issue a confirmation copy in form number CA 12. You both got merged together. ROC, official liquidator, communicated, but he have objections. Those objections will be communicated to central government in 30 days. What central government will do after upon communication? This concept will apply. Upon reference by ROC or OL, if central government has no objection, confirmation copy will be issued again. If central government also has objections, okay, central government has objections, inform the objections to NCLT. Now NCLT is involved. Inform its objections to NCLT, inform CA 13 within 60 days and consider the matter in accordance with section 232. I will come back to the chart once again. Confused. See here. Ide confused na. How can you read Bail Act here? From Bail Act I have simplified this. Then Bail Act how it will be? So please listen carefully. I will repeat from the beginning. ROC and official liquidator received scheme approved within 7 days of the meeting. They received it. They read the notice and they ignored that. Your ignorance will be taken as acceptance and it will be assumed that there are no objections. One point. They communicated back, but with no objections. Confirmation copy in CA 12 in both the cases. Objections are there, communicate to CG within 30 days. Okay. What CG will do, we have seen now. Okay. We have given to ROC, OL, CG. Now CG will communicate. How? CG didn't communicate, deemed as acceptance. CG communicate. Communicate by what? Upon reference by ROC or OL or sumoto. If it refers to ROC reference and has no objections, issue confirmation copy. Objections, inform NCLT within 60 days in form number CA 13 to consider the matter in accordance with 232. Now the question comes, sir, central government said NCLT consider through 232. Now NCLT will, definitely honor the given agreement of this central government. NCLT is a court. No one can order the court to do something. Court can order others to do something, but others can't order the court to do something. Therefore, central government said to inform. They use the word inform. They didn't tell order. Inform. Inform the objections to NCLT and consider the matter. Consider. Please consider. That's all. It's a pleasing. It's not ordering and demanding. It's a pleasing. Consider, please. Consider my situation. Like that we are asking. Consider under section 232. NCLT is of opinion that 232 is correct. 232 procedure will apply. NCLT is of opinion that 232 is not required. Central government, you are doing too much overaction. Small objections. We can go through 232. Go by 232. Same concept. Remaining is same. Okay. 233 subsection 8 dissolution without winding up. 239 transfer of assets. Legal proceedings to continue. Exit offer. All the things are same. Set off of authorized share capital, the fees, etc. Remaining everything is same, sir. This whole procedure is important to understand. This is section number 233. Now we completed the concept. Please, anyone, if you understood the concept, please tell me. Everyone understood the concept clearly? Okay. Next. So now we completed section number. Okay. So now we completed section number 233 as well. 236 section, as I already said, we will be discussing not here. We will be discussing along with say oppression mismanagement. Lastly, final touch I will give to 236. Okay, once you understand oppression chapter, 236 just becomes very easy. Okay, we need not again do. Question, Kunal Upadhyay, if NCLT satisfied that section 232 not required, then what? Then 233 only will be there, even if ROC, official liquidator and central government raise objections. That's the power of NCLT. NCLT is an independent body. It is not inclined to anyone. Okay? A pakkaki valani NCLT. So it will not fall to either the sides. It will not take the side of ROC. It will not take the side of government. It is an independent examining judicial or a quasi-judicial body set up under the regulations of section 10F of Indian Constitution. So therefore there is no concept regarding having dependency to the decisions of the central government. NCLT is an independent body. Ask me, I will tell. We have been many times to NCLT, the power of NCLT. What are the real powers? When we come to Insolvency Bankruptcy Code, we can understand, and soon a lecture will be on pre-packaged insolvency resolution process. Okay? So imagine how that lecture will be. Definitely we will be beyond imagination. The lawmaker's intention behind the pre-packaged insolvency resolution process, we will understand. Okay? Yeah. Next. After 236, I know I told you just now, this is a small chart only. I will explain once we completed oppression chapter. Now, everyone in the class, please get recharged again. Everyone in the class, please. We completed one important chapter, compromises, arrangements and amalgamation. Next 2 hours, we will be completing inspection, inquiry, investigation and oppression mismanagement. Once these are completed, small issues will be there, 30 minutes each and every concept. Okay, let's start with the issue. See here. Lokesh Kuraba, book reading can't give this much understanding. Thank you very much for acknowledging the efforts at least. I'm really thankful. Yeah. So see here, next topic, inspection, inquiry and investigation, section 2062, 229. Inspection, inquiry, investigation, 2062, 229. Before we start with this, we need to complete one important area called as oppression mismanagement. Oppression mismanagement section starts with yes, 241, ends with 246. Okay, ends with 246. We are into the next big chapter of our syllabus, oppression and mismanagement, the prevention of oppression and mismanagement. Once after completion of this, inspection, inquiry, investigation. Okay, so the time is now 11:06. Okay, but time is now 11:06. Exactly by 12:10 I will be completing this. Okay, 12:45 like that we will have a break. That means half the investigation chapter also I will complete. Half the investigation chapter also I will complete. Just another half like this. 20 minutes will be left. We'll be completing after that small areas. 20 minutes, 15 minutes. These companies like dormant will be there. 10 minutes. Government, 5 minutes. Foreign, 15 minutes, 15 to 20 minutes max. Like that every chapter will be completing. Believe me, I will strive my maximum efforts to complete all the topics. Okay? See here. Meaning of various terms. See here. Oppression and mismanagement. First thing, we are going to deal with a topic called as prevention of oppression and mismanagement. Okay? Prevention of oppression and mismanagement. First, let us understand what is the concept of oppression. Surprisingly, the word oppression is not defined anywhere in the Companies Act. It should be understood from the facts and circumstances of each and every case. That means this is oppression. Like that, there is no section 2 definition. There is no explanation anywhere in the chapter. From the case studies, we need to capture them. That's why each and every case, on the basis of case studies, we need to get the answer. Some cases are there which everyone must write in the examination. I repeat once again. In the suggested answers given by the institute, whenever a oppression question comes for more than 5 marks, 5 or more than 5, institute will first write what is oppression. What we need to write? The term oppression is not defined anywhere in the Companies Act, point 1. Oppression must be understood from the facts and circumstances of each and every individual case. Third one, as per needle industries case, oppression includes acts which are burdensome, harsh and wrongful. Burdensome, harsh and wrongful. I repeat, burdensome, harsh and wrongful. So, it is a burdensome to the members, or harsh towards the members, or wrongful towards the members. In such a case, they can put a oppression complaint. Shanti Prasad Jain versus Kalinga Tubes Limited case, the term oppression includes lack of minimum respect, probity, and lack of fair dealings. Like a human being also, you are not treating us. Lack of probity, lack of fair dealings. Elder versus Elder and Watson Limited case said that the term oppression includes intent to do fraud or actual fraud, misfeasance or other misconduct. You have to remember this chart as it is to get 6 out of 6 in exam. You have to write this. For this he will give 2 marks. After that you need to write the answer for the question given in the exam. Okay, first let us understand one concept. Why this chapter came into existence? Let me explain the idea behind just in 2 to 5 minutes. There is a case called as Foss versus Herb Bottle. A case has happened. Foss versus Herb Bottle, not water bottle, Herb Bottle. Foss versus Herb Bottle case law. Okay, very old, 100 years before case, but still it's a landmark judgment on oppressions. So see here. Generally, in a company, not in company, in the whole world will be running on the basis of majority. Means what? Example sake. There are 500 students attending the class. All the 500 are listening to the session. After the session is completed, 1 day or 5 days or 10 days session completed, randomly 2-3 persons went to the management and said, classes are very bad, we can't listen, we can't understandable, it is not understandable, it is irrelevant. Like that some people made a complaint. Will management take an action against the faculty? No. When 500 students are there, 2-3 persons making complaint means you are different from the others. Okay, the faculty is not. Therefore, what is missing here? Majority dissatisfaction is missing. Okay, therefore what the management will tell, if half the class comes and tell me, or majority of the students tell me, at least I can consider it. 1 or 2 students in 500 students complaining means what action I have to take? Are you understanding or not? Intentionally some people may put there. Intentionally some people may put a complaint. Everyone need not like me. Yes or no? Everyone need not like me. So intentionally they may put a complaint against me. So anything can happen. It is not just one single reason that play a role. Are you understanding the concept? Example, for example, let us take Mr. Satyam is there, Kadime Satyam. He like Lord Rama. Okay. Sharat Meghna K is there. She is liking some other god, Lord Shiva. And some other person is liking another god. Each and every person is not liking the same god. I am a human being. Everyone need not like me. So, 1 or 2 persons making a complaint, why you will take action against me? That's what the court observed. Therefore, complaint of 1 or 2 we will not accept. In that case, concept of majority rule came into existence. But problem started then. Now the real story starts. Zoom the camera to the majority rule. Okay. So the screen, majority rule. Babu, ready Babu? Start camera. Action. So now what happened? Jai and Etherdin. Majority rule concept. What happened? Let me explain. Majority rule concept, how much great it is, that much equally disadvantageous it is. Why? You are shouting about the concept of a majority rule. Okay? Concept of majority rule cannot be denied. But there is a disadvantage of majority rule. What is the disadvantage? In a company, majority represents not, I repeat, in company, majority represents capital majority, not number majority. Did you understand? So it's a number majority, a capital majority, a capital. Means what? 1000 members are there. Voting will be done on the basis of your shareholding. One share, one vote concept is the idea of the Companies Act, not one member, one vote. One member, one vote only in show of hands, but generally show of hands is not taken. Electronic voting, postal ballot, direct voting system by poll method. In all these cases, voting will be done on the basis of number of shares with you. I have 10 lakh shares, but I am only one person, but I can have 10 lakh votes. That means, listen carefully. Problem comes with the capital majority in Companies Act. There are, I will be repeating, there are so many students sitting in the class. 500 students are sitting. In the first row, 5 persons are there. Let's say in class also shareholding concept is there. Or in a meeting, in a general meeting, I am Mukesh Ambani. My family members are sitting on the first row. They are holding 70% of the capital. There are 7,000, 10,000 shareholders are sitting at the back. All of them are holding 30%. Now what will happen? What is the situation? What will happen now? Now the problem what comes is, first 5 persons who are my relatives, I will tell, you approve everything. Then they will raise the hand. Okay, I will tell, we are going for liquidation of company. Special resolution required. You people raise the hand. They raise the hand. That's all. Liquidation process start. All the other 10,000 members are saying like this. Who approved here? Your family members, your parents will approve and you will tell that scheme is approved. Majority la this problem is coming. In Companies Act, majority is the boon as well as a bane. It's a boon and sin on both the sides. It is very sharp knife. The time when we tell that majority rule is there, 1 or 2 persons can't file a complaint against the company and ruin its future. On the other hand, majority does not represent number majority, it is a capital majority, shares majority, which is again destructive. Therefore, 1 or 2 persons can't file a complaint, majority rule came. Using that majority rule, some are trying to disturb the other persons, oppression chapter came. That's how the concept of oppression came. When the majority, by its majority shareholding, tries to deny the decisions of minority, they will file a complaint to the tribunal saying that this majority is misusing their powers. That's concept of oppression started in Companies Act. Okay, so this is the basic idea behind this particular concept. Hope everyone understood the concept clearly up to here. Okay, yeah, see here, everyone in the class. So if there are any doubts whether this video will be available always or deleted, it will be available. I told already. Next, yes, voting is based on economic strength. Yes, it will be available. Yes, Manikanta, Jai Balaya. Jai Balaya. See here. So majority rule concept, hope everyone understood very clearly now. Yeah? Now let us understand the concept. From there, the concept of oppression started. Okay, see here. As per Needle Industries case, the term oppression includes acts which are burdensome, harsh and wrongful, lack of probity, lack of fair dealings. Either fraud is involved or intent to fraud is involved, misfeasance is there, other misconduct is there. In all these cases, we can call it as an oppression. This is on a case-to-case basis. These 3 points you need to write in examination. Mismanagement means what? One line answer. Mismanagement, using management powers or abusing abusive. Abuse of management powers. Completed. Now we are going to start with the section 241. This will take some time. Okay, this will take the lion's share of this chapter will be taken by this. After this, just like that, we will complete the remaining concepts. Please show some importance in this concept. Okay, amendment happened in the previous attempt, so please show some importance. First, basic complaint. What is the section we are reading? Shareholders are making complaint to the tribunal for relief against the oppression, etc. So let us see. Basic complaint. Complaint by whom? Member making a complaint. To whom? NCLT under section 244. What is that? We will see. Member making a complaint to NCLT. Reason for making complaint. Very important. Existing affairs, futuristic affairs. If you see the original Bail Act, section number 240, section number 241, subsection number 1, clause number A, they will tell that the affairs of the company have been or are being conducted in a manner prejudicial to the public interest or interest of the company, or to any member or members are prejudicial to the interest of the company. Like that they will tell. Next one is change in the management, change in the shareholding. I simplified that in the chart. Read this. Reasons for making a complaint. Members made a complaint to NCLT that the affairs of the company have been or are being conducted in a manner prejudicial, means against to the public interest, or to the interest of the members, or to the interest of the applicant member, or to the interest of the company. Okay, that means the affairs which are going on in the company are against to the company total. Okay, that's a point number one. This is going on. Sir, affairs are going on wrong, please take an action. Second one is very, very important here. Futuristic affairs will make a complaint today itself. Okay, what is that? Let us try to understand. See here. There is a material change. There is a material change. Material means significant change is there. Significant change has taken place in what? It can take place in the management. It can take place in the control. To be clear, it can take place in the board of directors. It can take place in the shareholding control. Okay. Management means what is taken place? Change in the board of directors, change in the manager. Any two things can happen. Manager means board of directors, it includes managing director here. Manager need not be a director kada. Therefore, or by change in manager. By reason of such a change, it is likely that the affairs of the company will be conducted in a manner prejudicial to the interests of the company or its members. Hope everyone understood up to here, but still, I will open this chart for you to read once before we start. Just a minute time, not more than that. Okay, just a minute time. Every one of you concentrate and read this. Read both the concepts just for a minute. Give a glance, because it should not be like me reading and going. You should first read, after that I will put explanation. So completed. Now let us go into the explanation part. Sir, I put that screen just for a reason that you should not lose the track at any point. See here, this is very important provision. I will explain. See here. First, complaint is made by member that there is an oppression. Okay, listen. Here two things are there. Affairs are done leading to oppression. Oppression is like, I repeat, oppression is similar to that of pain on the face. Affair is slapping on the face. Slapping happened, after that pain starts. I will make a complaint to the court. I will make a complaint in the police station that a person has hit me. When you have to make a complaint? At that time when there is some evidence that a person has slapped you. He slapped you after 5 years, you made a complaint in the police station. 5 years back this person slapped me. It will not take. Directly pain will not come. One person has to beat you, because of that you got the pain. beating is an affair, oppression is the pain. Now the shareholders are making a complaint that there is a pain in the affairs of the company. That pain happened because of existing affairs. That's the idea. Okay? That's the idea of the section is, they are doing existing affairs. Because of it, we are having oppression. The main point is, affairs may be happened in the past, but pain should be there on the date of making application. Very, very important case law. It was asked around 5 to 6 times in exam. Oppression should be present and continuous. Affairs which resulted in oppression may not be present. You need not go to NCLT after making application. At the time of making application, you should not ask that person, beat me now. See, he beat me, therefore make a complaint. Like that, you need not. That affair may be conducted in the past, but the result of that affair is an oppression that should be present and continuous. Okay, here affairs of the company have been. Past is referred to affairs. Oppression of the company have been illa. Oppression should be always present and continuous. So the affairs of the company have been, are being conducted, going on conducting in a manner prejudicial to the public interest of the company, applicant, or the interest of the company, whatever the case may be. This is easy. Very, very important. Futuristic affairs. Now the company is having, sir, I will give one classic example. Listen. You joined a course, CA course. Let's say it is law. Okay? Let's say it is law. Now listen. There are two institutes, Institute A and Institute B. Let's say for example, there are two institutes here. Institute A, Institute B. Institute A is ethical, Institute B is unethical. Let's say for example, okay? Now listen. One is ethical, another one is unethical. Institute A is there. Now listen carefully. Here, Mr. X will teach a subject, any subject. X is very, very popular. Okay, you announced his name. Public saw that, they paid fee. Students saw the name, they paid fee, they attended the class. 2 days okay, 3 days okay, 10 days okay. 11th day, they announced that we are changing faculty from Mr. X to Mr. Y. Will the people accept? Will the people accept? First thing, protest starts. What protest? Arey, X is very good here, why you are changing him? Don't change him. Like that, the complaints will start against that particular A. Means what you have understood here, till now the subject is being managed by X, now the hands are shifted to Mr. Y. We don't know how Y will teach, therefore we presume that Y is bad. But Y may also be good than X, but our mind will not take it. X is already teaching well, why you are substituting with Y? On this, now tell me, X is substituted with Y. Can you give a guarantee that Y is bad? No, Y may be better than X, but likely that Y may be bad. That's why the word likely will be used in next provision. Futuristic. Really oppression didn't happen, but we have a doubt that oppression can happen. On that futuristic doubt, you can put a complaint today itself. The day on which it really happened, tribunal will jump and catch the person. That's here. Second one. I joined Institute A. I joined Institute A where X teaches. Okay. Now X is there. X teacher is there. A coaching center is acquired by B. Did you understand? A coaching center was acquired by B. What will happen if the acquisition happened? An unethical institute will take an ethical institute. They will hike the fee. Now the shareholding shifted. Both are dangerous. After acquisition by B, B may become ethical, but we don't know because he has an unethical background. Therefore, whenever there is an unnecessary change in the management or unnecessary change in the control, by reason of such change, it is likely that the affairs may be conducted prejudicial to the interest of the members. Upon futuristic doubt, make a complaint today itself. This is the idea behind this particular section. Everyone understood the concept or not up to here? Please tell me. Everyone in the class, please confirm. Understood the point up to here, everyone? Okay. Okay. Thank you. So let's continue. So that is the basic idea behind this area. Up to here we completed. This is a amendment portion. Not recent, logically recent past. I am not telling exactly this attempt amendment. Very recent past. 2 attempts back this amendment came, but not tested in exam. Therefore every chance is there. It can be important. Now the question is on what is the point. Listen. Mismanagement will be done by artificial person like company. Company is an artificial person here. Company will not do any wrong. Company will be made to do wrong by natural persons inside called as directors and shareholders. Therefore, exactly that point we have to focus now. Some directors of the company are trying to, I repeat, some directors of the company are trying to, I repeat, some directors of the company are trying to do mismanagement in the company. Now, tribunal will involve and check whether this person is correct to continue as a director or not, or else remove him from the directorship. On that a new amendment was made. Look at the scenario. CG reference to NCLT. If in the opinion of CG, I repeat, if in the opinion of CG, affairs of the company are prejudicial to public interest, then CG may apply to NCLT. Sir, what is this point? CG cannot take the oppression complaint. Oppression is such a complaint where NCLT only have powers under Companies Act. If CG comes to know that there is an oppression, CG will tell NCLT, take this complaint. Okay, take this complaint and continue the oppression situation. Next, CG reference to NCLT to initiate inquiry, amendment portion. CG reference to NCLT. CG is of a opinion that 4 things will be there, you need to remember. Any person connected with management, that's why I said mismanagement, is guilty of fraud, misfeasance, persistent negligence, continuous negligence, breach of trust. I repeat, person connected with management has done any of these 4. Okay, person connected with management, I am talking about individuals. Next, managing directors, managers, whole time director, they have to carry on the business or not? Business is not carried on by sound business principles and prudent commercial practices. Who is doing that? That person. Against that person, we will initiate inquiry and check whether that person is capable to continue as an MD or not. Or third one, affairs of the company are managed in a manner, again managed. Again here also business management. Affairs of the company are managed in a manner which causes serious injury to the industry to which company pertains. Like Satyam company. Satyam company does mismanagement. Because of that, defame only to Satyam, entire software industry. If that be the case, before it happens, take action against them. That's why the name of the chapter is Prevention of Oppression and Mismanagement, not Curing of Oppression and Mismanagement. Prevent before it occurs. Okay. So I repeat, central government conducted investigation on a company. During the course of investigation, central government came to know that some persons inside the company are guilty of fraud. It will ask tribunal whether this person is capable to continue or not. Okay, tribunal will conduct inquiry, etc. And business is carried on not in sound business practices. Next, injury is caused to the entire industry because of this company in such a case, or business is conducted for a fraudulent or defraud the creditors, etc. In all these cases, central government will tell NCLT, I am doing investigation now. In the investigation, I came to know that there is a company. That company, the management is not proper. Some persons are doing mismanagement. You go and conduct an inquiry and give me a report whether that person is capable to continue as a director or not. If you tell no, we will remove him from the directorship. That's the idea. Okay? New point. Now we completed section number 241. Section number 241. Observation number 2. Powers of tribunal. Section number 242. Section number 242. Listen, big section, easy concept. Big, easy. Both are there on the same set. See here. Powers of tribunal. This we will keep it aside. We will read once after these 2 sections. See here. Connected provisions. We now thought that members will make a complaint to the tribunal against oppression mismanagement. Okay. So let us see how much capital is required with that member. Capacity to make application. Member has to make. Requisite strength. Okay. Requisite strength. depending on the type of company. If the company is having share capital 100 members or 1/10 of the total number of members, whichever is lower. If the company is having share capital or members holding not less than 1/10 of issued share capital. I repeat, if the company is having a share capital 100 members or 1/10 of the total number of members, whichever is lower. If the company is having share capital either this or this, members holding not less than 1/10 of the issued share capital. Okay, sir, what is the difference between first and second? In the first one we need to take whichever is lower. Okay, whichever is lower, here members are considered, not the capital. Members, 100 members, 1/10 of the total number of members. Capital is not considered. Second place capital is considered. Members holding not less than 1/10 of the issued share capital. Any of these two, first they should make a complaint to tribunal. Sir, my company don't have share capital, not less than 1/5 of the total number of members. Will make a complaint to the tribunal. This is 244 section. Okay, 244 section requisite members will make a complaint under 241 that the affairs have been or being conducted. Okay, actually first this section will come, but in a sequence we have to go now. That's why 241, 244. Applicants not disqualified. That means the members who are making complaint against oppression, first they should be disciplined. They should not have any arrears of calls. They should have paid all the calls. You didn't pay any calls properly. You are filing complaint against company that it is oppressive, overaction. First you rectify yourself. Next, joint members will be treated as single member. That means in this 100 members, one share is held by 30 persons. We are 30 members, you should not tell. You are only one member. Okay. Next, representative petition. For example, if there are 100 members, 100 members want to come, 100 applications you need not put to NCLT. One representative will stand. He will be the leader of the group. That person will take a paper, collect the signatures of all the 100, submit to NCLT. Representation is possible. Special powers of tribunal. Very, very important concepts. Please listen carefully. Please listen carefully. Special powers of tribunal. Listen. What are the special powers of tribunal? My company, 98 members made a complaint to the tribunal that there is an oppression. Okay. Now tell me, members holding not less than 1/10 of the issued share capital come to 105 members. 1/10 came to 5,000 members. Now, I don't want to go to this route. I want to go by this route. 5,000 or 98, 100, whichever is lower, 100. But only 98 made an application. Application acceptable or non-acceptable? It may be accepted by tribunal even though requisite strength is not there. Why? 98, 99 are making complaint. 100 you will accept, 99 you will not accept. Unreasonable here. Be justified. Therefore, small technical snags are there. No problem. Tribunal will accept your application. That means 100 is not a strict number. It can be 98, 99, 97 like that. Am I clear? Many students in CA will get 40 marks, exactly 200. In all cases, institute will throw a mark and add. And it is real. The software will do that automatically. Provided you qualify in all the subjects. Provided you pass in all the subjects. In any one subject you got 39. Because of that you got 198, 199 like that. Generally the software what it will do, it will add another mark and pass you. That's why whenever we get 40, we will be on the borders. 201, 202 like that. Because just because of that one mark, I should not fail you. That's why whenever we get 40 and qualify, it is an indication that the software added one mark. Okay. Now on this you need not put any comments on YouTube. Oh, sir, I qualified normally, only my friend qualified. Just telling you that it is a real fact. Okay. So that's the idea. Sir, everyone understood the logic up to here clearly? So these are all the special powers of the tribunal. So special powers of the tribunal. Tribunal has special power to waive majority requirement and not others. Only majority requirement it can waive. Other requirements you have to mandatorily follow at any cost. Hope everyone understood this particular logic as well. So please everyone tell me understood the concept. Before that, one last point. Member include both equity and preference. Capital is issued capital. It's not par, it's not paid, it's not market value. And sir, 100 members, 1/10 of the total number. When I should count? You have to count that. You have to recount that as on the date of application. As on the date of application. So on the date of application, that means as on the date of application, 100 members are there. Yes. After that, some members who gave approval, if they leave the company, no problem. Okay. Still application is acceptable. This is the end of section 244. Everyone in the class, please tell yes for this. If you understand, I will be going into the next area. Everyone, please give me a reply. Everyone participating, please give one reply. Sir, I told you, I am one person sitting here in my house and recording. Please, everyone. So you people has to react for me to continue at least. I think you can understand the problem. One person shouting for 10 hours here. It's not that easy, na? So thank you very much. Next, let us continue with another section, 246. Okay, 246. 246 is a very small section. What it says is, in one line I will complete. Whenever any complaint comes on oppression to NCLT, NCLT will conduct a inquiry side. It will know whether really oppression is there or not. It will check whether really oppression is there or not. Really oppression is there. Then on the persons who are creating oppression, what penalty I need to levy? At the time of winding up, in the winding up chapter, there are some penalties. Those penalties will apply, but subject to one condition, that institute has deleted those penalty sections of winding up from syllabus. Therefore, this section can never be asked in examination. Though they are in the syllabus, what you have to write? Penalties at the time of winding up will apply. Because section 339, 340, 341, 342 are the penalties. Those are not applicable for exam. Therefore, it has no room to ask the question in examination. Therefore, just remember, at the time of oppression mismanagement, if tribunal came to know about any fraud or mismanagement done by director, what it can do at the maximum? It can levy penalty. That's all. What penalty? Not normal penalties here. Winding up time penalties are there, those will be applied. Now question will arise, sir, why at the time of winding up those penalties are applied here? Question will come. That I will answer in a while. Just in 1.5 minutes I will explain you that after completion of 242. Now listen carefully. Important means it is very, very important. Please show some importance while listening itself. Okay, see here. Powers of tribunal. You made an application. A member made an application to tribunal against the oppression. You make an application. Okay. Tribunal has to form an opinion that application you filed is a genuine petition. Means what? Means what? Listen carefully. You are a member. You made a complaint against a company that there is oppression or a mismanagement to me, and you made a complaint. What you said? Affairs of the company have been or being conducted in a manner prejudicial to public interest, interest of the company, interest of the members, something you said. First, I should believe that those are in existence. You are a member. I am NCLT. You made a complaint that there are oppression, etc. Affairs have been, like that you said. I put the application, I saw the application, I saw the complaint, and I decided that there is nothing like that. Now I ignored that. That means just because of the reason that 100 members or 1/10 of the total number of members made an application to tribunal does not mean that tribunal shall accept the application. It is again subjective decision of tribunal whether to accept an application or not. Did you understand my logic? Whether to accept oppression complaint or not is a subjective decision of the tribunal again. You can't force tribunal. 100 members filed a complaint, you should definitely take an action. Then in Reliance India Limited, 100 members means how much? Little amount here. Every person will make a complaint in NCLT. You should not just make a complaint telling that affairs are against public interest, affairs are against company, affairs are against members. Making complaint is not enough. Tribunal shall form an opinion that affairs have been or are being conducted in a manner prejudicial of public interest, members' interest of the company. It should also feel that, it should also form an opinion that really the complaints are in existence. Really complaints are in existence. Now I will ask every one of you, please listen carefully. You should answer. Okay? You should answer. You should answer. There is a company. Against that company, one person made a complaint. One person means group of persons. I mean, 100 members are required. 100 members made a complaint. Made a complaint to the NCLT that a particular company is doing mismanagement. A particular company is doing mismanagement or oppression. Something is going on in a company. Okay? Now, tribunal should also feel that the complaint what you made is genuine. Or else why I will take action against some company, then they will file complaint against tribunal in the Supreme Court of India that it is exceeding its powers. Then over action will be the turn of tribunal, which should never happen. Therefore, tribunal will be on a safe hands always. It should take care. Therefore, what tribunal will do? Babu, you made complaint. Let me check. I will come for an inquiry and I will then confirm whether this is a genuine petition or not. It come to the company. After 4 or 5 months or after 20 days or after 30 days, after 1 month, tribunal has given a order saying that the affairs of company are prejudicial to the interest of public interest, you said. Yes, really that is in existence. Any of the four should be in existence. Sir, public interest, members, company, all need not be there. Any one should be there. You made a complaint that, you as a member made a complaint that affairs are prejudicial to public interest. Tribunal also felt that affairs are prejudicial to public interest. Now the action will be taken or not? Everyone answer this. If it is also forming an opinion, that affairs are in existence, will it take a action or not? Waiting for your answer. Sir, we are not telling any story here. Please participate like a normal class. It's your career, it's your future, it's your exams. Please participate, and I am not reading and going, you know that. Yes. So, can it take an action against if it also satisfied that the affairs of the company are against to the interests? Can it start taking an action? Yes, it can start taking an action. Is a wrong answer. It cannot. Along with that end is there, that to wind up the company would unfairly prejudice such member or members, but that otherwise the facts would justify passing the winding up orders. What a beautiful language he has used in the Bail Act. Bail Act as it is, I kept here, not to dilute the idea of the law. Okay? Answer is no. Mamata alti, not mandatory. Not mandatory is not the answer. It cannot. It cannot. Why? Let's try to understand. Praveen Kohli, sir, FTP class. FTP hai. What FTP? Sneha M may or may not. May or may not is also wrong answer, madam. It cannot. It cannot. Why FTP class you are asking me, Praveen Kohli? FTP is in indirect taxes. You are talking about foreign trade policy. Why foreign trade policy will be there in corporate and economic class here? Unnat jappadaniki gontu noppi vastundi. FTP is not in my subject there. Okay, see here. Point is, just believing that these are in existence also will not consider an oppression. Winding up. Sir, what winding up, sir? Suddenly, why winding up is coming? Listen carefully. Member going to, sir, everyone please listen to the screenplay properly. Members went to tribunal and made a complaint. Made a complaint against the company. Saying what? The decisions of the company or affairs of the company are prejudicial to interests of the company. Something they said. Tribunal thought that yes, really it is against. Immediately it can't tell oppression complaint taken. So you should take an action under section 242. No. Intensity, the gravity of oppression should be considered. What is the gravity, the intensity of oppression? How much oppressive the acts are? one time oppressive or two times oppressive or continuously oppression is caused in the company, that oppression should have a gravity, it should have intensity. Okay, are you understanding or not? It should have a blow on the face of company. So the oppression should be so intense that I want to wind up the company. Winding up of company cannot be a good idea always, because already I told you about Satyam case. I am telling directors of the company are doing oppression or mismanagement. Why you are winding up company? Tribunal is telling that I am not winding up company. Complaint you give me should be having so intensity that it should give me a feel to wind up the company, but winding up is not the idea. That means it should be so intense that in reality I want to kill the company, but killing the company will disturb the members and other persons. Just by seeing their faces, I am not killing this company. Technically, in another way, which I generally give the example, I will tell you, dust comes and fall into the eyeball. Dust comes and fall on the eyeball. What you will do? You will totally take the eyeball out. When dust falls on the eyeball, it irritates like anything. Okay, how much irritation it will create? Intensity of irritation will be in such a way that I want to pop the eyeball out. But popping the eyeball out is not the idea. You have to throw the dust out. But situation is in such a way that I want to, the irritation levels are in such a way that I want to take it out. But taking out is not the right idea. In the same way, in Telugu, kantlo nalsu perte, kannu pekadam daniki remedy kaadu. So, therefore, in the same way, even here, winding up intensity is there. But it is unfair if I wind up the company. Like that, the intensity of your application should be. If both are satisfied, tribunal will take an action against the company. That's the idea. Everyone understood the idea clearly? Everyone in the class understood the concept clearly now? Okay. So, the severity will be considered by the tribunal. Okay, everyone in the class, please give a reply. Everyone understood the intensity of that section at least? Everyone, intensity of the tribunal, okay. Intensity of the section, okay. So, okay then. Thank you very much. Thank you. Amrit Devi, thank you. K. Bhargav, Pavan Chinchu, Aruna, Meghna K. Pooja Jaiswal, Chandu Venkat, Sumasri, Jahnavi, Mr. Yam, Mamata Alti, Samir. Intensity of winding up must be there. So thank you very much everyone for replying, for putting the class engaged. Thank you very much. Sir, also inform your friends to participate in the class. More and more participation, automatically it will reach most of the persons. Okay. Your intensity, my intensity will never reduce here. I'm Koushik Mukhesh. Okay. So, sorry. Anyway, let us start with the concept. So, the intensity, you make application, winding up intensity must be there. The intensity should match the winding up level. It should not be just a complaint type. Okay. Sorry. Sir, if intensity also there, what tribunal will do? Freedom will be taken. What freedom will be taken? Your resolutions in your company, sir, in a company, oppression decisions means what? Resolutions will be passed against to the wishes of minority. Therefore, regulate the conduct of affairs. That means, in your company from today, any resolution is passed, before it comes into force, first tribunal has to approve that. You lost the freedom to pass independent resolutions. Action number 1. Action number 2. Just now I told you, dust fall on the eye. Eyeball removing is the idea, or dust removing is the remedy. Dust removing. If any members are causing oppression, purchase their shares, either by existing member or by the company. Okay. If existing members purchased, if company purchase resulted in reduction of share capital, if existing member purchase, he should not again retransfer that shares to other. Completed. Now, oppression 4 actions. Regulate the resolutions, purchase, company purchase reduction, other member purchase shares means restriction to retransfer back to the same person. From now, mismanagement actions will come. Mismanagement means persons in the management will be controlled. Okay? Listen now. managing director or a director, he comes into company by an agreement. In the agreement, they will tell terms and conditions, remuneration, all these things will be decided in this agreement that is being drafted. Terms are there. Your tenure will be 4 years, they said. Monthly you will get 2 lakh rupees subjected to section 197 and schedule 5. Like that, some terms and conditions are there. Mismanagement is done by directors. Now the tribunal will alter these agreements, modify, totally cancel the agreement or modify or set aside. Set aside means temporary suspension. Okay. See here. Termination, totally take it. Modification, make the changes. Setting aside, temporary suspension of the agreements between company and MD. Sir, management means only company MD, sir. KMP will also be there, sir. Other officers also will be there, sir. Next point, those are only covered, sir. Tribunal ఎవరిని వదలదు. Okay, tribunal will not leave anyone. Tribunal ఎవ్వడికి లొంగదు. ట్రిబ్యునల్ ఎవ్వడికి చుట్టం కాదు. టెక్నికల్లీ చట్టం ఎవరికి చుట్టం కాదు. పంచి డైలాగ్ ఇది. సో ట్రిబ్యునల్ ఈజ్ నాట్ ఎ రిలేటివ్ టు ఎనీవన్. ఓకే, ఇట్స్ ఇండిపెండెంట్ బాడీ. ఎండి డైరెక్టర్ మీదే యాక్షన్ తీసుకుంటే నువ్వెవడి అసలు మధ్యలో ఎవడా నువ్వు అని అంటుంది ట్రిబ్యునల్. సో termination and modification or setting aside agreements between company and others. Okay, others other than directors, other persons are there. Setting aside a fraudulent preference. I can't explain this now. This is IPCC syllabus, fraudulent preference, and in winding up chapter it will come at some place. I will tell you what is fraudulent preference at very much IBC concept. It will come anyway. Fraudulent transactions, preferential transactions, at that time you can listen. As of now, fraudulent preference, remember, this is the only thing which I ask you, remember as of now. Okay, so listen, let me revise everything. First member made a complaint, grounds shown, satisfaction of grounds plus winding up intensity should be there. Oppression complaint lo 4 actions: regulate the affairs, purchase of the shares by the company or by member, restriction on transfer, completed. Termination or modification or setting aside of agreement between company, MD and director or any other person. Setting aside fraudulent preference. Not only termination of terms and conditions, sometimes tribunal can also remove the managing director, remove the manager, remove any other director, remove any other person. It can remove. So removal happened, vacancy created. What to do? Appointment of the directors in place, those who are removed. Directors will be appointed. Removal made by whom? NCLT. Appointment made by whom? NCLT. Now he will be rotational director, non-rotational director, decided by tribunal. That's why in section number 152, subsection number 6, clause number A, subclause number 1, he will tell that rotational director means those directors as save as otherwise provided in this act. If anywhere in the act it was said that rotational director is appointed in some other way, follow that. Or else generally general meeting will appoint rotational directors. Okay. Linking. Removal of managing director, manager or any other director. Clear everyone in the class? Okay. Now listen carefully. So removal of a managing director, manager or any other director. Now everyone, just because revision sessions will be heard by those who already completed coaching. This is a revision. Now tell me, tribunal appointed director. Tribunal appointed director can be removed or cannot be removed? Directors appointed by tribunal under section number 242 can be removed or cannot be removed? I want an answer everyone. Linking section. Section number 242 linked with 169. Arey answer yaar. Tribunal appointed under 242, can he be removed? Cannot be removed. Yes. So a person who is a director who is appointed by tribunal cannot be removed is a wrong answer to the core. He cannot be removed by the shareholders under 169. Tribunal can remove him. Everyone is giving wrong answers. Rectify first. Everyone is giving wrong answer. Rectify. Can be removed, can be removed, can be removed, cannot be removed by shareholders under 169. It can be removed by a tribunal. Vinandi cheppedi. You are not listening. Still some persons are telling cannot be removed. It can be removed. It can be removed by tribunal. It cannot be removed by members under 169. Okay? Can be removed. Tribunal appointed executive, if tribunal can't remove, it's an insult on the face of tribunal. Thupuk. Tribunal appointing person can't be removed by tribunal. Thupuk thupuk. Okay? Everyone understood? Okay? డైరెక్టర్స్ మొదలు పెట్టడం అనవసరం అని దీనిలోకి వచ్చా. డైరెక్టర్స్ చెప్పడం రాక మాత్రం కాదు. ఓకే, కత్తి పట్టుకుంటే నాలా ఎవడు వాడలేడు. సేమ్ డైలాగ్, సేమ్ విత్ డైరెక్టర్స్. సిన్స్ స్టూడెంట్స్ ఆర్ ఫీలింగ్ డిఫికల్ట్ విత్ దీస్ ఏరియాస్, ఐ స్టార్టెడ్ విత్ దిస్. ఓకే, సో because of various personal reasons, even though student put some comments, I was silent and I was away from YouTube due to many personal reasons. Okay, understood? So నేను కాన్సన్ట్రేట్ చేస్తే ఎలా ఉంటుందో చూపిస్తా ఈసారి. If I concentrate really, how it will be, let me show. Another 2 months to go కదా, I will show. So, due to many good reasons, because of my office work, I have around 123 NCLT cases pending for my clients. So just because of that good reason, students will not understand all these things. They will put comments I will not even take for granted, because their exams are there. They will be feeling frustrated sometimes. Yes, I know that, but still, I just didn't concentrate because of many good reasons, better known to me. Okay, so listen carefully. So, special powers of a tribunal. Sir, these are powers beyond the special powers also there are, sir. Special powers untayi mari, that is NCLT. Special powers will be there. So what special powers will be there? Let's try to concentrate and understand. So see here, what is the name of chapter? Prevention of oppression mismanagement. Where is the prevention here? I made a complaint that there are some activities going on. You thought the intensity is equal to winding up. Then you are taking all these actions. Where is prevention? Nen complaint cheste action తీసుకుంటున్నావు. If I make complaint, you are taking an action. Okay? Upon my complaint, you are taking an action. You are not voluntarily sumoto. Before it happens, you are not coming to me. Then where is prevention here? Where is the justification to the word prevention? There is no justification to the term prevention here. Are you understanding or not? So the main point is, there is no justification for prevention here. It is only cure. After happening, you are taking an action. Then where is the justification to the term prevention of oppression mismanagement? You kept this much heading prevention. Where is prevention here? Everything is a curable defects. Where is prevention? Therefore prevention is there. What he is telling, you make me a complaint on oppression. Now I will prevent that company from futuristic oppression. What to do? Listen carefully. Mismanagement happened. Mismanagement. Observe the words. Mismanagement. Management is abused. Who is management? Directors. Directors are abusing their powers. Directors are getting powers from what? From articles and memorandum. Section number 179, subsection number 1. The board of directors of the company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. While exercising such power or doing such act or thing, the board shall be subject to the provisions contained in this behalf in this act, memorandum, articles, or resolution passed by the company in a general meeting or resolution passed by the company in a board meeting. This is what said in section number 179, subsection number 1 and 179, subsection number 1, proviso number 1. So these are the 2 points said in section number 179 of the Companies Act. Means what? Directors can do what company can do. Company can do what is there in the memorandum objects clause. That means from articles and memorandum, directors derives the powers. Okay? From articles and memorandum, directors derive the powers. Origin is articles and memorandum. End result is directors exercising the powers. If I alter that articles and memorandum, how it will be? That's the special powers of prevention. Tribunal has a power to alter MOA and AOA, and once altered, it cannot be re-altered by the company, except in following two cases: permitted by tribunal or permitted to the extent tribunal permitted you. Okay, alteration will have same effect as if alteration is made by shareholders in a general meeting. Tribunal copy will be filed with ROC within 30 days and reference will be given. This is all small points. These are the main issues which we need to cover in section number 242. Next, sir, in this chapter, these are the sections. 241 we completed, 242 just now we completed, 243 we need to start, 244 we completed, 245 hold on. Now I am not going to discuss class actions. There is a separate place to deal. 246 penalties during winding up. Penalties during winding up. Why question is there na? Always whenever you make complaint during oppression, it should match intensity of winding up. Therefore, penalties at the time of winding up will be levied. That is the idea of law. I want a reply from you. Did you understand this logic? Winding up time la what penalties are there that will be applied. Why? What could be the good reason? Because intensity matches to winding up. Hope you felt the concept, not understood, felt. You experienced a new way of understanding this. Okay? So, therefore, this is the main concept that everyone has to understand. Why winding up related penalties are given? So, the only intention is the idea of law is something different. Okay? It want to match the penalties of winding up because intensity matches with winding up. Yeah. Okay. So, thank you. Let's start. So, 246 we completed, 241 completed, 242 completed, 244 completed, 245 anyway separate set of discussion, class actions, because after some concepts we can understand class actions correctly. 243 talks of what? 243 talks of what? Listen, just 1 minute answer, sir. Agreements between company and directors are modified, terminated or set aside by tribunal. For other members also like that. Array, company said that I will be appointed for 4 years. Who the hell the tribunal is to breach the agreement? I want compensation. Tribunal is telling, chesinde adopani. Work done itself is useless work. And you are asking compensation. Malli compensation adugutunnavu. Yavana balance unda? Chesinde adopani. Sigle adagadaniki? Aren't you feeling shameless? Already what you have done is a mistake. What you have done is a wrong. And you are asking me to pay compensation for premature termination of agreements. Sigunda? That's what the tribunal want to ask. Simple answer. That's section 243. Okay? That's section 243. Now listen to one important concept. Linking. See here. There is a company or there are some group of members. This group of members have purchased 90% of the total shares of company. Okay? TCS plus Tisco. Generally, it is Tata Group will not do this, therefore I don't want to take. I will take Reliance. Reliance Industries Limited, Reliance Petroleum Limited, Reliance Communications Limited. These three companies are holding, okay? These three companies are holding or acquired 90% of the shares of X Limited. X Limited is having so many shareholders. 90% capital was acquired by all these people. 90% not of offer, not 235. Total 90% of the 1 crore shares are there, 90 lakh shares are there in the hands of these three companies put together. Balance how many are there? 10% are there. What will be their inner feeling now? Acquire also ours. Why you are leaving us? Also acquire ours. Now, even though this particular company don't want to acquire the balance 10%, this minority can force that majority purchase our shares. Let us go outside. You are all the majority people, na? I don't want to live with you. This Reliance India, Reliance Petroleum, Reliance Communications, we don't want to stay with you. Babu, మమ్మల్ని వదిలే మేము వెళ్ళిపోతాం. మా 10% కూడా కొనేసుకుంటే మేము బయటికి వెళ్ళిపోతాం. If you buy also our 10%, we will also go out. I am repeating both in languages, no problem. Okay? For Telugu touch, I am giving this, but I am repeating same thing also in English, not a problem. Okay? You will not miss even a single thing. Listen carefully. Telugu ekkada miss avagudadu. So, Reliance India Limited, Reliance Petroleum Limited, Reliance Communications Limited, all these three companies are holding 90% of the stocks of X Limited. 10% was only left. The 10% persons are crying, buy also ours. Why we are staying in the company, we are not understanding. Why we are staying in the company? You are all majority here. All the decisions you will take. Even if we wish to take any decision, we are not in a position. We will put a mandate to acquire our shares. Means what? In the previous 235 example, what happened? Even though we don't like, you pressured, forced us, induced us to sell our shares. Now we are inducing you also purchase our 10% and pay us money. This company cannot say no. This is what said in section number 236. That's what we left in compromises chapter. You read later. Okay, this concept, purchase of a minority shareholding when 90% acquisition was made by any person or a group of persons. That's the beauty of Companies Act. How beautifully they have preserved the rights of minority. Okay, that means the lawmaker is telling that బలవంతుడు బలహీనుని బెదిరించి బతకడం కాదు, ఆ బలవంతుడి వెనక కూడా ఒక పవర్ ఉంది, జనతా గ్యారేజ్. That Janata garage is NCLT. That means strong person always oppress weak person. But now, beside this weak person, there is a strength. That strength is called as NCLT. That's the idea. Hope everyone understood the concept. Hope everyone understood the concept now. Chapter completed. Everyone. Completed everyone? తగ్గేదిలే ఈరోజు అసలు తగ్గేదిలే. సో దిస్ ఈజ్ ద కంప్లీషన్ ఆఫ్ అప్రెషన్ అండ్ మిస్మేనేజ్మెంట్. ఓకే, సో దిస్ ఈజ్ ది ఐడియా బిహైండ్ దిస్ పర్టికులర్ కాన్సెప్ట్. సో అప్రెషన్ మిస్మేనేజ్మెంట్ వాజ్ కంప్లీటెడ్ నౌ. నెక్స్ట్ వన్ ఈస్ the topic which we are going to start is inspection, inquiry, investigation. As I already said you the word, by 2:15 I will be completing oppression. It's 2:10 now. Sorry, 12:15 I will complete. It's 12:10 now. I completed the chapter. Okay. Next issue. Inspection, inquiry and investigation. Sir, case laws were kept in the chart. Please read. Don't leave case laws. Oppression chapter la important case laws. Okay, oppression chapter la important case laws. Okay, read all the cases I have put here, all the applicable 13 case laws for the exam. That I can't explain, waste our time. So you have to read these important cases. Please read. Or else I can do one thing. I will make a video on this and put just a 15-20 minutes lecture on all the cases of oppression. But not now. Case laws are what we have to understand. Sections I will explain. Next. Inspection, inquiry and investigation. Section number 206 to section number 229. Everyone open the notes. Why? I will tell you the linking of this particular chapter. What sections we need to read. What is the sequence? Everyone put notes before you, write down the sequence. Part 1, part 2, part 3, part 4, part 5. Chapter will be divided into 5 equal parts. Very big chapter, na? 206 to 229, so many sections are there. Okay, but we should not leave even a single area. What to do? We have to divide that. Write down the sequence. Number 1, 216, 221, 213, 222. 213, 222. Next, part 2, number 1. 206, 206(4), 207, 209, 208. Part 3. 215, 210, 214, 16, 17, 18, 19, 220, 223, 224, 225. Part 4. 218, 218, 19, 20, 21, 22, 23, 24, 25, 26, 226, 227, 228, 229. Part 5. 211, 212, 217. This is the sequence. If you read in this sequence, really you will appreciate the chapter contents, or else it will be like some horrible concept you will leave. 2-3 questions will come in exam. Egripotar exam lo. You will fly off. Okay. So don't leave. This is the sequence we are going to follow. 216, 221, 213, 222, 206, 206(4), 207. 216 will be talking about inspection into the membership. 221 will be talking about freezing of the assets of the company. 213 will be criminal investigation. 222 will be freezing of the investments and imposition and restriction on the security. 206 will be inspection. 206(4) is the inquiry. 207 is the power during inspection and inquiry. 209 will be the power to make a search and seizure. 208 will be the report to the central government. 215 will be appointment of inspector. 210 will be investigation by the central government. 214 will be security for the payment of cost. 219 will be related investigation. 220 will be search and seizure during investigation. 223 report. 224 action on the report. 225 will be expenses collection. 218 will be protection of the employee. 226 will be proceedings of investigation and winding up shall not start during the course of investigation. 227 will be protection to the legal advisors and bankers. 228 and 229 will be the penalty. 211 will be SFIO composition. 212 will be SFIO powers. 217 will be powers of the inspector. These are all the sections that we are related in the inspection chapter. Let's go on. First, answer one question. Part 1 and part 2 are heavy. Part 1, part 2 completed. Till part 4 easy. 2, 3, 4 very easy. 30 minutes we can complete all these. Very, very easy chapter. Part 4 again, SFIO is a lengthy concept to some extent, and we can easily understand that SFIO concept. Not so great, easy only. So, and I am there to make it easy, not an issue. Just concentrate. Concentration is required. Continuous concentration if you put now, easily we can complete these areas here. First thing, I will ask you one question, answer. See here. Something is fishy here. What is that? Let us see. Okay. Sir, 5 minutes break. Some person is asking, please sir, 12:45. Anyway, I will stop. Okay. Some people should have the food now. 12:45. We will have a break. After that, again we will meet and again we will continue. Okay. I will complete everything. I am giving you the word. It may be more 1 hour extra or half an hour extra, but still I will complete. Okay. Slowly let us complete entire syllabus. Okay. We are not to rush here with the answers. I can't read and go. See here. Face-to-face classes la same problem. I will be always trying to put some value advantage and value added to the students. Students always push me. Complete it. Completed means completion will be like this. So please listen carefully. Point number 1. Members are there. They put a complaint in NCLT. Under section 241, read with section number 244. They made a complaint to NCLT. What complaint they made to NCLT? They made a complaint to NCLT saying that in my company there is oppression or mismanagement is going on. Let's say oppression is there. Let's say oppression is there. Okay. Oppression complaint we made. The affairs of the company have been or are being conducted in a manner prejudicial to the public interest, prejudicial to the member, prejudicial to such person who made an application, or prejudicial to the interest of the company. We made a complaint. Oppression complaint was taken by tribunal, and it is also justifying of the winding up, such that the case is intense. Now, then it will take an action. How it will know that the matter is intense? Just you filed a complaint. How can I know that it is having some intensity? How can I understand? Therefore, listen carefully. Whenever 241 or 244 application is made, NCLT will take an action under 242. But in middle, something is missing. Directly, consent, all these things gone out of the window. Directly 241, 244, 242 will exercise of power. So that means how can you justify that there is intensity of winding up? How do you know, tribunal? Just because of me making application, sir, I will write a story on a paper. After reading the story, person wala crying. That's all. My story will motivate you. Facts should motivate you, not my stories. Fact should motivate you. How the facts motivates me? You need to go into the reality and check. That reality check is provided by section number 216. Once a tribunal receive a complaint under 241 or 244 from the members, blindly it will not operate section 242. It will link section 216 in middle. It will tell that central government, go and jump on the company. Check whether oppression is going on or not. How can I know? Central government will tell. Central government will be appointing inspectors to inspect membership of the company. What? Membership. Members will be of two types. Type 1, members who are truly interested in success and failure of the company. Members who just want to control the company. Who will cause oppression? Who are interested in success and failure? Who want to control? Control. I want to identify these persons. From where control will come? From shareholding. Big shareholding will be there, na? 7% to 6%, 8%, 9% like this. All those will be sidelined. They will be set aside. On them, investigation will start. That means, unless and until tribunal have a evidence strongly that intensity is more, how can I pass an order under 242? Orally, that section said that, if it is winding up, go for 242. But who said that that is that much intense? Central government conducts investigation under section 216 by appointing inspectors, and it will give a report to tribunal that matter is intense. Members are cheating the minority. Like that, it will give a report. Did you get the logic, everyone in the class? In such a case, 216 investigation helps us to understand the intensity of oppression. Okay? So, who are really interested, who are just to control the company, we will do the investigation. Now, look at the scenario. Mukesh Ambani is there. Okay? Mukesh Ambani acquired 33% of X Limited. On X Limited, NCLT application on oppression was made. Now X Limited is under investigation. Investigation inspector will come and check who is the big shareholders. List the first person, Mukesh Ambani. Immediately he will catch him and call him to investigation. To avoid this, what Mukesh Ambani will do? Mukesh Ambani will provide money to A, B, C, D, E, F. He will give 5%, 5%, 5%, 5%, 5%, 5%. Okay, 6, 5 is 30%. Mukesh Ambani will give money to all these people and ask these people to invest in X Limited. Okay, these people will invest in X Limited. Technically, 5 members are there, but really they are controlled by Mukesh Ambani. Mukesh Ambani is the beneficial holder of the shares. These are just a registered holder of the share. Therefore, investigation will be done on the beneficial ownership. That's what section 216 said. They will check the bank accounts of all these 5 persons. If any money comes from any person during the day of acquisition, they will jump on that person and do investigation. Why you provided money to them? That's the intention of section number 216. Understand the greatness of Government of India in framing Companies Act in such a large fashion. How great the government is to put provisions like that. Appreciate the lawmakers here. Investigation into the ownership. Initiated by whom? Tribunal. Conducted by whom? Central government. I forgot to tell. Sir, always, keep it in quotations, always, every time. Those who watch Harry Potter will know much more intensity of that word, always. Okay, always. Listen, one important point. Purpose of investigation, you can put it aside. Always investigation will be done by central government only. Government does investigation. Tribunal will not do investigation. Tribunal may order investigation. Tribunal cannot investigate. Okay, central government can't order investigation. Central government can only investigate. Tribunal cannot. Okay, tribunal cannot investigate. Central government cannot order investigation. Central government can order investigation in sumo to public interest. Those we will discuss later. But one thing, tribunal can't investigate. Tribunal can only order CG to investigate. Okay, so purpose of investigation: to know true persons, to know who are materially influencing the policy, to know the beneficial owners. Central government shall appoint inspectors, decide the scope, and the report will be sent back to the central government. This is 216. Now answer my question. During 216 investigation, okay, A, B, C, D, E, F are there, na? A, B, C, D, E, F are there. Now what this A, B, C, D, E, F will do, this mischievous person, what they will do is, listen carefully. This person, A, B, C, D, E, F, they came to know that investigation on ownership is going to start. They will transfer shares to other parties. That means A transfers 5% as 1% to X, 1% to Y, 1% to Z, like that they will transfer. Therefore, section 222 came into existence. Restrictions by tribunal. 222 section says that during investigation under 216 or reference made by any person, okay, if tribunal finds that it is better to impose restriction on securities, it will impose restriction for not exceeding 3 years. That's how section 222 came into Companies Act. 222, one of the purpose is 216. Because of 216, 222 can come. Does not mean 222 can come only because of 216. That is not the answer. I repeat once again for your kind understanding. See here. 216 started. 222 99% parallelly start. That does not mean that 222 will come only because of 216. No, not like that. 222 can independently operate by reference of any other person. One of the reason to initiate 222 can be investigation under section 216. Hope everyone understood the logic behind. Okay, so therefore tribunal can order investigation and restrictions can be imposed by tribunal during investigation under 216 or reference made by any person. Now let us understand reference made by any person. Everyone listen carefully. Takeover concept just now we read in 235. 235 takeover. Okay, takeover lo what I said, some persons will be dissenting. These dissenting persons will make appeal to tribunal not to acquire the shares. At that time this section can get invoked. Like that linking they can ask in exam. At that time restrictions may be imposed on the company not to transfer the shares. Clear or not everyone? Or let me explain another example. Recent attempt one question was also given on 222. There is a company. That company want to issue convertible debentures. Because of issue of convertible debentures, what is the damage that is being caused to the company? If convertible debentures are issued, in future they will get converted into equity. Equity dilution will happen or not? Now the equity shareholders will make a complaint to the tribunal, restrict the issue of shares. Like that question can be asked. Any kind. Security restrictions are 222 will apply. For 222, one of the good reason is 216. During 216, these persons, in order to frustrate the proceeding, they will transfer the shares immediately to others, such that when the tribunal comes for investigation, when central government comes for investigation, little amount of shareholding will be practically held in their hands. Not to have that, this concept has been initiated. Hope everyone understood the concept clearly. Sir, everyone please reply. Everyone understood 216 linked with 222. Everyone. Sir, everyone understood? Yeah. Thank you very much. Sir, just wait for 10 minutes. We'll complete 2 small sections and then we will be, not even small sections. What is the time now? 2:30 almost. Do one thing. Take a break and come. It's now 2:30. Again, we will meet at 1:30. Give me 1 hour time. I have to take some rest. Okay. 1:30. We will again meet back. 1:30 to 2:45. We will be completing this. After that, the flow will continue with small chapters. 10 minutes dormant, 15 minutes Nidhi company, 10 minutes government company. Like that, small chapters are there. NCLT removal, all the concepts, small concepts. I will wipe and throw them out. Easily we can complete those. Okay. 1:30 we will again meet back. Okay. 1:30. Once the big chapters are completed, I feel very happy and I feel free. Main concepts are completed. The targeted main concepts will be completed. Okay. So Amit Thapa, first time I understood in depth. Thank you very much. What if the shares are already transferred before 2:16? Then no problem, sir. They will go for further investigation. Not an issue. Chandu Venkat. Sir, everyone, before you take a break, please give one small review how you felt about the class. Everyone. Understood the concept clearly, everyone? Everyone understood the concept clearly? So thank you very much. Take a break and come. 1:30 we will meet back again. Okay, exactly at 1:30 we will be again coming back. We will be considering first the investigation chapter and then we will be going on to the next areas. Okay, so thank you very much. Have a nice take 1 hour. 12:30 na 1:30 we will be meeting back again. Thank you. So let us start with the concept. So let us start with the concept. So everyone, welcome back. So we are having the topics regarding inspection, inquiry and investigation. The balance topic. Once after completion of that, we will be going into the next areas. Small chapters are there. We will complete all those. Types of 4 companies are there and 4 miscellaneous chapters are there. NCLT, NCLAT, special courts, miscellaneous, removal and registered valuers. So all these are set. There are small 8 chapters are there. Once that is covered, majority will be over. So let's first complete the big area called as inspection, inquiry and investigation. So let us start. Section number 222 we completed, 216 we completed, 222 also we completed. Now let us come to the other concept. Let's start with some interlinking areas again. So see here. Okay, see here. Everyone please concentrate. We started the class again. Yeah, everyone, good afternoon please. Let's start. Now, see here. As per section number 242, action will be taken by the tribunal if we satisfy all these conditions. Condition number 1. Complaint must be made by members. Condition number 2. Complaint must be made by member in capacity of a member. Again, I am a creditor and member. Sir, all your doubts regarding books etc. I will deal. Once we complete these concepts, let us first stick only on completion of these areas. Okay. So please listen first. I will discuss about all the related details later. So condition number 1, member has to make a complaint. Condition number 2, okay, capacity of member. Capacity. Oh, chart is not available. Oh, sorry. I didn't realize that. Sorry. See here. Condition number 1, member has to make a complaint. Condition number 2, In capacity of a member, he need to make a complaint, which means I am a member, I am also a creditor to a company. In capacity as a creditor, I cannot make a complaint just because of a reason that I am also a member. You should be a member. Oppression should also be caused only in capacity as a member. Condition 3. 4 conditions la any one condition must be satisfied. What are the 4 conditions? Oppressive to the the affairs of the company have been or are being conducted in a manner prejudicial to the public interest or to the members or to any one member or to the interests of the company. Any 4 conditions or one condition must be satisfied. Condition 4. Section 244, complaint must be made by requisite members. That means 100 members or 1/10 of the total number of members, whichever is lower, or members holding not less than 1/10 of the issued share capital shall make a complaint again. Condition number 5. Condition number 4. Condition number 5 is satisfaction of NCLT. Again, tribunal should be satisfied that all these are there. Condition number 6, justify winding up. If all these conditions are satisfied cumulatively, then section 242 la action will be taken by the tribunal on the company against the oppression. That means whatever the actions we have seen in section number 242, all those things will be taken by the tribunal if all these conditions are cumulatively satisfied. Condition 1 to 6 must be satisfied cumulatively. Then action under section 242 will be taken by the tribunal. But what is the chance? 6 conditions must be cumulatively satisfied for you to take an action against us. To what extent? What is the degree and level of perfection to this? What is the degree of perfection? Every condition we need to satisfy, all the 6 conditions. Member should make a complaint in capacity as a member. 4 conditions should be satisfied. 244 la complaint, you should sit satisfied, and the intensity should be equal into the winding up. How can we match to all these conditions? It is immensely difficult for any company to match up to here. Then answer my question. Reading section number 242 is easy. When you go into the practical implications, a real problem will come. So what to do is a question now. So in these situations, what is the remedy that is being available? Okay. So the remedy is, since member, capacity of member, 4 conditions, 244, satisfaction of NCLT, justification for winding up. Since all these things are good conditions and difficult conditions to satisfy, in all cases, how to get the satisfaction of tribunal, how to satisfy tribunal that these situations are in existence, how can you do that? Therefore, alternatively, another section came into Companies Act. That is section number 213. Very, very important section, 3 times tested already in exam. 213 section has become an alternative for those who could not comply with 242. That means, what do you mean by that? Sir, member, I am not a member, sir, I am a creditor, I want to make a complaint. Go for 213. Sir, I am a member, but not in capacity as a member, sir. Go to 213. Sir, I am a member in capacity as a member, but 4 conditions are not there, sir. Another reason is there. Go for 213. Next, sir, we are members, capacity as members, 4 conditions may be there, but 100 members are not there, sir. Then what to do? Go for 213. Sir, all these are there, sir, but I couldn't satisfy all these things to the tribunal. 213. Sir, all these are there, I couldn't justify winding up. That much intensity is not there, but wrongs are going on. 213. Whenever you couldn't satisfy any of the conditions of 242, remedically the law has provided another alternative substitute section called as section 213. Now everyone will get it out. So then everyone will go to 213, then who will come to 242? Impact of 213 and 242 is different. I said 242 is an alternative. Sorry, 213 is an alternative, but not equal to 242. 242 powers are immensely intense powers of tribunal. Okay. Sale of the shares of the member of a company, removal of directors, removal of managing director, removal of officers, appointment of new persons, takeover of management. All fantastic powers are given in 242. 242 is a reconstruction of entire company It is what, sir? It is a restructuring of entire company itself. But 213 la restructuring, reinventing will not be there. Reorganization also will not be there. I will be booking 447 section against the directors, that's all. Oppression mismanagement, removal, reappointment of another person, all these things will come. That much powers will not be there in 213, but I will take action against those causing oppression and mismanagement by booking a fraud case against them under section 447. This is the idea of section 213. Everyone understood the concept clearly. Break after, lunch break after, very, very dangerous time, but dangerous chapter is also there for us. Reply everyone. Sir, if you participate along with me, just like that you can complete. Shall I tell you one thing? After live, listening to class is very, very difficult. You can't sit and listen again. So, go with the flow of live class and complete it. I will put it on the YouTube channel only. I will not delete the lecture. I already said that, but still. Clear? Okay? Yeah. So therefore, with that intention, this particular concept of section 213 has been inserted into the company law. That means, if a person could not satisfy 242, always, I can't tell that since 242 is not there. Since 242 section cannot be resorted by the members, tribunal can't tell that go home and play. It can't tell like that. Alternative remedy it will show. I can't have 242, but I will accept 213. Okay, 213 is a remedy provision for 242. Okay, let us see how it look like. See here. See here. 213. Investigation into the company affairs in other cases. Section number 213. Section number 213. See here. Basics. Power with whom? Power with tribunal. Okay. Purpose of making application by whom? Two options are given. Option 1, requisite number of members, and any other person or otherwise. Any other person or otherwise. Now question will come. Sir, requisite number of members means how many, sir? See here. Requisite members are 100 members or members holding not less than 1/10 of the total voting power in case of company having share capital. Okay, in case of company having share capital. In not having share capital, 1/5, obviously. 100 members or member holding not less than 1/10 of the total voting power, not 1/10 of the total issued share capital here. Total voting power la 1/10. Okay, if you hold, members can make a complaint. It's option 1. Option number 2, any other person or otherwise, which is not possible under section number 242. 242 la any other person can't do, only member resorted. Here, creditor, everyone can make a complaint. Okay. Now, members are making a complaint to tribunal. In oppression chapter, I need to show that any of the 4 conditions are in existence. Here, what I need to show? Good reason supported by evidence. That's all. Any good reason it can be. Whether it is good or not, dependent on the member's intention. Tribunal will accept it. So therefore, it should be in the opinion of tribunal and in the opinion of the applicant, a good reason supported by evidence. That's all. It need not be prejudicial to company interest, prejudicial to public interest. This much will not be there. Any good reason, you make a complaint, I will take. Sir, any other person or otherwise can also make complaint, sir? Any other person can also make a complaint. Sir, who can make a complaint? Creditor can make, debenture holder can make, debenture trustee can make, anyone can make. Sir, then they also good reason in support. No. For them 6 conditions are given. Any of these 6, not all the 6, any of these 6 conditions you need to satisfy. Any other person or otherwise, they have to show that wrongful business is going on. What business, sir? Wrongful business. Business to defraud. Business fraudulent, unlawful. Business oppressive. Or company itself is formed for fraudulent or unlawful purpose. Or management persons are guilty of fraud, misfeasance, other misconduct. Or company is not providing proper financial information. For example, payment of remuneration to managing director, manager, whole-time director will be there. Give the details I asked. They are not giving the information. That means something is going wrong in the company. In any of these 6 cases, you can file a complaint under 213. Members or any other person make a petition to the tribunal asking tribunal, please conduct investigation. Tribunal will tell them, I can't conduct investigation. Investigation will be conducted by central government. Then why you asked me to come to you? You file a complaint to me. Now I will appoint central government who will investigate and give a report back to me. Oh, okay. That means listen to the scenario flow. You need to continue. Members are there, or creditors are there. They couldn't go through 242. They came to 213. Tribunal said, come to me. They came to us. They said, who are you? Sir, I'm a member. I'm a member. Now I will ask you one question. Member will come under option 1 or option 2. Everyone participate. Good afternoon, everyone. Member, and this class is for you, not for me. Please. Okay. In spite of my throat is paining, I am taking the class now. So it's your imperative responsibility to listen everything. So please listen. Members comes under option 1 or option 2. Everyone. Members here. Member will come under option 1 or option 2. First tell me that. See here, member, if requisite number are there, option 1. If requisite number are not there, option 2. Can the So, requisite number of members if they are, option 1. If the requisite number of members are not there, option 2. So, whether to apply option 1 or option 2 depends on requisite number are there or not. If this can be satisfied, jump into option 1. If this could not be satisfied, jump to option 2. Clear or not, everyone? So that's how we need to understand this. So there is no hard and fast rule that members will come under option 1. There is no such concept. It can be option 1. It can also be option 2. Okay. So now, next issue. They have to if any other person or otherwise makes a complaint, they have to satisfy any of these 6 conditions. Business is to defraud creditors, business is for fraudulent purpose, or business is oppressive in nature, or company a fraud company, or management is a fraud. Here business is fraud, company a fraud, management fraud, financial information not given properly by the company. In all these 6 cases, any of these 6 cases are in existence, if you can prove to the tribunal will start investigation through CG. Now what the tribunal will do? Tribunal should satisfy that any of the 6 conditions are in existence or this condition is satisfied. Then it shall order any central government inspector to investigate into the affairs of a company. What I said at the beginning, tribunal cannot investigate. Tribunal can order central government to investigate. Now it orders central government to investigate into the affairs of the company. Central government will start investigation. Clear? If any of these conditions are really in existence, fraud is involved, officers will be liable under 447. Everyone in the class, please write down a note point here. Any time it can be tested in exam. Note. Section 242 results in substantial reorganization of company, and section 213 result in action for fraud under section 447. Under section 447. Under section 447. Under section 447. Okay. So shall we continue, everyone? Everyone, completed writing. Shall we continue? See here. Next one. So we now completed section number 213. Now listen carefully. During the course of oppression complaint under 242 or under 213 or by any reason, if the assets of the company are mismanaged, if the assets of the company are not properly taken by the company, if assets of the company are misused by the company, in such a case, what tribunal will do? Listen, again I am repeating the same concept. Oppression complaint made by members. Okay? Oppression complaint made by members to the tribunal. Tribunal justified and satisfied that winding up intensity is in existence. Winding up intensity is in existence. Now the tribunal want to take an action against the company. Okay, assets are being misused by the company. What this particular NCLT can do? Okay, what action NCLT can do now? What actions it can take against the company? Freezing of assets of the company. Very, very important and litigant section which requires a lot of understanding. Please see the screen, everyone in the class. Everyone in the class, please see the screen properly. Litigant section I am telling you before I start. It requires lot of legal contemplation, not just like understanding on an overall basis. Yeah. So see here. Freezing of assets of company on inquiry and investigation. Section number 221. What is this? Let's try to understand. See the screen, everyone. First, application to whom? Tribunal. Okay. Next, application by whom? Central government. Okay. Application by whom? 244. Oppression time la member made a complaint to tribunal that the affairs of the company are not properly managed. Assets are being transferred to some other persons, like that misuse of assets is there. 244. Or during inspection or inquiry. Just now we read 213 inquiry, inspection, investigation. Or creditors having outstanding 1 lakh dues. Sir, why creditors are making complaints, sir? Whenever I am a secured creditor, for my credit amount, asset will be kept as a security. If you are misusing that asset, in future, that asset will not be available for me as a security. Therefore, I am the concerned party who will always cry for the assets. So, creditors, but outstanding amount should be 1 lakh. Or any other person can make a complaint, but he should have some relation with the issue happened. Anyone can make an application to the tribunal to do what? To pass a stay on asset disposal for a period of not exceeding 3 years. Same thing. Previous section we have seen that security transfers will be restricted for 3 years. Here asset transfers will be restricted for 3 years. Sir, can you explain an example for this? How it can be tested in exam? Yes, I will give you one classic example. Listen. 2 examples I will give. Example number 1. Amalgamations. Okay. At the time of amalgamation, assets of the company, one company will be taken by another company. At that time, some assets which tribunal said not to transfer are also getting disposed. Immediately any person can make a complaint to the tribunal saying that some assets which you ordered not to transfer are also getting transferred. Like that this section can get attracted. Okay, like that this section get attracted. At that time, who will make a complaint? ROC, or official liquidator, some person will make a complaint, becomes any other person. Clear, everyone? So like that it can happen. I will give second example as well. See here, second example. 180 subsection 1 clause A. Directors concepts la 180 subsection 1 clause A. 180 subsection 1 clause A says that the board of directors of the company shall exercise the following powers only by means of special resolution, namely to sell, lease or otherwise dispose of the whole or substantially the whole of the undertaking of a company. Some of the directors of the company decided to sell the assets of the company. Immediately the members of the company may apply to the tribunal under section 221 to stop this activity of transfer any other person. Now put a message everyone. Have you understood and linked the concept how it can be asked in exams? Understood, sir, everyone? So that's how it can be tested in exam. Okay, these are the linking concepts. How this section will get attracted? So the main problem with CA final exams is he will not ask you write about section 221. He will link that to the original concept. At that time we should be conscious enough. Okay, at that time we need to understand under what circumstances it will get applied. Okay, so anyway, let us continue. So thank you for giving a feedback. Sir, go on continually giving some feedback such that you will also stay awake. Okay, please don't sleep. One day session, everything will be completed. Please see here. So therefore, under any of these 5 circumstances, yes, you can apply for tribunal freezing orders on the asset transfers. Everyone listen one point. Sir, you said that investigation chapter will be in the hands of central government. But this section, tribunal is passing the orders, na sir. Listen carefully. Restrictions passed by tribunal under this section, freezing of assets under this section, these both are called as stopping the company from doing something. Means what? Here security dealings are stopped. Here assets transfers are stopped. In both the cases, what it is doing? Stay order. Stay order will be given by central government. Stay order is given by civil court. Civil court. What is the civil court under Companies Act? NCLT. That's why NCLT is involved in both these sections. 221 and 222 are stay order sections in Companies Act. Okay. So this is the completion of 216, 222, 221 and 213 as well. Okay. So we completed these sections now. As I already said, list of the sections you have with you. Part 1, 220, 216, 222, 221, 213. Like that I have given. All these are completed now. Okay. Sorry, not this. So 4 sections set is completed. Now we need to come to part number 1. I repeat, we are coming to part number 1. Part 1 is 206 and 206.4. 206 and 206.4. Everyone listen carefully. Logic must be understood. See here. Heading of the section. Power to call for information. Power to inspect. Power to inquire. So how many powers are there in this section? In this section totally ROC is given with 3 powers. I will write here. First one call. Second one inspect. Third one inquire. 3 powers are there. How many? 3 powers are there. Sir, what is the difference, sir? Listen. I will call you for information. Give me the information. Maryadaga. If you don't give, I will come for inspection. Amaryadaga. During that time, if I feel that affairs are fraudulent, I will go for inquiry. Inka maryadaga. Okay. So the point is, give me information. When I call you for information, provide me with information within the specified time. If you don't provide, I will come for inspection. Okay. At that time, if I came to know that there are some frauds in your company, I will start inquiry. Sir, what is the difference between call, inspect, inquiry? Calling means I will call you for information, submit the documents online. Inspection means I will send some persons or only I will personally come. Inquire means our persons will come to you orally, they will ask you questions, take the statements from you. Intensity increases. Calling, basic. Intensity somewhat increase, inspection. Intensity somewhat increase, inquiry. More increase of inquiry, investigation. Like that, the intensity will increase. Examination, intensity will be there. That intensity go on increasing. Clear, everyone? So that's the basic idea behind this particular section. Let us read now. Power with whom? ROC. Okay. What ROC is doing? You should go by the wavelength of the section, sir. Everyone in the class, I ask you only to do one thing. Go by the wavelength of the class. Observation required. I said 3 are there. Call, inspect, inquire. First call. Without calling, how can you directly go for inspection? Okay. So first call. Power with whom? ROC. ROC will call for what? Information. Orally, by a phone call, he will tell, give me the books, return notice. Require the company to furnish information, produce documents. Okay. Now why ROC want your books? Why ROC want explanation? Why ROC want you to produce documents within a reasonable time? What is the reason why he is asking? Already our company has filed financial statements with ROC. Upon scrutiny of the documents filed, ROC got a doubt. Therefore, he is asking us to furnish. May furnish, shall furnish a company. It is the duty of officers and employees, including past employees. If present information inquiry, information is called present officers. Past information is called past officers are also liable to give information. On this exam question was also asked one time. Okay. What is the duty of these people? Provide information to the best of their knowledge. Up to here, hope everyone understood. Simple concept here. If you read like this, keep very clear. Listen again. Company filed documents with ROC. ROC made scrutiny of the documents. On scrutiny, he got a doubt. He made a written notice, asked the company, bring the information. Company has a mandate to bring the information to the best of the knowledge. Past information are past employees and officers liable. Present information are present officers and employees are liable. You should produce it within the reasonable time. Answer completed. As simple as that. Next. Power to call for additional information. Okay, power to call for additional information. This is also called as inspection. He will directly go. If information is not submitted within reasonable time or submitted within reasonable time but it is inadequate, or ROC upon scrutiny opined that the state of affairs of the company are unsatisfactory and does not disclose fair information, he will go for a physical inspection of the books. I repeat, any of the 3 conditions must be satisfied for inspection. Number 1, information is not submitted within reasonable time. Second one, information is furnished within time but inadequate, not that information what I asked you. Third one, information is submitted within time and it is adequate only, but on the basis of that adequate information I came to know that you are unsatisfactory, your affairs are unsatisfactory. Then I will go for inspection. Then I will go for what, sir? Inspection. Okay. Another written notice calling for such books of accounts and information and conduct a inspection. Here you can add one point and conduct inspection. Conduct inspection. Okay, this is the point. So if you revise everything in short, everyone in the class, please revise along with me. Your faces are not available, your voice is not available, but still feel as if we are in the class because it's your exam, not mine. Repeat everyone. First, power is with whom? ROC. ROC may give which notice? Oral notice or written notice? Written notice asking for information. You should submit within time. Whose duty? Company, officers and employees, present and past, to submit all the information and documents. Next. They submitted information, they didn't submit within reasonable time, or submitted within reasonable time but it is inadequate, or it is inadequate but it is unsatisfactory. In all these 3 cases, I have a power to conduct inspection. Next. Inquiry. Very, very important concept. Inquiry. When ROC will conduct inquiry is the question now. ROC will conduct inquiry. Okay. Now listen carefully. I am ROC or some person is ROC. I am in company. I am a director of a company. ROC came like this. He said, I want to inquire your company affairs. Who is the managing director? I said, who you are? I am ROC. Shut your mouth and please leave the company, I said. Okay, with due respect. First leave the company. He said, hey, I am a civil court, almost similar to civil court. I have civil court powers. He answered, oh, you are civil court. I am not court, but I can throw you outside. So I will throw you out. Hey, I am an ROC here. Aite enti? ROC aite? I am a director. Aite enti? So, I am a director here. I am a director in this company. If you are ROC, what is great for me? If you are ROC, go to your office and send me a notice. You are coming to my company asking for inquiry on what basis? What grounds? What I have done? What our company has done? Your company business is conducted for fraudulent or unlawful purpose, or it is not in compliance with the act. And investors are making complaint to you, but you are not at all attending to the complaints of the investors. Who said you? That ROC has to answer. Just telling that business is conducted for fraudulent. Who said you? Who said you that I have done for a fraudulent or unlawful purpose? On the basis of information available with him, furnished to him, or representation made by any person. If you can show both these two conditions with any of these three bases, if you can prove, then you can conduct inquiry, or else same effect. I am director. Like that they will also react. So therefore, ROC while conducting inquiry should have a rock solid proof with him that the business is being conducted for fraudulent or unlawful purpose or not in compliance with the act, or grievances of the investors is not properly addressed, and that you should show that on the basis of any of these three it has been satisfied. Then you can conduct an inquiry, or else no chance of doing any inquiry. Hope I think everyone understood what is the idea behind this section. Okay? Everyone understood the point clear up to here? Everyone in the class understood the section completed? Everyone understood the idea behind this? Everyone, please give a reply. Everyone understood the concept clearly? Section completed. I said now very big section that was completed now. Yes. So this is the idea behind. So in a nutshell, summary, how to write this answer? ROC will ask for information. We need to submit the information within a reasonable time. The officers and employees of the company, whether present or past, is responsible to submit information to the ROC. If the information is not submitted within reasonable time, or it is inadequate, or it is unsatisfactory, he can conduct the inspection. If on the information available to him or furnished to him or any person making a complaint against the company, it was satisfied by the ROC that the business of the company is carried on for fraudulent or unlawful purpose or not in compliance with the act, he can conduct an inquiry into the company affairs. Answer completed. This is what 206 section talks of. Very big section. Next, 206 we completed. 207, 208, 209. 207, 208 and 209. So there is a small clerical mistake here. Instead of 209, they printed 208. So let's adjust this. Okay, let us start. Conduct of inspection, inquiry and investigation and search and seizure. Listen carefully. First, 207. Conduct of inspection and inquiry. Sir, what is this? What section 207 talk about? Let us understand this. First, power of an ROC during inspection and inquiry. What are the powers of ROC during inspection and inquiry is going on? Inspection and inquiry will be going on in the company at that time. What will be the powers of ROC? Listen to my language. After that you can read. ROC does not have any special powers. ROC power is entrusting duties on others. Technically, what are the powers of ROC? అని అడిగితే ROC చెప్పేది ఏంటి? నా పవర్ పక్కన పెట్టు, నేనేం చెప్తే అది వేరేవాడు చేయాలి. దట్ మీన్స్ మై పవర్ ఈజ్ imposing duty on others. Sir, what do you mean by that? I will explain in a more crystal manner. See here. ROC will have a power to impose duty on officers and employees of the company to give information. That is my power. My power is entrusting duty on the employees to give information to me. Produce document, furnish statement, render assistance. In the inspection process, you have to render me the assistance. Okay. Next. Now the special powers of ROC. ROC will have power of making copies of books of accounts and other books and papers. He can have copies of books and papers. Not only that, he can place identification marks in the original books such that it is a token of inspection being made. So now let us revise everything. What are the powers of ROC? It shall be the duty of every officer and employee of the company to furnish information, produce documents, render assistance, etc. Along with that, ROC will have a power to make copies of books and papers. Not only that, he can place identification marks in the original documents as a token of inspection being made. This is the point. Okay. Not only this, ROC will have civil court powers. Number one, summoning and enforcing the attendance of a person. Summon means what? Summon means demanding the presence. Come here. Demanding. Enforcing that if you don't come, I will enforce your presence with police assistance. Enforcing. Examination on oath. By oath of a promise, tell all the facts. Not only that, discovery and production of documents. Okay. Before coming into this, let me revise one point. 207 section we are discussing. Powers of ROC. What are the powers of ROC during inspection and inquiry? Duty on officers and employees. Number one. Take copies, place identification marks. Answer completed. Third one, civil court powers. What civil court powers? Summon the person, examine him. Examination on an oath. Discovery and production of documents. Discovery means search. Production means seize. That's what the next section. ROC's power of search and seizure. Okay. ROC power of search and seizure. Let us see. Power with whom? ROC or an inspector. On what basis? On the basis of information in his possession or otherwise. What he can do? He can make a search and seizure. Listen carefully. Search don't require anyone's permission. Seize requires a special court permission. I repeat for the second time. Search can be made directly, but seize can be made only with the permission of the special court. Okay. So now listen. ROC received information from the company, some person, director, auditor, members, stat auditors or internal auditors, or some person has given information to ROC. What information? Information says that the company books of accounts are likely to be, chance is there, destroyed, mutilated, altered, falsified or secreted. That means they may be totally destroyed or mutilated, or they may alter, or they may falsify, false accounts they may prepare, or secreted, they may hide it. Any of these things happen, ROC cannot conduct a proper inspection if any of these things happen. Okay. Therefore, if the books of accounts are likely to be destroyed, mutilated, altered, falsified or secreted, ROC can enter into such places where the books are kept, with or without assistance. Seize the books, but only with the prior permission of the special court. Prior permission of the special court. This was given in examination as well. 10 o'clock, notice is received from a member that the books are getting likely to be destroyed. 10:30 ROC entered premises and seized. Possible? Not possible, because you didn't take the permit of the special court. With 30 minutes of special court permission also given, it will take days time. So therefore, like that, 10 o'clock you received information, 10:30 you cannot go. Okay. Repeat once again to the concept, everyone. ROC power to make search and seizure. What are the powers? ROC or inspector has a reasonable ground to believe that the books and papers of the company are likely to be, everyone in the class, repeat, 5 things. Likely to be, that question was asked 4-5 times here, please repeat. destroyed, mutilated, altered, falsified, secreted. Once again, destroyed, mutilated, altered, falsified, secreted. Once again, destroyed, mutilated, altered, falsified, or secreted. If any of these 5 things are proved, then he can enter the place, seize the books with the permit of special court. Sir, seize the books, okay sir. 2 questions will come. Whose books, how much time? Books relating to director, company, auditor, KMPCS. Any book you can seize, but you can keep for a period not exceeding 180 days. How many days, sir? 180 days. Okay. We completed 2 sections now again. 207, 209. 207 powers of ROC. ROC power, entrusting duty. Make copies, place identification mark, civil code powers. In that civil code power, one of the power is discovery and production. That lead to search and seizure section. Information received from some person to the ROC that the books are likely to be destroyed, mutilated, altered, falsified, secreted. Enter place, seize the books, special court permission, any books with the special court permission and retain for 180 days. Simply this is the answer. 207, 209. Now, calling information completed, inspection completed, power exercising completed, inquiries completed, search completed, report preparation will be there. Now the ROC or inspector will prepare a report. Report of calling information, report of inspection, report of inquiry, report of search seizure. They will write full report and send to the central government because central government appointed them. That is section 208. ROC or inspector, okay, on inspection, recommend further investigation and send a report to the CG. That means they will tell central government this is a report. But false statements are there in the company. We want to conduct investigation. They will recommend investigation and send a report to the central government under section 208. This is the end of 206, 207, 208, 209. Now you have to give a review. Everyone understood the concept clearly or not? If you say yes, I will go into the next sections and complete off. Completed everyone? Okay. So let's continue. So power to make a search and seizure is also completed. So second set is also completed. You can check there. Our agenda is there, na? There I completed 216, 222, 213, 221, 206, 206, 4, 207, 209, 208. Completed. Now let us go to the set 3. Set 3. Investigation sections. Which sections, sir? Investigation sections. Okay. Now, first, section 215. Now we are coming not to inquiry inspection, already completed. Investigation sections we are coming into. Okay. Which sections? Investigation section. Okay. Listen carefully to the logic, everyone in the class. First point number 1. Inspector can only be an individual. Answer completed. 215. Completed. That means a firm, body, corporate or association shall not be appointed as inspector. 215 completed. After 215 which section? 210. The basic investigation section. This is the charging section. Investigation ke charging. Listen carefully. Everyone know this section, but still let me revise very fast. 210 section says that central government can order investigation in 4 cases. 3 are may, 1 is shall. 3 are may, 1 is shall. Okay, there is a small printing mistake here. I will rectify now. See here. 3 are may. 1 is a shall. Means what? There are 4 grounds totally. In this 4 grounds, 3 are may. This is also may. Okay, this is also may. Only this is a shall. By mistake, it was printed like this. So please ignore that. This is may. From here to here, may. This will be shall. Means what? ROC or inspector made a report to central government and sent it. On that basis, central government may order investigation, or special resolution is passed by the company that affairs of the company are investigated. That means shareholders themselves are asking central government, "Arey, something is going wrong in our company, please conduct investigation." Central government may, or central government voluntarily may. Fourth one is 213 section. Tribunal ordered central government to conduct investigation, then central government don't have may, it is shall. When court ordered, you don't have an option. In all other cases, there is an option for you. I repeat once again, listen carefully. There are 4 grounds of investigation. ROC report, special resolution, sumoto, may. Tribunal na, shall. You need to conduct investigation mandatorily. Okay? Common sense has to be used now. Everyone in the class should answer this question. Observe all the 4. ROC, special resolution, central government, tribunal order. So tribunal ordering central government to investigate. No doubt. Why tribunal is ordering? Tribunal cannot sumoto give. Some member, creditor, they have to first make complaint to tribunal. Tribunal appointed central government to investigate. That means technically in the 4th case, some person, members, creditors like that must have made application already to the tribunal. Kada? So therefore I will write like this. ROC, special resolution, central government, some person. Okay. Now, let us take 1, 2, 3, 4. Everyone in the class, answer. Who are, in this 1, 2, 3, 4, who are government related persons, non-government private persons? You need to tell numbering. 1, 2 are government side, 1, 3 are government side, 1, 4 are government side, 2, 3 are government side. Like that you need to tell. Who are on government side, who are on private side. Waiting for your answer. Everyone, participate, write down, give an answer. And no one is still understanding this class is for you, not for me. Write down. Who is on the government side? Who is not on the government side? Okay, very good. Here and there some wrong answers came. Jahnavi, you gave 1, 3 and 4 as government, but 4th one is technically some person making application to tribunal. Government persons are ROC and central government. Special resolution by shareholders are private persons, not government related. And tribunal is a government related authority, but the why tribunal will directly make application to central government? As some person has to first complain to tribunal. That some person can be member or a creditor. Again, he is a private person. Private. Government. Sir, why you are asking, sir, division of government, non-government? And I am not a mad fellow to ask, sir, please. Really, I am 100% sound mind. I am not disqualified as a director. Okay? So, please see here. Why I am asking is government ROC, Central government and government. Whenever investigation application comes to the central government from shareholders or some person making complaint to tribunal because of that it received application, in these two cases, security amount of not exceeding 25,000 must be paid by the applicants. Tribunal is not applicant. Tribunal is ordering central government. Upon whose application? Member or creditor. That person should deposit 25,000 rupees maximum as a security deposit. Insult here. If you ask ROC, central government is telling ROC, come on, deposit 25,000. Tupuk. You are my person asking 25,000 for me. You don't have a clarity on what you are talking. Central government will make self tupuk. Central government will make 25,000 payment to central government. Therefore, logic must be sustaining there. So, next section related to 14, what it says is a payment of security that will be paid only by second case and fourth case. See how beautifully they said. Second case, 210(1)(b), 213, last case. In these two cases, security will be collected before appointing inspector not exceeding 25,000. But that will be refunded if investigation resulted in prosecution. That means in the investigation wrongs are found. In such a case, I will refund you back your security deposit. Like 161 lakh rupee deposit back. Same concept. Now give a review. Everyone understood the concept or not? We completed these sections as well now. I think everyone understood why I asked you to tell government and non-government. Okay? Yeah. So now completed. Now we completed section number 215, 210, 214. 228 just here it is printed, but we will not discuss here. We will discuss at a later stage. Hope everyone understood the concept clearly up to here. I'll be going into the next part. Okay, next one. Next. Sir, the related sections, what I said is, if you see our material, agenda of topics, 215, 210, 214, later 219, 220, 223, 224, 225. This is what I have written. 215 we completed, 210 we completed, 214 we completed. Now 219. What is 219? When the inspector goes for investigation into our company, not only our company, he can also enter into investigation into related entities. What are those related entities? Let's say for example. So see, power to do what? Power to investigate into the affairs of related persons. Power with whom? Inspector under 210 or 212 or 230. Any investigation. Okay. What are related entities? Important. Group companies. My holding, my subsidiary, subsidiary of holding. Write down note. Associates not covered. That only will come in exam. He will ask associate company related entity investigation. That's not covered by 219. Okay. So see here. So holding, subsidiary and subsidiary of holding company. Okay. Next. So I repeat, when ROC comes for investigation into our company, he need not restrict investigation only to our company. He can also jump into related entities. That related entities can be holding, subsidiary or subsidiary to my holding. Okay. Next. Any body corporate which is managed by managing director or manager who is or who was MD or manager of the company. Sir, I didn't understand. I will explain. Our company is X Limited. Already this is under investigation. In our X Limited, Mr. X, Mr. Y are there. Mr. X is a MD. Okay, MD. There is a company called as Y Limited, another body corporate. In this Y Limited, X is a manager. X is a manager. because of X in this company, X Limited is now subjected to investigation. If X is there at some other place, we have to doubt even that company. Mana padam ekkadunna daridhrame kada. Mana padam ekkada pedithe akkada sarva nasaname. So therefore, not only this company, wherever your iron leg is there, those companies are also subjected to investigation. This is the idea. అటువంటి పాదం మరి. సో నెక్స్ట్ వన్, ఎనీ బాడీ కార్పొరేట్ whose board of directors are accustomed to act in accordance with decisions. Sir, we will read this more in 185 loans to directors. But one thing I can tell, our director is there. Our director is not a director there, but according to his instructions, another body corporate is acting. That body corporate is also subjected to investigation. Our company's MD will be investigated. Our company manager will be investigated. Employees will be investigated. All these are called as related entity investigation. Okay? Read. And next, sir, I will give you 1 minute time. I will open this chart and put it for you. You can read later. This section also I will complete and then I will do. Ditto copy paste to 209 search and seizure. No change. That is at the time of inspection. This is at the time of investigation. That only on the company. Here search and seizure of related entity books is also possible. There I have to give back within 180 days. Here I need not give back within 180. I can retain till the investigation is completed. 3 changes are there. Number 1, what is that section? 208. 209 search and seizure. ROC or inspector has a reasonable ground to believe that the books and papers of the company are likely to be altered, falsified, mutilated, secreted. He can enter such places where the books are kept and seize the books and papers belonging to the company, managing director, KMP, CS, auditors. Same thing is also there here. 3 changes are there. That is at the time of inspection inquiry. This is at the time of investigation. Second one, there search and seizure only on that company. Here I can also seize the books of related entities, these entities. Number 3, 180 days I need to give back. Here no restriction on 180. Till investigation completion, you can keep the books with you. That's all. We completed 219 and 220 as well now. 219 completed, 220 completed. Everyone understood the concept clearly? Ranger ZR, I am from Foundation. I got notification. Thank you very much. And Tadhastu, let's come to CA final soon. And CA IPCC result, new syllabus result was really appealing. Almost around 20-27% was given. Old syllabus I don't know, but new syllabus it was reasonably good this time. Okay, sir, I am putting the chart for you. If you have any doubts, you can read now. I am putting the chart. Start reading. 1 minute time I will give you. Read it. Please don't waste time. I am giving time for you to read once for all. Check all the points clearly. So let me clarify some doubts. Here special court permission not required. And next question, Amit Thapa, in 219 ordinary director covered or not? Not covered. Only influencing persons will be covered, like MD, managers. Next one, in section 220 is prior permission to retain BNP not required. Not required, sir. So hope everyone is clear to the issue up to here. Shall we continue? So see here. So now we completed 219 and 220. Now we are left out with 3 other sections. What are the 3 sections? 223, 224 and 225. 223, 224 and 225. Let's see what these sections are talking about. These are called as post-investigation procedural sections. What are these? Post-investigation procedural sections. Investigation completed. After investigation, what's next? If that be the scenario, this is the answer for that. Okay, see here. Inspector's reports. Report will be given. Sir, already report given, sir. That is inspection report. This is investigation report. This is what report, sir? Investigation report. Okay. Types of reports. Listen. Interim report, final report. Interim report will be given optionally only if it is asked by the government, or else not required. Final report must and should we need to give upon conclusion of investigation. It shall be signed by a common seal, or under Indian Evidence Act it should be kept with a public officer. Okay, online websites are there today for the public officer's website. There the document should be preserved, or preserved through a common seal of the company. Simply you need to remember 2 points here. There are 2 kinds of report: interim, final. Interim before investigation only given if ordered by the CG. Final investigation on conclusion you need to give. Both the reports must be authenticated. It should be in a written form. That's the idea. Okay, sir, I want a copy of report. Who can ask? A copy of report may be obtained by creditors, persons affected, members. Any of these persons can ask for a report. Common sense let us use now. So listen, let me first explain. After that you read. It will give immense clarity on the concept first. 220, 210 investigation, 214, all these sections are completed. Investigation is over. Report preparation done. Report interim final. Final on conclusion we will give. That report will be authenticated. That report we want a copy. Creditors or persons affected members can take. Report received by CG. CG has to take some action. Yes or no? What actions CG will take is a question now. If on the report I find that any directors of the company are guilty of a criminal offense, prosecution will be conducted against them. What will be conducted, sir? Prosecution will be conducted against them. See here, action taken by whom? Central government. On what basis? Report under 223. Any person who in relation to body corporate guilty of a offense, if he is criminally liable, on that person we will initiate prosecution, recover the damages, recover the property. That means if the assets of the company are misused by that party, we will recover damages and recover the property along with the damages and initiate criminal case against him. He will be sent to the special court. Sent to what? Special court. Report given. CG received report. In the report they found that frauds are there. That fraudulent person in the company will be subjected to a prosecution. We will recover damages from him, recover the property from him. Completed. This is said in section 224. Next, expenses of investigation. Listen carefully. Investigation conducted for 1.5 years. Satyam investigation 3 years it conducted. 2006 la case happened, 2009 la report given. How many years it has taken? 3 years fully. And one of the popular chartered accountant, Padma Shri awardee, T.N. Manoharan sir, he is one of the person who involved in the investigation of that particular case, and we are really Really, we are fortunate that one of the chartered accountant was honored with that honorable award. So the best, one of the best civilian awards our chartered accountant has also received. So really such a great person. So T.N. Manoharan sir, chartered accountant, he is also involved in that investigation proceeding. He investigated Satyam Company investigation till he is also one of the member, and his lead has helped to complete investigation more fastly. Smooth and fast investigation was completed because of his initiative. So anyway, investigation will be conducted for 2 years, 2.5 years, or 1 year. Satyam case now one of the biggest corporate scandal. Therefore, it has taken around 1 year time. Let's not take the case of Satyam. Normal company investigation, 1 year time. 1 year, how much expenses will be incurred? Inspector appointment, travel, conveyance, food, all expenses. First, government will bear. Okay? Expenses relating to investigation or in connection with investigation, first government will bear. After that, it will be reimbursed. Mandatory reimbursement. So, who will reimburse, sir? On whom prosecution is launched, that person will pay some amount. On whom damages recovery was launched, that person will pay some expenses. How much expense you need to pay, that will be decided by the tribunal, court. Recovery of property is made from some persons, that person. Company which is subjected to investigation, that company will pay some part. Person under prosecution, recovery damages, company or a body corporate on whom proceedings were brought, all these persons will share the cost of investigation. This is what said in 223, 224, 225. I will revise completely once again. Listen. 223 talks about the report. There are two types of report: interim report, final report. Interim report during the investigation, final report after the investigation. We will submit to the central government. On the basis of that report, any creditor or a member or a persons concerned can take the copy of that report. On the basis of the receipt of the complaint, if the central government is of a belief that criminal liability is also there inside the company, if there are any criminal offences that are conducted in the company, it will initiate prosecution, recover damages and restore the property of the company. Expenses of investigation will be collected first it will be paid by CG, later it will be recovered from the persons on whom initiation of prosecution is made, persons on whom recovery of damages and restoration of property is made. Lastly, the company which is subjected to investigation, that company will pay the balance. Answer completed. 223, 224, 225. As I said you, 215 completed, 210 completed, 214 completed, 219, 220, 223, 224, 225. All the sections are completed. Everyone understood the concept? Everyone understood the concept? Everyone understood the concept? Hello, everyone understood the concept clearly? Everyone in the class? Yeah. So we now completed section number 215, 210, 214, 219, 220, 223, 224. All these sections are completed now. Now what is still remaining for us? Look here. Next. Post investigation also completed. This is completed. This is completed. Miscellaneous. Listen carefully. Miscellaneous section. This question was tested 2 times in exam. I don't know what is so great about this section, but still, let us learn, because it was multiple times tested in exam. Protection to employees during investigation. What we said, when you are investigating into affairs of the company, managing director, manager, employees are also subjected to investigation. One of the key employee of a company, like a school child, fold the hands, sit straight, said all the wrongs about the managing directors. Am I clear? All the other directors are very serious about that employee. You are a Satya Harishchandra, you said all the information about the director. So therefore, let investigation go. These inspectors, they leave the company. We will show what we are. Like this, they try to do some intimidation on the employee who assisted the department in the investigation procedure. Therefore, law says like this: protection is there to to the employees of the company during investigation under section 210, 212, 213, 216, 217. Okay, sir, it's not 217, it's 219. Okay, 210, 212, 213, 216, 290. Any investigation, if employee assisted the department, employee assisted the government, that employee, because of the reason that he assisted, you can't remove them. By the mere fact of giving information, you can't remove. Misconduct, if there is any, you can remove them. We will not stop you. Just because of the reason that he served as a medium for us to investigate, don't remove him. Okay? Protection against what? Against what he is protected? Protection against dismissal, suspension, reduction in rank, change in terms and conditions. Dismiss him, totally send him, suspend some days, reduction in rank, demotion, not promotion, demotion, change in terms and conditions. Okay? Transfer to Simhachalam forest. Go there. It will be very good. Okay? 7 hills will be there. Go there, enjoy. Simhachalam hills are there. At that place, our forest ranger departmental office is there. Sit there every day. Change in terms and conditions for a disadvantage. Any kind which hurts the employee, you cannot take an action. However, you can take an action with the tribunal permission. If you want to take any action against such employee who assisted the government in investigation, procedure has to be followed. Observation required. Company applied to tribunal. Okay? Tribunal communicated within 30 days. What it communicated? It is in support of proposed action. That means it also said, take an action against him. Take the action. It said, don't take action against the employee. He is perfect person. Then accept the decision and make an appeal within 30 days to NCLAT. Okay? If a tribunal is not communicating within 30 days, silence taken as acceptance, take the proposed action. This is the answer for the given question. So let's see the question once again. Employees assisted the government in the course of investigation under section 210, 211 or 212, 213, 216 and 219. That employee is subjected to protection from dismissal and suspension, reduction in rank and change in terms and conditions to his disadvantage. Company must make an application to tribunal to take any action. Tribunal, if not communicating within 30 days, take an action. If it communicated within 30 days, take proposed action under this section. If it says not to take, accept and make an appeal within 30 days. Now one question. Tribunal, company, against the orders of tribunal, it can make an appeal. Then what employee can do? I am asking you one question. Answer my question first. Answer my question. There is an employee here. Okay? I am an employee. I assisted government in investigation. Company want to remove me. But section stopped the company to do. They applied to tribunal. Tribunal said, take an action. Now can I go for NCLAT? Can employee go to NCLAT? Remedy is for employees, remedy is for company. Answer is no under this section. Answer is yes under section 421. Under this section, employee cannot be protected within 30 days. He can prefer an appeal against the order of tribunal under section 421. 421. Then another section is there. According to that section, he can go for an appeal. Appeal cannot be made by employee under this section, but appeal can be made by an employee under section number 421. Okay? On this one, exam question is also there. That's why I am asking about this question. Why I am asking this is, there is exam question that came on this area. That's why. Sorry, next one. Legal advisors and bankers not to disclose certain information. So simple answer, sir. No need to even read. Just I will give you the summary. ROC, tribunal, ROC. See here. tribunal, central government, ROC, inspector. They can come for investigation. Employees, managing director, they can ask. But legal advisors and bankers need not disclose confidential information. Okay, they can tell the name of the client, address, but they need not tell what that person has disclosed to them. That's the importance of a legal profession, confidentiality. Okay, so that's the point. Next, voluntary winding up, not to stop investigation. This was tested one time in exam. Listen, what is this? I will explain. Okay, this will be understood only if I explain, or else you cannot. See, this is the answer here. You can read the answer later. Let me first explain the concept. Listen. Investigation application reached NCLT. Investigation started. First investigation is there, second 241. First 241, second investigation. First investigation, second winding up. First winding up, second investigation. Like this you need to read. Okay. Already investigation started. Okay. Central government is going on doing the investigation. At the same time, investigation is going on. Some members of the company want to apply to the tribunal under 241 for oppression mismanagement. Can they file a application when there is a pending investigation going on? Question number 1. Second, already 241 is taken by tribunal. At the same time, investigation petition is received by the CG or by NCLT, whatever the case may be. When already NCLT is freezed with the oppression complaint, new investigation can be taken. Question 2. Question number 3. Investigation going on in progress, same like oppression. Here winding up petition received. Here first winding up petition already received, later investigation proceeding started. Now the question is, can both of them run parallelly? That means when investigation is going on, 241 and winding up can go. When 241 and winding up is going on, can investigation applications can be conducted or can it be continued? Is a question. Answer is, nothing will stop another. Parallelly everything will run. Okay. New investigation may be initiated irrespective of existing winding up proceedings. Fourth case. See here, I will read all the cases. Fourth case. New investigation may be initiated irrespective of existing winding up proceedings. Fantastic. Next. New investigation may be initiated irrespective of existing oppression. Second case. Existing investigation shall not be stopped or suspended due to new winding up petition. Case 3. Existing investigation proceedings shall not stop due to new oppression or mismanagement petition. Case 1. Game over. 226 is also completed. So we now completed sections 218, 227, 226. What is the set of sections I said you? What is the set of sections I said you? 218, 227, 226. 228 also I said. Okay? 228. Simply 228 says that investigation chapter is applicable not only to Indian company, it is also applicable to foreign companies. Answer completed. 229 penalty chart, just it's a penalty provision. So we now completed the following sections. 218, 226, 227, 228, 229. So now if you refer to the list of sections that I have given you, what we completed? We completed everything in investigation chapter except 3 sections. 211, 212, 217. 211, 212, 217. These are the 3 sections which we have to cover. Okay. Now listen carefully to the agenda. Sir, investigation chapter la section 216 onwards we started. It's now 3-6 time. Give me 5 minutes. I will revise whatever we have completed till now. Just in 2-3 minutes. Okay. From page by page I will go into this 206 section. Okay. In the sequence la first 216, 222, 213, 221. Okay. 216. Investigation to the ownership of the company affairs. If on any person's complaint the central government receives an application that the affairs of the company is mismanaged, that means I am talking about membership, to know about the persons who are factually and truly involved in the success and failure of the company, and to know about the persons who are able to control and manage the company affairs and the beneficial owners, we will conduct investigation under section number 216. Central government will appoint inspectors to conduct the investigation. 222 section says that restriction or imposition or restriction on the securities. Tribunal can impose that stay order on the basis of 216 or by representation made by any person. Restriction will be for a maximum period of 3 years on the securities of a company. It can be security, it can be debenture, it can be share, anything. 213 is a remedial section for section number 242. Application must be made to the tribunal. Application may be made by a certain number of members or by any other person. Members means 100 members or members only, not less than 1/10 of the total voting power, or by any other member or otherwise can make a complaint. If complaint is made by a member, any good reason supporting evidence, and if that be the complaint made by any other person, they should prove that the business is carried on for fraudulent or unlawful purpose, business is carried on to defraud creditors, or business of the company is oppressive, or business itself is formed for fraudulent or unlawful purpose, or the company is not providing proper information. Like this, they can make a complaint and they can apply to the tribunal. Tribunal will ask central government to conduct investigation. Report will be forwarded to tribunal. If there is a fraud, action under 447 will be taken. 222, freezing the assets. Same section, tribunal will have the power to order a stay order for freezing the assets of the company on the basis of report from CG or 241 or inspection or creditors outstanding 1 lakh, or any other person can make a complaint to the tribunal to initiate a freezing order on the assets of the company for a period not exceeding 3 years. Next. 221. After that, 206. Company files certain information with the ROC. ROC opined that certain information is further necessary. He will issue a written notice to the company to supply all the other required documents. Present and past officers and employees of the company are having a duty bound to submit all the information expression to the ROC within the time specified. If this is not supplied within the reasonable time, or it is inadequate, or if it is found that it is unsatisfactory, he can conduct inspection on the accounts, inspection on the books of accounts of the company. Inquiry starting will be done. Why inquiry? On the basis of information received from any other person, or the basis of information furnished or representation made by any other person. If the ROC is of a intention or is satisfied that the affairs of the company are for fraudulent or unlawful purpose, are not in compliance with the act, or grievances of the investors is not properly addressed, he can conduct inquiry into the affairs of that particular company. This is 206. Okay. 207, powers of ROC. ROC power will become others' duties. They will be duty bound to give all the information explanation, and he can take the copies of the books and papers, and he can also place identification marks. 207, and he has the powers of a civil court, summoning and enforcing the attendance of a person, examination of, discovery and production of documents. 209 section says that search and seize up during inspection, where the ROC or a inspector has a reasonable ground to believe that the books and papers of the company are likely to be destroyed, mutilated, altered, falsified or secreted, he can enter such places where the books are kept and seize the books and papers of the company or KMP or auditor or CS, and he can retain for a period of not exceeding 180 days. While giving back, he can take copies and place identification marks. Answer completed. 207, 209. Next, after this, 208, report will be forwarded to central government recommending investigation. 215, inspector should be individual. 210, there are 4 modes of investigation. Central government can order investigation, may order investigation on the basis of recommendation of ROC or on special resolution or a public interest, and shall order investigation on the instance of the tribunal. 210 section is completed. 214, security. First case, second case, special resolution. Fourth case, applicant to tribunal. In these 2 cases, security of payment of not exceeding 25,000 required, refunded back if it is resulted in prosecution. 214 after 219, related entities. Not only our company, we can also jump into the related entities, group companies, holding company, subsidiary to the holding company, or any other body corporate which is managed by the managing director or manager of our company which is under investigation. Okay, or any company, any body corporate which is accustomed to act in accordance to the directions or instruction of the managing director of this particular company. And the last one is manager, employee and managing director of this particular company will be subjected to investigation. 219. After the 220, search and seize during investigation, same concept is there. 220 after 223, 24, 25. Report will be given under section 223, interim and final report, interim before and final after the conclusion of investigation. 224 section will be taken about the action to be taken on the basis of inspector's report. Action will be taking off in the form of prosecution, recovery of damages and restoration of property. From them only the cost will be recovered back. 225. After the 226, 227, just now we read, this is the chapter. Okay. Why I am telling this is 211, 212, 217. These 3 sections are lengthy sections. At the last I will cover such that In this meanwhile, next 3 hours I will complete all the remaining concepts of the Companies Act. Then we will be left out only with 4 missing concepts. Class actions 211, 212, 217. Big concepts na. Rather than spending time on this, in the next 3 hours, it's now 3:10 almost. By 6:15, I will be covering all the concepts of Companies Act. Okay, small areas are there na, NCLT, NCLT, these type of issues. I will be covering all those things. Let's start with that. Lastly, we can take big concepts and cover. Rather than completing one big concept, we can complete all the remaining concepts of companies. Sir, up to here, everyone understood the concept clearly. So the revision of all the concepts that are done till now, everyone. Okay then. So thank you very much. Next one. Next one. So let's keep a halt for this. Instead of covering those 3, we can complete remaining. Those are big concepts, na? So let's complete small ones first. Now listen, sir. In our syllabus, so we completed these concepts. Just a minute. Yes. Types of companies. Let us start with all the 4 kinds of companies. Okay. Let us start with all the 4 kinds of companies. What are the 4 kinds of companies? 4 kinds of companies will be government company, foreign company, nidhi company, dormant company. All the 4 kinds of companies let us complete. After that, 4 companies completion, we have a concept called as registered valuers, 5 minutes. Removal of names of the company from the register, another 10-15 minutes. Miscellaneous provisions, another 5 to 10 minutes. Like that, if you complete, everything will be closed very clearly. Okay. So with that intention, let us start with government company concept. So government company. Okay, government company. So what is a government company? Government company means a company in which not less than 51% of the paid up share capital is held by central government or state government or multiple state governments or a combination, and includes subsidiary of such government company. From this definition, what you can understand, to be a government company, first in that company, either public or private company, either CG or SG or combination or SG CG combination, has to put some amount which is equivalent to not less than 51% of the paid up share capital. Like that, you can become a government company. Or second option is also there to become government company. If you are a subsidiary to a government company, automatically you will become government company. That means you need not even check how much capital is there. If you are a government company, yes, your subsidiary is automatically a government company. Okay, that's the idea behind the definition. So a government company means a company in which not less than 51% of the paid up share capital is held by central government, state government, multiple state governments or combination, and subsidiary. In classroom, we will do 10 illustrations on government company. That I cannot do now and waste your time. Therefore, open that notes and check the illustrations later. But overall revision we need to do now. This is a concept. Government company, first it should be a public or a private company. In that public company or a private company, I repeat, in that public company or a private company, government should put some capital which is minimum 50%, 51% of the paid up share capital. Then I will call that company as a government company. Next. Government company, along with annual return, must provide annual report. Means what? Annual returns are filed with MCA. Annual report is put before Parliament or state legislature. Okay. First, there are two sections, 394 and 395. In 394 and 395, one content is common, 2-3 points are uncommon. I divided in that way. First, listen, everyone. Sir, every section can be tested in exam. Don't underestimate government company concept. If you leave this, these only will come in exam. May 2017, 4 marks question was asked on government company. Very next time, another 4 marks came from annual reports. Please don't neglect any chapter. Revision, everything is equally important. See here. See here, sir, everyone. So, government company. 394, 395. 394 covers government company where only CG is a member or CG plus SG or SGs is a member. 395 covers SG or SG members only without CG involvement. Okay. Therefore, see here, common content. In both the sections, common content is there. Audit by normal stat auditors, along with that supplement audit will be conducted by C and AGI. Obtain the comments. Prepare an audit report under 143. Audit report under 143. Along with this report, audit report will be again prepared. Okay. And prepare an annual report on working and affairs of government company within 3 months of AGM. AGM is conducted within 3 months of AGM. Prepare an annual report on the working and affairs of that government company. I repeat once again. Audit will be conducted. Normally, company audit will be over. After that, C and AG audit will come. They will conduct audit. They will write comments. Normal audit report under 143 will be done. That report will be there. Everything will be analyzed and an annual report will be prepared. That annual report will be prepared within 3 months of AGM. After that, 394 section. 394 la only CG is a member. Put it in the Parliament. Only CG and SG is the members. Put it in the Parliament and both state legislatures. Only SG or SGs, state legislatures. That annual report should be placed before state legislature. Answer completed. That's all. So, let's revise everything. Government company means a company in which not less than 51% of the paid up share capital is held by CG or SG or SGs or combination, or by becoming subsidiary to a government company. Common contents of 394 and 395. First, in all the two sections, 3 points or 4 points are common. Audit by C and AGI, obtaining comments, prepare the report under 143, and prepare an annual report on overall basis of the working within 3 months of AGM. Later question will change. 394 lo only CG is a member. Put that annual report before Parliament. CG plus SG, Parliament and state. Only SG or SGs, state legislature or legislatures. Completed. We completed a chapter, government company. Everyone, comments please. Understood the concept? So types of companies la 12 marks will come in every attempt. Average 12 marks will come. MCQ la 3-4 marks. Normally 2 questions. Nidhi and foreign will come generally in descriptive. Government and dormant will go for objective. Or sometimes interchange will be there. But 12 marks you can expect from these areas. Srinivas Gadi. It's not like revision, but it's like regular class. Thank you very much. Srilu Narapareddy, how you got control over company law? It's an insult here. How you got control over company law, you should not ask. How you got control over law, you should ask. Not company law. Next. Yeah. Thank you. So, after this government company, next we need to start with companies incorporated outside India. Companies incorporated outside India. Sir, anyway, so just 5 minutes, please give me. One question was a subsidiary of government company is also a government company. Yes, because it's a subsidiary first. Subsidiary definition la below how many subsidiaries are there? Everything is a subsidiary, na? It is also a subsidiary. Okay, sorry. Before we start with this, everyone please listen. Everyone, sir, please listen. Yeah. Just let me show you the question bank that we have prepared. It was under preparation. Another 4 chapters are still required to be cleared. Once that is completed, it will be out. Let me first to show you the insights of this question bank. Okay. The point is, it will be having the highest number of compilation of institute past questions, RTPs and mock tests. Okay. Generally, the thing is, I try to make it ultimately perfect as possible every time. Every time, whatever the work that I have to do, I try to put on a level of ultimate perfection. Okay. Therefore, previously I don't have a time to appear before the YouTube and take sessions. So sometimes I would take, sometimes it is not possible for me to take because my clients, so many NCLT cases are pending, we need to deal. Classes are there, health disturbances, I got COVID at that time. Sorry, everything happened. Okay, all the circumstances sometimes affect a person negatively. At the time it affected negatively. Sorry. After that, when the works are all completed, to be very free in the session, now the classes only are there. All the pending cases we have cleared in NCLT. Over. So at the time I got one idea, why can't to prepare a question bank? Last 2 months, continuously for around 5-6 hours every day I put an effort to prepare the question bank in such a way that it becomes the best in industry with regard to the question bank compilation. From 1988 onwards I took the questions, CA questions, answered according to the current guideline answers. Okay, at that time provision I don't care. According to relevant provision today we have to do. Recently when a question came for 8 marks in exam from managing directors, ditto 1996 question, I will show you when we come there. 1996 one question came for 8 marks. Same question was copied pasted with a change in numbers, change in names. At that time I got it out. We have to go back. Okay. When you are reading latest RTPs, those questions are not coming. They are taking the essence of very old CA questions. Therefore, with that intention, I compiled a textbook. I compiled compilation on directors, all the concepts. 4 chapters are still remaining. Okay. 1 week it will be taking. In that 1 week we will be completing everything. But directors concept, I am not talking board meetings, board powers or managerial remuneration. Only directors, 149 to 172 sections. These are the set of 24 sections. From that, expect how many questions would be there. Expect how many questions would be compiled. How many questions will be there in that 24, 22 sections? See here, totally there are, you can check with any other present question banks available in the market. Take it for granted. Any material, I am not telling about anyone. Anything in India. Anything in India. Okay, let me show you this. Only on these directors, (122) questions were made, including CS June 1996, 1998 question. And how the presentation was made, ultimate perfection. This question, for suppose it came in CA final November 2019 exam. Okay, like this, all the questions. So presentation, first I need to show na. For example, let us take randomly one question came. Due to internal problems in the working of Messrs. Infighting Detergents Limited, Mr. Sachin, the executive director, something. Resignation concept. May 2001 question. How to write in exam presentation? You need not ask presentation on me. Read this properly. First, we need to always, when the valuer is valuing our paper, he will check whether you have a legal clarity. Means what has been said in the law. Do you know or not? He will check that first. Point of law. Point of law. First 3 points. Later conclusion. Since this is a 4 marks question, 2 points are enough. Point of law, conclusion. Another question is there. Point of law, conclusion. So it's 8 marks answer. We need to present very clearly in point wise format. Not like institute RTP answer, big paragraph. So we have to first divide the answer. It should be very clear and visible to the person reading it. Okay, not just this randomly. I am scrolling it. Let it stop at some place. Take this. First, one question was tested. November 2001 question. Meaning of small shareholder we have written. Procedure for appointment. This big procedure we have to write. Alternative procedure completed. Randomly let it go. 1 second. Scroll. Okay. See here. 2 questions were tested. November 1996 one question came. Same question came in 2008 again. That means 1996 question was again retested in 2008. So this is on additional director. First we need to write this. Write this. Analysis of the case and conclusion. This is the conclusion. Like this, everything was made. All attempts were made to make it 100% perfect with regard to the current analysis, current scenario of the institute. In a point-wise fashion, it was divided. All the chapters except 4 chapters, everything was already prepared. Take it for example, this is with regard to the director's concept. Okay, just because director's concept is the first one we started. Next, board powers, managing directors, like that it will start. In board powers, there are around 185 questions that are compiled from 1988 onwards. Managing director section, let us take. Okay, I will show you one thing. Just wait a minute. See this? Topic is on 197 and Schedule 5. 197 and Schedule 5, I compiled 35 questions on 2 sections. 197 and Schedule 5. May 2016 one question came here. See here. May 2016 one question came. International Technologies Limited, like that. Commission at the rate of 5. Directors other than managing. July 21. Latest attempt. Same. International Technologies, Innovative Intelligence. Listed company. Being managed. Commission 5%, commission 5%. Directors other than. Kamal became Sharma here. That's all. Answer. 8 marks question. We have to write like this. 2002 modified question. See, this is amendment provision, by the way. This is amendment. According to the amendments, I have given the answer. This is latest amendment applicable for December 21 exams. This question answer is different in the last attempt. This question answer is different in the present attempt. Okay. So this is the answer. So like this it was presented. 1996 one question came. 2005 same question came. This is how it was presented. 1999 May attempt question. How many questions we compiled, sir? Managing directors la. Check any material available in India. Okay. Check anything in India. It has 61 past exam questions. Okay. Note it. 61 past exam questions. See here. These questions. Everything. I didn't leave even a single point. Presentation is clean. How to write an examination in the same way. See here. 2003 la one question came. Again it came in 2019 November. Okay. So this is how the questions are being tested. So similar questions will come, sir. That means once you read the question bank completely, you will get a confidence. Okay. Presentation will be like this. How to present in examination. Sorry. In this, how many questions will be there means I already said to you. The most important thing in the question bank, what I felt to prepare is, see here sir everyone, this is CMA December 2015. If any new questions are found there, I put that. ICARTP, this is the main thing. Self-made illustrations wherever question is not tested. The main quality of the question bank is, in many of the cases, the problem with the students is, when a question is already given in RTP, MTP, they will write. If a question is not at all tested in exam till now, if a question comes like this, what is his position? Therefore, whenever a question is not tested in exam, I created a deadliest question on that as a self-made illustration. Compensation for loss of office is not tested properly in exam. Standard is not there in the examination. Therefore, I prepared one worst question. If 8 cases are given like this, 1, 2, 3, 4, 5, 5 years are there. If we resign at end of first year, second year, third year, fourth year, fifth year, between 2 and 3, between 3 and 5, between 4 and 2, what will happen? Answers were given like this. Okay. Special aspects of Companies Act. Just now we completed. These are all compromises, arrangements topic. Investigation, inspection chapter will be there. Na? 47 questions I compiled on only investigation chapter. Another 8 questions I got newly. I will add those into the material. This is how you need to write. ICARTP, May 2016. This is the question. See here. Already we completed just now. Na? See here. See here. A notice was sent to Mr. Left by registrar to furnish the information relating to the business transacted during his tenure in X company. Mr. Left ignored the notice considering he is no more an employee of the company. Registrar issued a summons against Mr. Left. So we have to write like this, where such explanation relates to past period, officers who had been employment, past officers and employees must also give. This is a law saying, this is a conclusion to the answer. Did you understand the concept, everyone? Okay. So totally we are trying to cover totally 936 questions only on company total syllabus. Case based MCQs will be there. 150 questions are kept. And MCQs, there are around 900 MCQs totally. That means the book will be compiled to prepare 3000 questions totally. Okay, totally everything put together, a 3000 questions compilation will be there. Practically these descriptive questions will be running into around 930 questions will be totally compiled. And answers given like this for all the questions. Whenever a similar question comes, a common answer will be provided. This is on investigation. Another 7 questions had to be added to this inspection. 55 questions will be there in inspection investigation chapter. Okay, sorry. Like this, everything will be types of companies. If you observe in the types of companies, foreign company there are around 33 or 31 questions, something like that. 31 questions are there in foreign company. Government company anyway, small chapter, 3 questions will be there, 4 questions will be there. Very, very important Nidhi company chapter. Nidhi company chapter, if you observe the screen, just 5 minutes sir, I don't want to waste your time, please see here. One question came in May 2018. One question came in May 2019. Okay, see this. Nidhi provisions had undergone tremendous amendments in the recent times. In spite of amendments, no great questions were tested in exams or in the revision test papers. Therefore, I have personally analyzed all the rules with respect to Nidhi and provided self-made questions on each possible rule reaching the standards of ICAI and beyond even that. Okay, so if you want to check, just a minute, see here. There are 24 rules amended today for Nidhi, but no question was tested till date. That means in the next attempts, these 2 questions will not come. That means if you prepare these 2 questions and go to exam, we become the biggest fool on the planet. Then how the questions will be tested? Like this. This is on exemptions to Nidhi. 5 questions on incorporation, nature of Nidhi, paid up capital and objects of Nidhi. Like this, all the questions were made up. Slightly I increased the standard of the questions. 10 questions in one single set of Nidhi. This question was taken live from Maban Nidhi Limited, one of the Nidhi company in India, the biggest Nidhi in India. So 10 different kinds of questions. This is another question that I framed. What I framed is, if at all a question has to come, any of these points will come. I don't tell that exactly this will come in exam. But if you do all the questions, there is no question in examination which can come from Nidhi beyond the book. Any time, any person can ask the question only in that way, if it is a legal provision. And all the Nidhis taken are real Nidhis in India. Names that are taken from MCA website. Kalaimagal Mutual Benefit. This is on post office deposits and concurrent deposits concept. So how to calculate the net owned funds and whether qualified investments are made or not on this. This concept is on auditors. This is on depositors list. This is entire question. Like this, I prepared 28 extra questions on Nidhi, covering all the concepts applicable for exams. Okay. These are the efforts that were put in the last 2 months totally. Okay. Last 2 months, those are the efforts that we put. So details of all these things I will anyway put here, and I will also conduct a question bank revisionary session like live like this, and we will be covering out all the important questions in that particular material. Okay. So that's what I want to tell. See here. So the company is incorporated outside India. So the company is incorporated outside India will be called generally as a foreign company, but it is really not the correct idea. Definition of foreign company. Let's have a glance. See here. Section 2 clause 42, definition of a foreign company. First, to call something as a foreign company, first it must be incorporated outside India. Not just incorporation outside India, place of business must be there in India. Incorporation outside India, place of business within India. That place of business may be, that business may be done by itself or through agents, whether physically or electronically like Amazon. That means 2 conditions are to be cumulatively satisfied by a foreign company to become a foreign company. First, incorporation must be made outside India. Business must be conducted in India. That business can be conducted either directly with its own name or in the name of agents, either physically or electronic mode. Physical means stores will be there. Electronic means through website they will sell. So Amazon is a classic example of electronic mode. Naptol is there. All these things are telemarketing, telemarketing or TV marketing, mobile computing, cloud computing activities, web pushing, all these will come under electronic mode. Electronic does not mean internet. Any medium of electronic. Any electronic media will be covered here. So 2 conditions ought to be satisfied to call something as a foreign company. Company must be incorporated outside India. Place of business must be there within India. That place of business can be there either by itself or it can be through the agents. Okay. That can be taken either physically or electronic mode. Then we call it as a foreign company. So what is electronic mode? Electronic mode means electronically based transactions or activities. Main server location is irrelevant. On that last attempt one question came. Jan 2021 one question came. Server is not in India. Server is installed in Dubai. Who asked you about server? Are you providing electronic services in India or not? Yes, that is important. Location of main server is not important. It may be located in India or it may be located outside India. Okay, it may do business to business, business to customer. Okay, electronic data interchange, any kind of electronic transactions it makes, including email, mobile devices, social media, cloud computing or anything. Electronically are you doing? Yes. Main server location is irrelevant. It can be in India, it can be outside India. It will be called as a foreign company. So, summary. Foreign company means a company incorporated outside India, having a place of business in India, That place of business can be carried on either by itself or through agents, whether physically or through electronic mode. Electronic mode, electronically, anything you provide, it will get attracted. Cloud computing, smart computing, social media, mobile devices, any mode attracted. Main server may be in India, main server may not be in India. Completed. This is what said in the foreign company, the first part. So listen carefully to the logic, sir, everyone in the class. We now completed the basic definition regarding foreign company. Next. Next one. Application of Act to foreign companies, section number 379. Application of Act to the foreign company. Sir, what is this application of Act to foreign company? Let's try to understand. Generally, Companies Act 2013 is applicable only to Indian companies. However, if some conditions are satisfied, it is also applicable to foreign companies. Okay? So therefore, what they said is, companies are broadly classified into three parts. This concept, please everyone listen carefully. I want every one of you, please present in the class, everyone. See here. There are three kinds of companies. Companies incorporated outside India. Second case. Companies incorporated outside India having place of business in India. Number 3. Companies incorporated outside India having place of business in India and there is majority Indian holding in this incorporated company outside India. Company incorporated outside India. Company incorporated outside India with place of business in India. Company incorporated outside India with place of business in India with majority holding, Indian holding. If it is a company incorporated outside India, no place of business, it's only a company incorporated outside India. In such case, 387, 388, 389, 390, 391 will apply. If it is a company incorporated outside India with place of business, because of CIOI, all these will apply. 387 to 391 plus. Because of having place of business, it becomes a foreign company. Because it is a foreign company, this entire chapter will apply. 379 to 386 plus 392 and 393. That means entire chapter will apply if it is a foreign company. Next. CIOI with POB with majority Indian holding. CIOI, because of becoming CIOI, 387 to 391. Because of this, 379 to 386 plus 392 and 393. And because of majority Indian holding, such other provisions will also apply. Government has to notify that. It didn't notify till now. So, there are three kinds of companies in this chapter. Just a company incorporated outside India without POB. Company incorporated outside India with POB. Company incorporated outside India with POB with majority Indian holding. These are the provisions applicable. This is what he said. Now the real question comes. Sir, what do you mean by that majority Indian holding? That you need to understand here. Okay, listen. Where not less than 50% of the paid up share capital. That can be either equity or preference or partly equity and partly preference. Of whom? Of a foreign company is held singly or aggregate by Indian citizens or by Indian companies or body corporate or a combination. Simply, there is a foreign company. That foreign company's substantial capital, 50% capital is held by Indian persons, either citizens or body corporate. Such foreign company comply with the provisions of this chapter, entire sections, plus such other provisions as if it is a Indian company. As if it is a Indian company. So technically what that section says is, where not less than 50% of the paid up share capital, whether equity or preference or partly equity or partly preference of a foreign company is held by one or more citizens of India, or one or more companies or body corporate incorporated in India, or a combination, such a foreign company shall comply with the provisions of this chapter and such other provisions of this act as if it is a company incorporated in India. That means if it is a majority Indian holding is there, as if it is an Indian company, such other provisions will also apply. Government didn't notify anything. If it notifies, those also will apply to such kind of significant foreign companies. Okay. So summary is, if you are a foreign company, 379 to 393 apply. I am only CIOI. Since you are not a foreign company, 387 to 391 will apply. If you are a foreign company plus majority Indian holding, along with entire these topics, such other provisions as central government notify will also apply to you. Sir, everyone understood 397, sir? One small review, everyone. Understood the concept of 379? Everyone? Everyone in the class understood the concept clearly? Up to here. Okay. Next. So we completed section number 379. So 379 section is completed now. So 379 section is applicability of this particular act to the foreign companies. Okay, that was completed now. Next issue. Documents to be delivered to the ROC for having a place of business. Listen, if I want to start a company in India, there is a section called as section 7, which will be talking about procedure for incorporation. But now I am not starting an Indian company. Foreign company already incorporated, place of business has to be established in India. I will repeat, I want to start an Indian company. Section 7 will provide how to incorporate. But I want to have a foreign company to establish place of business. What is the procedure? Section 7 does not apply. Section 380 will apply to that. Section number 380. First, a foreign company came to India. Searched location. They found that we start in Hyderabad. Establish a place of business here. After establishing a place of business in Hyderabad, what it has to do? Then the real story will start. Then what it will do is, it has to submit some documents to ROC within 30 days. Within how many days, sir? Within 30 days, it has to submit certain documents. What documents it has to submit? Check here. Charter, statutes, MOA, AOA and other instrument defining constitution. Charter, bare act of that particular company. Charter means incorporation certificate of that particular company outside India. Statute, the bare act and other provisions incorporating that company outside India. Their memorandum, their articles, any other relevant instrument incorporating the company. All about foreign company. Submit those. Okay. Enough. That company is incorporated in India, outside India, outside India. Full address outside India. Having principal place of business in India, full address here. Did you come to India, went to USA, again came to India at any time? That means this is the first time you are coming to India to establish POB, or already one time you came, you went back, again you come. No sir, this is first time. Then not required. Or else you need to give the details of opening and closing in the earlier occasions. Okay. Next. A very, very important point. Listen. Foreign company is a company incorporated outside India. Place of business will be there in India. Okay. That means incorporation, if it is happening in India, registered office will be there in India. If registered office is there in India, registered office is a place of communication. That means if anyone want to communicate with the company, you have to communicate to the registered office of the company. You have to communicate to whom, sir? Registered office of the company. I repeat once again. Incorporation in India. That be the case. Registered office will be there in India. If registered office is there in India, advantage is any person who want to communicate with you will communicate to RO. Now take a scenario. GST Commissioner in Hyderabad want to issue notice on a foreign company in India. Okay. Now, registered office of that company is where? It is in USA. You will send to USA, na? GST officer in India will send a notice to America, and that person will give a review and reply about GST in India, na? Nonsense. Therefore, one Indian representative is required. That name of Indian representative you need to give. That representative must be a resident in India representative. Clear everyone? And you need to give a declaration that directors are not debarred from accessing the management of any company in India or abroad. That means no misconduct on the directors. And a list of directors and secretary. That means you have to give their details, name, father name, email ID, nationality, PAN, etc. etc. These are chatta concepts. Mainly the concept we need to understand is charter, statute, MOA, AOA. Outside India address, within India address, opening, closing early, and representative in India, declaration that they are not convicted for any offense. Chapter close. Now filing with ROC. All these documents you need to throw on the face of ROC using a form called as FC1 within 30 days of establishing POB. Alteration made in the details. I changed Indian representative. We changed directors. Then everything will change or not? Changes will be given in FC2 within 30 days of such change. Okay? Every foreign company shall file with ROC in form FC3 along with the financial statement list of all POBs in India. In India, how many places of business is there? Principal place is in Hyderabad. I have business in all the states. You give the details of all your places of business in India. Okay? Summarize everything. 380 section will be talking about filing that is mandatorily to be made by a foreign company. Foreign company only. Okay? So, charter, statutes, MOA, AOA, full address outside India, full address within India, particulars of opening and closing, names and addresses of the Indian resident, and declaration that he are not convicted, and some other basic personal details of directors and secretary. Furnish FC1 within 30 days, alterations FC2 within 30 days of alteration, and place of business you have to file along with financial statements. Completed. So, this is the idea behind this particular concept. Hope everyone understood the logic clearly. So, listen carefully, sir. We now completed section number 380 of the Companies Act with regard to foreign company. So, two sections are there. We will tell the two sections and then we will take a break. Okay. So, break is now only for 15 minutes. We will take a break and come soon and attend. We will complete all the concepts like this. 15-20 minutes, fat, each chapter will be completed. Okay. Let's start. See here, sir. Everyone please. Accounts of a foreign company. Accounts of what, sir? Foreign company. Foreign company has to prepare accounts in India. For its Indian business, it has to prepare. See here, everyone. Every foreign company shall prepare balance sheet to P&L in accordance with Schedule 3. Sir, my accounts there outside India will be not in accordance with Schedule 3, sir. At least as near as possible to Schedule 3 you need to prepare. Okay. So, the financial statements must be in accordance with Schedule 3. If impractical, at least as near as possible to Schedule 3. 9. Financial statements, you have to attach board report. You have to attach auditor report. You have to attach other statements. Attach documents required to be annexed under Chapter 9, Accounts of Company. Start from the beginning. P&L balance sheet should be accordance with Schedule 3, even for a foreign company. So, not possible, sir. Near to Schedule 3. Okay, point 1. Attach all the documents under Accounts of Company Chapter 9. If the company which started its place of business in India, okay, it is having a parent foreign company which is already submitting CFS to its authority, that should also be filed with the ROC in India. Why? Comparison. What is its performance globally? What is its performance within India? And for reconciliation purposes, I repeat, prepare standalone P&L and balance sheet in accordance with Schedule 3 or as near. Attach all the auditor's report, etc. India law audit should be conducted, audit report. And the CFS of the parent foreign company submitted in its country, attach. If they are not in English, translation into English must be made. Okay, if they are not in English, translation into English must be made. Sir, I prepared accounts. To whom I should file? See here. Every foreign company shall, along with the financial statements, attach the following documents. These are called as special statements. Along with the P&L, balance sheet to consolidated accounts of company attachments, three another attachments will come. Statement of related party transactions. Statement of related party transactions. Means what? Related parties will be there in section 188. If there are any related party transaction, give the details. Repatriation of profits. Means what? Profit come to KFC in India. It will be used for corporate social responsibility within India. Na? They will take their money back. Repatriation means taking back. In FEMA revision class, we will do that. So, statement of repatriation of profit. Statement of transfer of funds means what? From your home country, how much money came, how much money went. How much money came, how much money went. Everything. Not profits, fund, total fund. Okay. Audit will be conducted like in India by a CA, individual or a firm or a LLP. Summarize everything, and you need to file the financial statements within 6 months from the date of financial year, from the end of financial year. Financial year ends within 6 months you need to file the financial statements. See here. Prepare P&L balance sheet according to schedule 3. Attach accounts of company, all the attachments. CFS attachment. English language, if it is not there, convert it to translate to English. File within 6 months. Along with financials, you need to attach some statements. Related party, repatriation, transfer of funds. Audit, same as an Indian company. Answer completed. This is all about section number 381. Concept is on accounts of a foreign company. Okay, that is a concept. We'll do one thing, take a small break and come. A 15 minutes break. It's around 4 o'clock. 4:15 exactly we will start with the session again. 4:15 to 6:30. See how the miracles will happen. 4:15 to 6:30. 90% will be completed. Take a break and come soon. So shall we start again? So everyone, please come fast. We have to do small chapters. Muhammad Samir Pasha, you came, huh? I'm very glad that you didn't sleep in the class today. So let's start with the concept. So let's start. Display of name etc. of a foreign company. So what is this concept? Let us try to first understand. Every foreign company must display certain things very legibly, conspicuously, such that all the others can see that clearly that it's a foreign company. Okay, what disclosures it need to make? There are 3 points totally. Okay, 3 points are there. What to display, where to display, mode of display. What to display, what I have to disclose? Name of your original company, the country where you are incorporated, the liability of the members is limited, the fact that it is limited. 3 displays you need to make. 1 second, just a minute. Sir, everyone please participate. Fast. Continue. Come to the live, everyone. Next very important chapters will start, sir. After the types of companies is completed, NCLT and special courts is there. Very important chapter. So please everyone, come fast. So see here. Display of name etc. Not only name, other things are also to be displayed. What are those? Name of the company, liability of the members if it is limited, the fact that it is limited, and the country of incorporation. We need to display all these 3. Where to display? It should be displayed outside every place of business. That means board or sheets, whatever the case may be. In all publications like business letters, billheads, notices, etc. and prospectus. What to display? Name, country, liability. Where to display? Outside place of business. Business letters, billheads, official publications, etc. and in the prospectus. How to display? What is the mode of display? It should be displayed in English language, number 1. And if the place of business is in Hyderabad, local language will be Telugu. You also should give in the languages generally in use in the place of business. You can give in Hyderabad in Hindi and in Telugu. Hindi and Telugu are the 2 languages we use here. So both the languages you can put. Okay. So this is a general concept only. Next. Service on a foreign company. So what is this section? Simple section only, listen carefully. Foreign company don't have registered office in India. It has registered office outside India. Therefore, to whom we need to send the notices for a place of business within India? To the person whose name and address has been submitted under 380. If you remember, under 380 section, we will submit the detail of a representative or not. To him, if you send the document, it is deemed that it is served on the foreign company registered office outside India. Okay? See here what he said. Any process, notice or other document which is required to be served on a foreign company shall be deemed to be sufficiently served if addressed to person whose name and address have been delivered to ROC under section number 380. Simply, to the representative in India, if you submit the document, it is deemed that it is submitted to the register office outside India. That's all. This is all about section number 382 and 83. See here, sir, one second. 242 definition. 379, 380, 381, 82, 383, 384, 385, 386, 387, 388, 389, 390, 391, 391, 392, 393, 393A. These are the sections. What we completed, 242 completed. Okay. Oh, it is not visible for you. Sorry. Anyway, 379 we completed. 380 completed. 381. 242 definition. 379, 3 types of foreign companies. 380 giving the details to ROC about the place of business and other details. 381 accounts completed. 382 display completed. 383 service and foreign company completed. Now what are the sections to cover? Next settler, 3 topics we need to cover. 384, 385 and 386. Once that is covered, remaining concepts will be a continuity in flow will be there. Okay, let us see what they are. 384, 385, 386. Next target. Exactly 5 to 8 minutes we need to spend on this. Listen. What is this? Let's try to understand. If you are a foreign company, along with the 379 to 393, there are another 6 topics that are applicable to you. What are those topics? See here. If a foreign company issued debentures in India, section 71 will apply. Means what? Debenture redemption reserve, debenture trustee appointment, everything will applicable to you. Number 1. Annual return has to be filed. Not annual report, annual return. From the end of your company's financial year, within 60 days, in India you need to file a annual return. Generally, AOC 4, MGT 7 are 2 documents. AOC 4 for financials, MGT 7 is for annual report, annual return. Here, those forms will not be used. Separate forms will be given here. So, here, section number 92 will apply. But the filing will not be done within 60 days of AGM. AGM will be conducted in the register office. Register office is not there in India. Therefore, foreign company, 60 days from the end of financial year we need to consider. Not 60 days from AGM, financial year. Next one. 128. Books of accounts must be kept also by a foreign company. Books of accounts means what? All, money is received. All money is spent. Sales, purchases, assets, liabilities. All these books must be preserved and maintained as per Companies Act 2013. 128 is applicable. Summary again. Debentures issue 71 apply. Annual return 60 days from financial year. 128 books of accounts should be maintained also by foreign company. Foreign company is a company incorporated outside India. You are doing business in India. You are utilizing resources in India. You are using space in India. You should be responsible or not. Then Indian company, you should be socially responsible. Therefore, CSR is applicable to you. Okay. Fantastic linkage. See here now. Debentures are issued. Generally, debentures are secured. Therefore, charges chapter is applicable. Books of accounts are maintained. This books, whether it is maintained properly or not, how to do? Investigation chapter will apply. That's why in investigation chapter we read section 228. What we read there? Investigation chapter is applicable also to a foreign company. This is the linking. Okay. Summary. Debenture 71. Charges linking. Books of accounts 128. Investigation linking. Independently annual return CSR. Answer completed. That's all. This is all about section number 384. 385. Listen. Sir, whenever, for example, foreign company is a company incorporated outside India, place of business in India. Place of business will be of two types. Principal place of business, other places of business. Principal place of business is in Hyderabad. Other places of business is there in 10 states. Now, if at all I have to file something with ROC, which state ROC I need to file? Principal, other, all the ROCs. Question came. Lawmaker said that not of any of these. All foreign companies, commonly one ROC will be there. He is ROC of New Delhi. Not Hyderabad ROC, not any other state ROC. New Delhi ROC you need to file for foreign companies. Previously, in the 1956 Companies Act, they used it to tell principal place of business ROC and New Delhi. Now everything is deleted. Only New Delhi ROC. Next one. Interpretation of certain terms. See here. In this particular section, they use some words called as, okay, first let us complete this. Director they will use. Director means what? Normally board of directors. Along with that, I am not a director, but according to my instructions, the board of directors of the company are accustomed to act. There is a foreign company here outside India. That company, Mr. A is not a director, but according to A's instructions, that company will work. He is also deemed as a director. Place of business includes share transfer office, share registration office. What does it mean? We will discuss along with section number 390. Okay, when we come to 391, technically 391, we will discuss about place of business relevance. Okay, first very important, mark this important provision, certified. What is the concept, sir? Certified. What is this certified? Let's try to understand. Listen carefully. Foreign company, whenever we tell foreign, in our mind it was fixed that foreign means USA. Generally Indian tendency is in such a way that manaki telisina foreign USA. Very, very popular foreign adi. But there are many countries. Japan is there, China is there, Spain is there. All the three country names, whatever I said, don't use English as a medium of instruction. Espanol is used in Spain, French used in France, Japanese in Japan, and Mandarin in China. So if you observe all these things, their original language is not English. In that case, that company memorandum, that company article, that company charter, that company statute, that company, all the other relevant documents, they will not be in English. What to do now? Translation. So, listen carefully. Certified. Nature of original document. Original document is in English. In that case, true copy will be the certified copy. ROC will certify the true copy. Anyway, it is in English. English you need not convert into Tinglish. English na, keep it in English. Not in English, translation required. Who should translate? If translation is made, where is the question? Where you are going to translate? Outside India na? Within India na? I am going to translate outside India. In that case, who is having custody of the document? My company secretary. Okay, that person has to translate. That person don't know English here. He is knowing only Japanese. English is not knowing about that. Oh, then notary public will be there in your country na? That person has to certify. Notary public means it is not possible here. In such a case, bring within India. In India, if you want to get it translated, 2 steps are involved. Step number 1. First, translation will be made from other language to English. Spanish is there, Espanol. French language is there, original document. Convert that into English. Who will convert? Language translator will convert this. After language translator converting it, language translator will only give the certification of conversion. If R is used, I will convert that into, if R is used in French, I will convert it into ARE in English. OF off is written in French, I will write it in English. That I can do. But legality I can't authenticate. Therefore, 2 steps are involved if you want to convert within India, translate. Translation by expert. After that, authentication must be made by advocate, pleader having representation in High Court. That person will authenticate legal validity of that English document translated. So, summary. See here. Certified. In original document English, original certification will be made. Not in English. Translation is required. Where you are translating? Outside India or within India? Outside India, person who is having custody shall translate, or notary outside India should translate. Not possible, come to India. In India, 2 steps are involved. Translation by a language translator, authentication by an advocate of High Court. Answer completed. This is all about 385 and 386. Now we completed, as per the word, 384, 385, 386. Everyone please answer. Understood the concept up to here clearly? Everyone understood the concept clearly? Sir, everyone in the class understood the concept clearly? Okay. So this is the idea behind section number 380, 384, 385 and 386. Okay. Next. Okay. Before you read prospectus related, 4 sections are there. First, let us complete penalty sections here. Okay. What sections are? Penalty provisions. If any foreign company commits contravention, 392 will apply. This was amended now. Sir, where are amendments? Already uploaded amendments lecture on Companies Act. See there. Material also attached to the drive. So download that, you will get a penalty. Penalties I don't want to discuss in the class and waste your time. If any foreign company commits a contravention, penalty will get applied. Previously it's a punishment turned into penalty. Now this is a penalty chart. Next, along with that, along with the punishment that you levy, further some punishments will be given to the foreign company. Listen carefully. Whenever I call something as a company, company will have one important character. What is that? Capacity to sue and capacity to be sued. Means what? This company can sue others. Others can sue this company. That's called, sue means file a case, civil case. Company will have 2 capacities. Capacity to sue others, capacity to be sued by others. If a foreign company fails to comply with the provisions of this chapter, capacity to sue will be lost, capacity to be sued will be continued. Means what? Others can sue you on that regard for the failure done, but you can't sue others. Simply see here. If a foreign company fails to comply with this chapter, what is affected? Right of company to bring a suit. It cannot file complaint. Claim a set off. I have to give you 1 lakh, you have to give me 2 lakhs. Balance a set off. Like that you cannot do. You cannot institute any kind of legal proceeding until the provisions are complied with. That means your right to sue others will be lost. Others can sue you. Okay. That means the contract entered will not get invalidated. Capacity of others to sue the company shall not get affected. Others can sue the company. Company can't sue others until you comply with the provisions of this particular chapter. So this is the summary. Repeat once again. 391 and 392. Sir, 392 and 393. 392 will be talking about punishment for a contravention committed. Whenever a foreign company contravenes the provisions of this chapter, penalty will be levied. Point 1. Along with the levy of penalty, there is also some other consequential impact on that. What is that? My right to file a suit to legal proceedings set off is lost. Others can sue me and contracts entered will be valid. Because of my non-compliance, outsiders should not get disturbed. So contracts will not get affected. My right to sue others will be lost. Clear, everyone? That's all. This is all about 392 and 393. In this chapter, we completed 379, 380, 381, 382, 383, 384, 385, 386 we completed. 392, 393 completed. 4 sections are still remaining for us. 386, 387, 388 and 389. I repeat, 387, 388 and 389. These are the 3 sections which are still left out for us for discussion part. Let's do that. Those are only the important things. Listen, sir. Everyone in the class, 3 sections I covered in a single chart. Okay, I will zoom it, no problem. First listen. First one. For all the 3 sections, one common provision is there. In exam, if a section was tested on this common point is same for all the 3 sections. 387, 388, 389. Same. Copy paste. Listen, difficult provision in this chapter. Once you understand this, foreign company chapter, nothing difficulty will be there. Easily you can score the marks in examination. Okay? So please listen carefully. Prospectus and related sections 387, 388 and 389. Let's see the concept now. Everyone have a look here. All the 3 provisions will have one common point. No person shall issue, circulate or distribute any prospectus offering for the subscription of any securities of a company which is incorporated or to be incorporated outside India, or when incorporated may or may not establish a place of business in India, unless following conditions are satisfied. If the following circumstances are established, unless following conditions are satisfied. Sir, what is this, sir? I will unzoom it. Okay, now I will be showing you the screen like this. Just read it for a while. Take a minute time. Read it first. Completed? Now let us see. No person shall issue, circulate or distribute any prospectus offering to the subscription for securities of a company. Okay, first one. What the section is telling, no one can issue any prospectus. That's the idea. Okay, why prospectus will be issued? Subscribing securities of a company. Which kind of company? It may be a company incorporated outside India, having place of business in India or not. That means it can be a CIOI or it can be a foreign company. That's why for CIOI, 387, 388, 389, 390, 391 will apply. This is the reason. Okay. So now observation required. So the point is, foreign company is there or CIOI is only there. If you are a foreign company or if you are not a foreign company but just a company incorporated outside India, if you want to issue the prospectus, 3 sections will stop you. 387, 388, 389. What is 387? 387 says that I will give you a set of conditions. Follow these conditions and issue prospectus. 388 says that I will give you set of circumstances. If you satisfy these, you cannot issue prospectus. 389 says I will give a set of conditions. If you follow, you can issue prospectus. How to understand this? Positive, negative, positive compliance. Means what? Like this we can read. No person can issue prospectus unless following conditions are satisfied for 387. No person can issue prospectus if the following circumstances are established. That means here no person can issue prospectus unless you satisfy this. Here you cannot issue prospectus if the following conditions are satisfied. That means circumstances here should not be established. Conditions here and here are to be satisfied. 387 is a positive section. 388 is a negative section. 389 is again a positive section. Okay, let us check out. See here, 3 sections are there. Positively comply with this, negatively don't comply with this, positively comply with this. Let us see the first one. What should be contained? Prospectus should be dated and signed. There should be date on the prospectus, sir. Why date, sir? Why? What is the reason for the date? If you write the date on the face of prospectus, your subscription and issue should start after that date. For example, prospectus date is 10th September. Your issue is on 23rd August. It's a false issue because even before it is registered with ROC, you issued the shares to public. Therefore, dating should be there. Next. Contains following information. What information it should contain? Instrument defining constitution of company. Certificate of incorporation, we call it. Okay. Enactments and provisions which affected incorporation. Rules of that country through which it is incorporated. Okay. Next, sir, instrument defining constitution and enactments. Where we can inspect in India? Give that address where inspection can be made. Date and country of incorporation. Full address of principal place of business in India. All these 5 details you need to submit along with the prospectus. In the prospectus, this information must be there. Simply 5 information. Instrument defining constitution. Provisions affected incorporation. Where the address in India where I can inspect these 2 documents. Date of incorporation and your country of incorporation. Okay. Next, full address of principal place of business in India. Completed. All these details you need to attach along with the prospectus positively. Next one, important. Expert consent. Which one, sir? Expert consent. Listen first, later you read. Whenever a foreign company is issuing a prospectus in India, that foreign company will have assets and liabilities on the balance sheet. Okay? It want to issue prospectus for what? For issue of securities in India. When you are issuing a share in India, at what price you will issue? Depending on your free cash flow model. Okay? Therefore, the total assets and liabilities must be taken. They must be revalued according to rupee configuration. Experts only will do that. Therefore, whenever a foreign company want to issue prospectus in India, their accounts must be translated into rupee and according to our thing. Therefore, one expert will come who will all translate the other currencies into rupee at an appropriate rate and also calculate the value of a share. Expert only will do that. Therefore, listen carefully. These 3 cases should not be there. That means something negative going inside. What is that? Let's try to understand. Prospectus contained statement made by an expert. In the prospectus, statement made by an expert is there. Expert statement is there inside. But the expert has not actually given the consent. That means it's a false statement. If false statement is there, no person can issue prospectus. That's the idea. Prospectus, there is a statement made by an expert, but expert has not really given the written consent, but still they have written. False statement number one. Second one. Prospectus contains a statement made by an expert, but the expert has before its registration withdrawn the consent. That means by the time I issue to the public, consent is already withdrawn, but they didn't tell that it is withdrawn clearly. This is also a false statement. Third one. Prospectus does not contain statement made by an expert or has not withdrawn the consent. How beautifully the section was drafted. First situation, statement not given, but you said it is given. Second one, statement given but withdrawn, but you are still telling that it was given but not withdrawn. Third case, company should clearly tell that statement is given by expert and he has not withdrawn it. They should tell clearly. ఇచ్చాడు ఇచ్చినది తిరిగి తీసుకోలేదు అని క్లియర్గా చెప్పాలి. చెప్పకపోతే కూడా మిస్టేక్ అవుతుంది. ఇఫ్ యూ డోంట్ టెల్, దట్ విల్ బికమ్ ఎ మిస్టేక్. దట్ మీన్స్ ప్రాస్పెక్టర్ షుడ్ నాట్ ఓన్లీ టెల్ దట్ కన్సెంట్ ఈస్ టేకెన్, ఇట్ షుడ్ ఆల్సో టెల్ ఇట్ వాజ్ నాట్ విత్డ్రాన్. ఓకే, జస్ట్ యూ టెల్ ఐ టుక్ కన్సెంట్, కన్సెంట్ టేకెన్, ట్రూ. Withdrawn, not withdrawn, not that also you need to tell, or else it becomes omission of a true statement. Prospectus will become invalid. 3 points. Prospectus contained a statement made by an expert, but it has not actually given the consent. Prospectus contains statement made by an expert, but expert has withdrawn before its registration, withdrawn the consent. And prospectus does not contain a statement made by an expert or has not withdrawn the consent. Okay. Last one, 389. Registration of prospectus. What is that, sir? Registration of prospectus. Prospectus once prepared, first it should be signed by the company chairman and directors, approved by the entire board of directors, sent to ROC for registration. That's all. This is all about section number 389. Now we completed 387, 388 and 389. One review from the student side. Have you understood the concept, everyone in the class? Please, everyone. Sir, everyone feeling comfortable with the session? Is it a value addition to you? Sir, everyone in the class, is it a value addition to you, everyone? Is it helpful? Thank you very much, everyone. So, next one. Next one. See here. So we completed hardcore difficult concepts in foreign company chapter as well. Al bacha 2 concepts are there. Let's see. Sir, prospectus is issued with a false statement. What will happen? What will happen? Automatically you will be liable for section 34, 35, 36 of Companies Act. Criminal liability for issue of prospectus, civil liability and punishment for fraudulently inducing a person to invest money. Any of these 3. Okay, you needn't even remember this. Just remember 34, 35, 36 will be applicable for issue of prospectus in a false way, issue of IDRs in a false way. Punishments will get attracted. Offer of IDR. Sir, listen carefully. Let me explain this concept. IDR. Outside India, one company is there. As per the FEMA regulations, it cannot directly issue shares in India. It will issue receipts. It will issue receipts. Receipts will be converted into shares. It can be of two types. Multiple receipts into one share, one receipt into multiple shares. That will be decided by the company issuing the stocks. Okay. That will be issued to a depository in India. Either NSDL or CDSL. This particular depository is in India, which will issue to the public in India. Depository will put it for sale. Indian public will purchase. Purchase what? Receipts. This public will go to depository after a particular period of time, convert those receipts into shares. If you convert into shares, then you will get the dividend. Okay. Therefore, IDRs means what? IDR is a receipt issued to the depository in India. Therefore, it's called as Indian Depository Receipts. It is not a share. It's a receipt. Receipt issued to depository. Where depository? In India. That Indian depository will issue for public sale. I will purchase. I purchase receipts. I want to convert it into shares. Go to depository within the time period given, convert that into shares. If you don't convert, dividend will go to depository. That's the idea. Okay. Now listen carefully. Whenever depository is there in India, I will convert my receipts into shares. Shares are there with me. Now, the shares which are there in my hand today, I want to transfer to my friend, or I want to trade in stock market. That means transfer should be there or not. How that a transfer will be? Did you understand my point, everyone? I repeat. Koushik Mukhesh purchased receipts from a depository in India, being a public, converted into shares. I want to transfer it to my friend. How to transfer? If it is a Indian company, I will apply for transfer certificate. I transfer from me to my brother. But it's a foreign company. Register office is there outside India. From here I will send the share to outside India. That person will transfer to my brother. Where is his Aadhaar card with him? How can he check whether the Aadhaar card is correct or not? Therefore, someone should be there in India to assist the transfers. Therefore, share transfer office, share registration offices will be set up. Once this is set up, purchase and selling of shares happen or not, this will be called as a place of business, makes you a foreign company. That's the point we left there. If you observe, definition of the term, interpretation of the term place of business we left here. I said we will discuss somewhere else. Place of business includes share transfer office and share registration office. Why that concept came? IDR's purpose. Whenever IDRs are issued, they convert into shares. Once they are shares, they want to transfer. Transfer generally under Indian Companies Act should happen through registered office. Registered office of this foreign company is there outside India. Then there should be some Indian transfer office. They establish share transfer. Once you establish share transfer office, you become a foreign company. That's the beauty how the Companies Act is drafted. Everyone understood this concept clearly? Everyone understood this concept clearly? So this is the idea. So Indian depository receipts, in relation to that, what are all the concepts? Let us try to understand. From the Indian depository receipts point of view, what are all the concepts that we need to understand? See here. CG shall make rules for what? How to offer IDR, what disclosures are required to be made in prospectus. Means what? One receipt equal to how many shares, or how many receipts makes one share, when to transfer, when to do all these things. And manner in which IDR shall be dealt in depository mode, when to go for the depository to convert the receipt into shares, you need to tell clearly. Last one, manner of sale, transfer and transmission. Just now I said the example, you need to tell. To have a transmission, I need to have a share registration and share transfer office. Chapter completed. 379 to 300, 15, 7, 16 sections chapter is also completed now. So we completed government company, we completed foreign company concept also. Okay. So